Okay, Senator Whitley, you're going to lead us in the pledge. There you go. We're going to start with the Pledge of Allegiance. Senator Whitley is going to lead us. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Senate Judiciary is now in session. The Honorable Sharon Carson is going to introduce our first bill. Welcome.
Good morning, Mr. Chairman, and good morning to my colleagues on Senate Judiciary. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Senate Bill 506 FN, which is relative to aligning statutes with the age of a delinquent established under the Juvenile Delinquency Statute. Mr. President,
Thank you for the promotion.
Mr. Chairman, this is a technical cleanup bill. When the state raised the age of a juvenile from 17 to 18, there were a few spots in the statute that were missed. And again, this bill would clean up those remaining references to 17. Thank you very much.
Thank you,
will
Senator
conclude
Carson.
my testimony.
Thank you. Senator, have any questions? Seeing none, thank you, Senator.
Thank you.
Paul. I was going to get it.
That's okay.
Thank you.
Good morning.
Good to see you, sir.
Paul Allison, I contacted Senator Carson indirectly several while after also this issue. I coordinated these recommended changes for all county attorneys in the Attorney General's office, as well as the Chief Legal, Regulatory, and Legislative Affairs at DCYF. Everyone was in agreement with it. It is a cleanup bill. I did notice, another attorney actually pointed out to me, a little ambiguity in two paragraphs that I would like to recommend a change to. And that is on page 2, at line 6, and at line 12. It would be the same change in both of those. Where it reads, nor more than 18 years of age, I'd recommend that go to and under 18 years of age. So strike the nor more than and add in and under 18 years of age. That just takes the ambiguity out of what age 17 is. I think all of us would realize that if someone asks you how old you were, you would tell them how old you were as of your last birthday, not as of the date you were asked. But it's a cleanup bill. Everyone I've talked to, as I said, is in agreement with it, and I'll gladly answer any questions on the bill.
Thank you. Senator Carson has a question for you.
Thank you very much for the question,
Yes,
Mr. Halverson. There are a few other places in the bill where it says 18 years of age. It begins on line 5.
On the same page?
On the first page.
Yes.
And then under the age of 5, it says having reached the age of 18 years or due to the completion of proceedings for transfer to the adult criminal justice system.
Yes.
So you're recommending that we include, rather than just say 18 years, having reached the age of 18 to under the 18 years of age?
Not on page 1. The only two recommended changes is on page 2.
Okay.
Line 6 and line 12.
Okay.
Everything else, I believe, reads correctly.
Okay, may I follow up, Mr. Chairman?
Yes.
Thank you. So I just want to make sure line 6 is, it says of children no less than 11 nor more than 17 years of age. So you want to cross out nor more than 18 years of age and put in under 18 years of age.
And under the age of 18, and okay. Under 18 years of age.
Okay.
No less than 11 and under 18 years of age.
Okay, just want to make sure I got it right.
And the same language will go in line 12 on page 2.
Okay. Okay, thank you very much.
Any other questions? I'd gladly take them. Thank you very much.
Thank you. ahead, Ben. No, go, you finish.
John Williams and Jeff Fletcher, do you want to come up together? Efficiency of time. Thank you both. Good morning. I love 2 for 1. Works great.
Good morning, members of the Senate Judiciary Committee. For the record, I am John Williams, Legislative Director for the New Hampshire Department of Health and Human Services, and with me today is.
Good morning, Jeff Fleischer, DCYF Director.
And our testimony is going to be fairly short. Although not requested by the department, we are absolutely fine with legislation, particularly with the 2 mentioned amendments to it to clarify the age issue in terms of the application of Senate Bill 506. We are supportive of the underlying bill. And our primary testimony, other than letting you know we're fine with it, is that the fiscal analysis has not caught up with the bill yet. The Legislative Budget Assistance Office is working very diligently. They are the unsung heroes, doing their best to getting those caught up with the legislation. But we just wanted to reflect our financial analysis, which is that this bill is commensurate with current practices in the department and would have no additional fiscal impact to our agency. And I would turn it over to Director Fleischer to see if he has anything that he would like to add.
Really nothing to add, just that we're in support of this bill. Yeah.
Thank you very much. Do we have any questions? Yes, Senator Carson.
Thank you, Mr. Chairman. And thank you for your comments. I think they'll be very helpful. I just wanted to point out that because this is a fiscal note bill, the chair of finance will be taking a look at it. And hopefully by then we will have some sort of fiscal analysis and there'll be a hearing in finance to address that. So I just wanted to update you with that.
And thank you very much. And thank you for the county association for bringing this important, legislation forward.
Thank you, gentlemen. Thank you. Does anyone else wish to testify on 506 who didn't sign in? Seeing none, thank you very much. And 506 is closed. Thank you.
Okay, we have 5 minutes.
Where's my scrambled eggs?
Hey, why, good.
Good.
Oh, no. Okay. I'm like, I'm wearing perfume. Oh, gee.
Yeah,
The Senate Judiciary is back in session. The Honorable Sharon Carson is going to introduce SB 502. Welcome, Senator Carson.
Thank you, Mr. President. And again, good morning to my colleagues on Senate Judiciary. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Senate Bill 502 relative to the scanning of non-drivers' identification cards by real estate brokers. Mr. Chairman, this legislation is seeking a statutory change to RSA 26312 X relative to the electronic sharing of driver's licenses. The intent of the legislation is to combat an uptick in scammers posing as landowners and asking a real estate agent to list the property. This scam operates in the following manner. An individual will claim to be from out of state and looking to sell a property quickly. In some cases, the scammers have researched the history of the property and have a great deal of information which can make the request appear authentic. There have been cases where deposits from buyers were placed in escrow before the scam was discovered. This is prevalent in the northern parts of the state where vacant land is more prevalent. It is something happening across the country with greater frequency. Mr. Chairman, I had read a number of articles about this happening, and it's usually happening to our older citizens, many who will go to Florida or the southern states for the winter months, and they have large open land holdings. And I read particularly about a case in Greenwich where property, a landowner still maintained a residence in Greenwich, but there was a large parcel that he had inherited from his father, and he just left it open. And he went to Florida and he got a phone call from a neighbor of his saying, "Wow, I didn't realize you sold the property." And he said, "What are you talking about?" He said, "Oh yeah, they came and cut down all the trees and they're building a house." And he came home immediately and found out that someone had fraudulently sold the land. They had pretended to be him, and the people, of course, that bought the land and were building the house, they're now out of all that money. And of course, the person who did the scamming, they're long gone. So this bill, Mr. Chairman, is an attempt to prevent that from happening to New Hampshire citizens. Under current law, real estate licensees are prohibited from asking for these buyers to send a copy or photograph of the license to authenticate their identity. Currently, RSA 63:12 prohibits electronic storage of a driver's license unless specifically exempted by statute or regulation. This bill seeks to add a small exemption to the existing statute for real estate licensees. This bill prohibits maintaining the scanned license beyond the closing date of the transaction or when requested by the holder of the driver's license. Currently, pawnbroker, scrap metal dealer, secondhand dealer, etc., are exempt in statute, while financial institutions, insurance, and other legitimate businesses which deal with motor vehicles are exempt in the rules. Senate Bill 502 would enable real estate licensees to have a similar limited exemption. We have leaders from the New Hampshire Association of Realtors here who will provide some additional information and can answer any questions. The realtors did provide the language to the Department of Safety in advance of filing the legislation, and I do hope that someone from the New Hampshire Department of Safety is here to discuss the bill this morning. At this point, Mr. Chairman, I will conclude my testimony and just note again that the realtors are here to answer any questions, and thank you all very much for your consideration of this bill.
Thank you, Senator. Do we have any questions? Seeing none, thank you very much. Sarah Holland. Morning.
Thank you for the opportunity here, and Senator Carson for working with us. Thank you. My name is Sarah Holland. I am a real estate agent in Plymouth with Coldwell Banker Realty, and I serve as Vice Chair of the Public Policy Committee for the New Hampshire Association of Realtors. The Realtors asked for your support for Senate Bill 502. As explained by Senator Carson, fraudulent real estate sales are on the rise. The FBI's Internet Crime Complaint Center warns that losses from real estate and rental scams are steadily increasing, reaching more than $396 million last year. New Hampshire is not immune from these fraudulent activities. A person or entity who commits such fraud generally attempts to create the appearance that they have legal title to a piece of property when they do not. There are a couple of recent cases that I'd like to share with you. One involved a real estate broker who received a call from someone purporting to be the son of a past client of the broker. He was asking the broker to list vacant property for them. This person had acquired an old email from the broker and had very specific information, which led the real estate office to believe this person was who they said they were. The scammer had knowledge beyond what they could have learned in the public record alone. At this point, the broker would have liked to have asked the person to send him a copy of their driver's license to assist in demonstrating that this person is who they said they were. However, the broker was a friend with a state trooper who informed him that such a request would be a misdemeanor. Fortunately, in this case, the fraud was detected before any agreements were signed. However, there have been cases in New Hampshire where money was put into escrow accounts before the scheme was uncovered. In our real estate process, the real estate professional is kind of the first line of defense in a transaction where, although we are not allowed currently to ask for identification in electronic means to be able to retain it, and we do have retention records that we are supposed to keep and maintain, the transaction can go on and on and on before we get to title or we get to some sort of financing where at the closing table they would ask for this identification. And at that point, there is a lot of harm that could be done. Another story, I had a office meeting this week and one of our broker partners indicated that he had a client who had been targeted multiple times by these scammers. This client was a fraud attorney. And multiple real estate agents had tried to reach out to verify the identity. They had determined that this was a scammer. This person did not place their property on the market. So that had a better ending, I suppose. But without this ability to be able to ask for identification, it is sometimes it can get further down the line. So we understand that asking for identification is not a foolproof method, and brokerages do need to take a series of steps to ensure that fraud is not occurring. But we do also understand privacy concerns. And the choice of the consumer to provide their identification is theirs alone. So our hope is that we can at least ask for this information. If a scammer is on the other end of the line, it is unlikely they would provide this identification, and then we would end the call and be able to move on, knowing that this was not the correct party. But unfortunately, at this moment in time, we cannot even ask for that identification. So this is not a cure-all, but it's an important tool in our toolbox for a variety of reasons to prevent fraud, but also to prevent harm to ourselves when we go out to meet parties that we have never met before. Identifying that they are the person who they say they are, so we can maintain a safe working environment for ourselves. And with that, I'm happy to entertain any questions. Thank you.
Thank you, Ms. Sullivan. And seeing no questions, have a great day.
Thank you.
Does anyone wish to testify who didn't sign in on 502? Seeing none, the hearing is closed.
Yeah, I know.
I'll give him 30 seconds. Okay, Daryl, roll it in. You don't bring us donuts, you come late. Senate Judiciary is back in session. We're going to hear SB 463. The Honorable Sharon Carson is presenting the bill. Good morning.
Good morning again, I was going to say Mr. President.
I
again.
love it.
Mr.
It's great.
Mr. Chair, and again, good morning to my Senate Judiciary colleagues. For the record, my name is Sharon Carson. I represent Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Senate Bill 463, expanding access to court-appointed counsel for children in dependency proceedings. Mr. Chairman, I've got extensive, information, and I'm going to try to quickly go through the main points. We know that children are the central parties in abuse and neglect cases. These are some of New Hampshire's most vulnerable children, and there are potential consequences they face, including the loss of their parents, homes, and families, which are severe and life-altering. So what does this bill do? It amends New Hampshire's Child Protection Act to give family division judges the discretion to appoint counsel for children at any time in abuse and neglect cases. Under current law, courts may only appoint counsel for children in abuse and neglect cases in very limited circumstances. However, situations may arise at any point in an abuse and a neglect case in which a child's welfare would best be served by appointment of counsel, regardless of whether the child's expressed wishes conflict with the guardian ad litem recommendations. This bill provides more flexibility for courts to determine whether and when to appoint counsel for children. Secondly, it adds a new provision to the Child Protection Act requiring mandatory appointment of counsel for children who are placed in or at a high risk of placement in any group home or residential care institution as defined by RSA E:25 or certified by the Department for the Care of Children pursuant to RSA 169C or in any state-operated residential treatment program. This includes children placed in or at risk of placement in residential care, both in and out of state, as well as state-owned facilities such as Hampstead Hospital. Being placed in a group home or other residential treatment facility is traumatic and isolating for children. Children placed in these settings are removed from their schools, from their communities, their families, and their friends. As recently exposed by the Office of the Child Advocate's report on Bledsoe Academy in Tennessee, placing children in residential facilities may result in children suffering additional abuse and neglect. This bill would require counsel for a fraction of children in child protection cases. As of December 31st, 2023, DCYF had 882 children in out-of-home care. Of those 882 children, 121 were placed in a group home or other residential facility and would be appointed counsel. Children at high risk of institutional placement would also be appointed counsel. However, having counsel may help to reduce the number of children placed in group homes and other residential facilities. Third, it adds a new provision to the Child Protection Act granting appointing counsel the right to view and copy the child's medical, psychological, educational, and other records necessary for counsel to provide competent legal representation. And it also provides records to counsel under this section shall only be used for proceedings under the Child Protection Act. 4, it adds a new provision to the Foster Care Children's Bill of Rights requiring notice to the child of their right to appointed counsel. So, Mr. Chairman, the question is, why do these children need attorneys? Children are legal parties to abuse and neglect cases. The New Hampshire Child Protection Act and Foster Care Children's Bill of Rights provide children with many legal rights which only legal counsel can assure are protected. Children face potential loss of their families, friends, belongings, and community through no fault of their own. Children may be subject to abuse and neglect in residential facilities, including possibly being subjected to prone restraint, which is now unlawful in New Hampshire. Children deserve to have their voices heard and respected, especially in matters that have significantly impacted their daily lives. Having counsel to represent the child's expressed interest will empower the child in situations where they have little control and the stakes are incredibly high. Providing counsel for children placed in residential facilities or at risk of such placements will ensure that their rights are adequately protected. The attorneys appointed for children will provide legal advice and develop legal strategy. They will also represent the child's perspective and express the child's wishes to the court. They can also help the child understand their options and fully participate in legal proceedings, and they can ensure the child is treated fairly throughout those legal proceedings. Providing counsel for children in abuse neglect cases is a nationally recognized best practice. Children who have legal representation obtain better results than those who do not, including less time in foster care or group settings, shorter time to reunification with their parents, adoption, or guardianship, and there are fewer school transitions. New Hampshire is an outlier, Mr. Chairman. It fails to protect children's rights in ways that most other states do. New Hampshire is only one of 13 states that do not guarantee the right to counsel for all children throughout abuse and neglect proceedings. Other states are Alaska, Florida, Hawaii, Idaho, Illinois, Indiana, Maine, Minnesota, North Dakota, South Carolina, Texas, and Washington. And New Hampshire is only one of 6 states that do not guarantee the right to counsel for children in abuse and neglect proceedings under any circumstances. Other states include Maine, Illinois, Indiana, South Carolina, and Hawaii. At this point, Mr. Chairman, I will conclude my testimony. It's quite a bit, and so I'm again going to conclude, and I can try to answer any questions, but the folks that I've worked with on this legislation are here, and they can probably answer your questions much better than I could.
Thank you, Senator
So thank
Carson.
you.
That was very enlightening for me. You covered the subject really well. Anyone else? Thank you very much, Senator Carson.
Thank you.
Mr. Fleischer and Mr. Williams, if you'd like to come up again.
Good morning again. Thank you, members of the Judiciary Committee. And for the record, I am John Williams. I'm the Director of Legislative Affairs for the New Hampshire Department of Health and Human Services. And with me today,
Yeah, good morning again. Jeff Fleischer, DCYF Director.
and we thank you for the opportunity of coming before you on Senate Bill 463. We certainly embrace and acknowledge the work of the prime sponsor, Senator Carson, on this bill. It's a very important initiative. And you're very much probably aware that also in the House, retained from the 2023 session into this session and recently passed by the full body, is House Bill 535. So there is another bill that is out there that will be coming likely before your committee, and certainly thoughtful reflection in terms of harmonizing both the House consideration on this issue as well as the Senate consideration will certainly take place. The other reason we wanted to make sure we came up here, and you'll certainly be hearing from the other advocates who worked with Senator Carson on this important initiative, and although we're not taking a position on it, that is based upon the matter of the necessary resources needed for legislation. recognizing clearly this is a policy committee, and I think Senator Carson laid the ground very clearly that that will be something thoughtfully considered, if not at this particular level, working as we make our way through the Senate Finance Committee for acknowledging the resources that would manage to making this bill work. And in New Hampshire, we get it right, and we get it right because when we do decide that something's important enough, we provide those resources necessary to making those things happen. So Mr. Ripple, again, from the Legislative Budget Assistance Office, another call out for his heroism in terms of getting turned around the fiscal analysis on this legislation. And I believe that you have been presented with this. Your committee's support has been tremendous. And so I'm just holding my hand a copy of the fiscal analysis. The Judicial Council, and I don't know if members are here to comment, certainly they play an incredibly important part of making this legislation work because the initial cost for paying for those court-appointed counsels will come through the Judicial Council itself, very much similar, as we know, through the Indigent Defense Fund. That's where those resources would come. So there's already a system in place relative to those appointments of counsel with some minor adjustments here in recognition that we're serving a very important population involving our children who are part of this process. The other part that we just wanted to bring to your attention is that our incredible team of attorneys that are at the department's Division for Children, Youth, and Family do an incredibly great job. However, in recognizing the need for getting appointment of counsel, to getting it right here in New Hampshire, you have to ask yourself, what does the department need in terms of at least minimal resources to be able to make this work? The anticipation is by court-appointed counsel, and I think that Senator Carson actually touched on something that in moving forward, certainly we would acknowledge that there are some cost savings that would be anticipated as a result of this bill based upon exactly the comments that Senator Carson said. And I just want to go on the record that in addition to what we had submitted working with the Legislative Budget Assistance Office, I think it's important to note that that's not part of this in here, but I think we would acknowledge that there would be anticipated some downstream cost savings. With that said, the good news is that there is a federal match of 25% for paying for our attorneys at DCYF, but it is anticipated that working along with the court-appointed counsel representing the child's interest in these matters, that our agency would be engaged with additional court matters, very necessary as part of this process, and we'd hope for the committee's support in working with us and ensuring that we have the necessary resources, not in a fiscal note, but actually in the legislation itself, acknowledging some level of appropriation and possibly identifying the 5 attorney positions in those particularly critical areas in the state, such as over in the Connecticut River Valley area. We certainly need those resources there because our attorneys are working hard up in the North Country, in the rural areas, as well as in the Portsmouth area that we have identified in the fiscal note. With that, I would like to turn it over to Director Fleischer to see if he would like to add any comments on this very, very important legislation. And we look forward to working with Senator Carson, this committee, and also the advocates behind the bill.
Yeah, thanks, John. Yeah, just emphasizing John's statement that this has a cost to DCYF. But aside from that, I just want to applaud Senator Carson's statements and how you framed the reason for wanting court-appointed attorneys. We do want to keep kids with their families, kin, foster care, close to home in their communities. We want to only place a kid in an institution when it's only absolutely necessary and at the shortest term possible, and they get the absolute best care. So I just want to applaud the reasons for this bill. And as you know, DCYF is working in tandem with that mission. So thank you, Senator.
Thank you both very much. Yes, Senator Whitley.
Thank you, Mr. Chair. Thanks for taking my question and for that testimony. I am committed to certainly, work with a sponsor to get the resources that you need. Absolutely. So just to clarify, is it the department's preference that we actually add an appropriation to the bill for the 5 positions?
That is the standard approach to giving us the resources, so that would be our request.
Okay. And seeing no other questions, thank you both very much. Emily Lawrence.
Good morning, Chairman. I'm going to.
You're doing a BOGO, so I'm happy.
Yep.
Saving time. Great.
Are you? BOGO? I know. Good morning.
Good morning.
I'm Karen Rosenberg. I'm the Policy Director with the Disability Rights Center.
And I'm Emily Lawrence. I'm the Deputy Advocacy Director with Waypoint.
And we are both here representing the Juvenile Reform Policy Group, which is an affiliation of nonprofits that advocate for children and youth in this state. And that includes the Disability Rights Center New Hampshire, Waypoint, New Hampshire Legal Assistance, the Children's Law Center of New Hampshire, New Futures. I think that's it. And I do want to point out that one of our members who couldn't be here, Lisa Wolford, submitted some testimony electronically, so hopefully you all received it. So we are here in strong support of SB 463, and we want to thank Senator Carson and all of you who signed on to co-sponsor this bill. We think it is a really important piece of legislation to protect some of our state's most vulnerable children who, through no fault of their own, land in child protection proceedings. And as you know, at those proceedings, some of their most fundamental rights are at stake. The right to be with their parents, to live in the homes, the only homes that they've ever known, to be with their friends in their schools and communities. And it's elevated even higher when they're either placed already in an institutional setting or they're at high risk of such a placement. Because we don't use the term normal so much in my office, but it's not normal. And what these children really want to be is like their friends, with their friends. It's fundamentally important. So as Senator Carson mentioned, New Hampshire is one of only 6 states in the nation that never guarantee a right to counsel for children in child protection cases under any circumstances. This would create a right for those children who are the most vulnerable, where the stakes are the highest, where they are out of their homes in an institutional setting or at high risk of that. So for those reasons, we think it is extremely important for this bill to pass. We also acknowledge that this bill would provide some expanded rights for the courts to appoint counsel throughout the proceedings in matters where they feel it's appropriate and necessary to assist the child in protecting some really fundamental rights that we may not have contemplated just through, institutional placement. So, Emily, do you have something to add here?
I just want to emphasize, and Senator Carson mentioned this in her testimony, but children are the center really of a child protection case, and they're the only party right now who does not have counsel. And so this bill would give them counsel, but also we want to be clear of the roles of everyone else in this case. So in a child welfare case, the child would still continue to be appointed the CASA or a guardian ad litem. And this bill would then just be adding on. So they would have the benefit of both their CASA, who would represent their best interest. So the CASA is able to meet with the child, meet with people that are involved in the child's life, and really forms a strong, often long-lasting relationship with the child, and then makes recommendations on their best interest. And then you would have the attorney who would come in, and again, we're only talking in limited cases, so this isn't every case, but children that may be appointed one if they request one or someone else does, or if they're in residential, the attorney would represent their expressed interest. And this is really important, particularly for those kids that we see as adolescents who go into residential placements, so that they can have their own voice. These kids are really out of sight, out of mind when they're in a residential placement. And so we want to make sure that they have both of these roles to supplement and support them. The more people we have advocating for children, we believe the better.
And we're happy to take any questions you might have.
I'm going to start. So I am a co-sponsor. I want the thing. I want advocacy. But just so I know for my own self, have there been times, so the court's always acted, since I've been on the bar for 40 years, in the best interest anyways. Without counsel, have there been cases where you've seen that children's views and their wishes haven't been advocated for them?
Most children would not choose a residential placement.
Okay.
And as I read the fiscal note from the Judicial Council, in the past year, they've appointed counsel only 4 times for children. So I think the answer to your question is, yeah, this happens.
Okay, thank you. Senator Abbas. I'm sorry. Oh, yeah, I saw you first. I'm sorry. Go ahead.
Thank you, and thank you for taking my question. Can you just walk me through the process? Where's the the source of all the attorneys that are being appointed? Are they volunteers? Are they sign up? Can you just maybe provide some information on that?
No, they would be court-appointed counsel, like we already have in criminal cases, other juvenile cases. It could, so I think that there's a bar of attorneys who would be happy to take these cases, but they need to be compensated, and they'll be compensated at the rates set by the Judicial Council.
Follow?
And my follow-up would be, obviously, I don't have any issue with increasing the eligibility for a court-appointed counsel, but is there enough attorneys out there to satisfy the demand, I guess, is my question.
I mean, we think that there are, or there will be, and there will certainly be enough lead time for that to occur because the bill wouldn't become effective until January of 2025. So.
And also, just to note, is it the Judicial Council? There is a group of stakeholders who are working on training for these attorneys so that when the bill, or if the bill were to pass, and even if not, so that we could have a training for attorneys that would be appointed even in the limited circumstances under the law right now. And I think what Karen mentioned is true, is that we have heard there are people that are interested in taking these cases, but you can't rely on that because they're so infrequent, and so there's just not the need.
Follow up, Senator?
Thank you. And the point that I was going to get to, is there anything perhaps you would recommend we could do to encourage members of the New Hampshire Bar to perhaps participate in this, if there is a shortage?
I think passing this bill will be really a big step forward towards doing that, because it's kind of like, if the opportunity doesn't present itself, then attorneys aren't going to be stepping in because there's not a place for them, right? But if this bill passes and we already have in place some training and standards for representation of juveniles, which is being dealt with right now, then we will have that opportunity is created, and I think that attorneys will come to fill those roles.
Follow up again?
Is there an appropriate amount of funding for the court-appointed attorneys? I guess it looks like there's a request for money, but that's really for the staff attorneys for DCYF. So I guess my question is, I would like to make sure there's actually, for this program to work, which I think it's great, I want to make sure it's adequately funded, I guess.
I think the Judicial Council is probably in the better position to let you know what kind of funding they would need to effectuate that.
Thank you.
Thank you. Would you guys agree, if you build it, they will come? Meaning.
Exactly, yeah. Field of dreams here.
Okay, there you go. Thank you both. And yes, Senator Whitley.
Thank you, Mr. Chair. So you all define sort of everyone's role in these cases, which I think is helpful. And I think because we're talking about such vulnerable children, I think it is important to recognize everyone's role, including the GAL and the CASA. When we're talking about court-appointed counsel who is there to effectuate the express interest of the child, I'm wondering if you could even refresh my memory about the ethical guidelines that attorneys are sort of required to adhere to for cases involving children.
So the rules of professional conduct, which all attorneys must comply with, do provide for how attorneys should treat clients who may be incapacitated or even children. It's Rule 1.4 of the rules. And essentially, what we are, as attorneys, are required to do is, I brought it, as far as reasonably possible, maintain a normal client-lawyer relationship with the client, who in this instance would be the child. And in commenting on this rule, what the American Bar Association has found that when someone suffers from diminished capacity or is a minor, there may be times when it's difficult to maintain that attorney-client relationship. However, what the Bar Association says is, and I'll quote, "Nevertheless, a client with diminished capacity often has the ability to understand, deliberate upon, and reach conclusions about matters affecting the client's own well-being. For example, children as young as 5 or 6 years of age, and certainly those of 10 or 12, are regarded as having opinions that are entitled to weight in legal proceedings concerning their custody." The rules of professional conduct are directly on point and would support appointment of counsel, and counsel have direction about how to effectuate that representation.
Thank you.
Thank you. Good question. Thanks very much. Seeing
Thank-
no other questions.
Thanks
Thank
for
you.
your consideration.
Cassandra Sanchez and Lisa Messers. Messer. Good morning to you both.
Good morning. For the record, my name is Cassandra Sanchez, child advocate for the state of New Hampshire, and I have with me today.
I'm Attorney Lissa Massio. I'm the Associate Child Advocate.
And we are here in support of Senate Bill 463, relative to expanding access to court-appointed counsel for children in dependency proceedings. The Office of the Child Advocate has a unique role in the state as we have oversight of our child welfare agency. And so we currently have access to review cases, including some of the court proceedings of the child abuse and neglect cases, as well as the juvenile justice cases within our state. As many of you may know, our children in the juvenile justice system are provided attorneys on all of their cases, and those in the child welfare system are not. We are able to recognize in our role some of the benefits of having children in the system, and particularly those who are already represented in the juvenile justice system when they have attorneys. Many of our children in the juvenile justice system equally end up in residential care, as do our children in the child welfare system. The Office of the Child Advocate takes inquiries from the public, and in that we often do receive inquiries from attorneys for children in the juvenile justice system. What we hear often is an ask to take a look at what is happening in the case and understanding why a child is being recommended for a certain level of residential care. The attorneys in learning from us either about the programming that can be offered in that facility, as well as reviewing the child's trauma history and whether that facility may be able to meet their needs. The attorneys often tell us that they will go to court and file motions to protect the child from going to a facility that does not meet their needs, that is not the appropriate placement for them. That is currently what we are seeing is missing in our child welfare system. Those children do not have the same protections. They do, of course, have CASA advocates who do their best to advocate. I do understand that they also have attorneys on staff, and so there may be times where they have to file motions for the child's best interest. But as discussed prior to me sitting up here today, that is the child's best interest versus the child expressed interest. And in the Office of the Child Advocate, one of our other primary roles is ensuring that we raise children's voice and make sure that they have an opportunity to be heard. And we would love to see the children involved in our child welfare system have an opportunity to be heard in the court, not just outside of that system, and ensuring that although there are times where their wants and needs may differ, it is still important for the judge to take into consideration both and hear both aspects of that. I also wanted to share with you today that I previously to coming into my role at the Office of the Child Advocate, I worked in the child protective system in the state of Massachusetts. In the state of Massachusetts, all children in child welfare cases were assigned attorneys. So I had the experience of working in a system that operated that way. The difference in Massachusetts was that not all children had CASA advocates. And so I would work on cases where attorneys would advocate and look out for children's best interest in their school. They would advocate for appropriate placement. They would be able to access records for the child, whether it be medical or school records, to understand whether their needs are being met. But what was missing was that voice of, although they had the advocacy, were they truly able to put forth what was in the best interest of that child if they were expected to speak on that child's wants? And so also learning from Massachusetts, shortly after coming to my role in New Hampshire, the Massachusetts Office of the Child Advocate put forth a report on the Harmony Montgomery case. A critical piece of their report on the Harmony Montgomery case was acknowledging that the child's interests were not represented in the court proceeding that ultimately sent her to live with her father. And so what they put forth is a request for the state of Massachusetts to move forward with not only having attorneys for all children, but also having CASA advocates for all children to ensure ultimate protections for our most vulnerable children. And we're not sitting here today asking to expand that to every child involved in the child welfare system at this time, but primarily those at risk or in residential facilities, because we do understand that they are vulnerable. As you heard in Senator Carson's testimony And when introducing the bill, my office had an opportunity to travel to Tennessee this summer and to visit a facility there with extremely unsafe conditions for the children that were placed there. And unfortunately, those children lingered in that placement far longer than they should have been there. Although we understand that one of those children did have an attorney, the other child did not. And they were not able to advocate to get those children home. So thankfully, ultimately, those children were able to return to New Hampshire, but the trauma that they suffered in the interim for the approximately 7 months that they were in that placement is now still currently affecting them in the placements where they are today. And we do believe that if they had those additional protections, they may have returned to our state sooner and had an opportunity to receive appropriate treatment to overcome the trauma that they have suffered. I'm open to any questions.
Thank you. Yes, Senator Carson.
Thank you, Mr. Chairman, and good morning, Ms. Sanchez. We both serve on the Commission for Children's Oversight of these services, and we met last Friday, and you reported to us an instance where a child that is currently in a residential placement facility was subjected to prone restraints. Just for general knowledge, prone restraints are illegal in the state of New Hampshire. Now, if this child had been assigned an attorney, do you think that this would have had an impact on that situation? At least with them being able to report to their attorney that this had happened to them.
Yes, they would have been able to report to their attorney that this happened to them, as well as the attorney would have an opportunity to take this information to court to ensure that the court, who is the placing agency, is aware of what this child is undergoing in that facility. I will say, just from a deeper review into that, I do hold concerns for the appropriateness of that level of care for this child. The child specifically has higher needs than the facility can meet at this time. And I do believe if an attorney was assigned, they would be going into court to advocate for a more appropriate placement that can meet their needs and would not put them at risk of dangerous restraint techniques.
Thank you very much.
Thank you. Just a question, do people struggle, I would, representing the best interest versus the expressed interest? Like, they may not want to be committed somewhere, and I would, in my head, I would struggle with that. Rule 1.4 would be a problem.
I believe that with having the assignment of the CASA and the attorney, ultimately best practice would be that they work closely together. Sure. And so they would understand what each side is representing, and having both sides represented to the court, it is easier to stay in your lane, as opposed to that is some of what was learned in Massachusetts when there is only one person representing. Sure. That attorney was juggling, needing to bring forth the express interest of the child in the court, but also counseling behind the scenes the child what is in their best interest. And so by having both coinciding, I do believe that they could stay in their lane clearly.
Thank you.
Lissa, I believe, also has a comment to this.
And this relates to some of the questions that were asked earlier. Within the ethics of attorneys, as you know, there are rules around it, but there's also a lot of work being done around standards. The Judicial Council actually has a group convening, which I'm part of, and some of the JRPG attorneys are part of, talking about that difference, particularly with child clients, where that line is, best interest and need, want, as well as sort of the fluidity between cases. Children that are assigned a juvenile justice attorney has a 169C case, how might that work as far as continuity of care? So there are conversations happening. There are standards being promulgated, commentary, as Attorney Rosenberg mentioned, in the rules, as well as trainings that are being undergone both with attorneys that already do this work with juvenile justice cases. There are also attorneys that take parent cases as contract attorneys. So presumably some of those folks might also take child cases. But it's definitely an active area of thought and discussion and interest in the legal field.
Sure. Do you have your own testimony, or you haven't switched up
I'm
yet?
here for the legal questions.
Oh, okay, sounds good. Let's see. Nope, seeing none, thank you both. Karen Rosenberg. Oh, she did? I'm sorry. 22222. Does anyone else wish to testify on 463? Seeing none, this hearing is concluded. Senate Judiciary will now hear SB 459. Senator Carson, good to see you again.
Hopefully, Mr.
See
Chairman.
you all day.
Yeah, it's been kind of like my morning to introduce bills. Thank you again, Mr. Chairman, and my honorary colleagues. For the record, my name is Sharon Carson. I represent Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have this morning for your consideration Senate Bill 459, relative to the presumption of harm under the Child Protection Act. Mr. Chairman, this bill revises certain definitions under the Child Protection Act, including the definitions of abused child, neglected child, institutional abuse and neglect, serious impairment, and imminent harm. It also revises circumstances creating a rebuttable presumption of harm and removes the child from the prospective repeal of that section. The bill expands child abuse reporting requirement to include healthcare providers who treat a child under 13 years of age for a sexually transmitted disease. You might wonder why we're even talking about children under the age of 13. As I said previously, I chair the Oversight Commission of Children's Services, and we had a report last year from the Attorney General's office that they've seen a large increase in the sexual abuse of children from infancy through toddlers, an age group that you normally would not associate with that. But we just need to be really aware that this is happening in our state, and the Attorney General's office at the time of the report, we're seeing an increase in the reports. And it is important that they report this to our state. In Section 1, it repeals and reenacts the purpose section of RSA 196C to reiterate the primary purpose of the child protection laws that are to protect the physical, emotional, and psychological welfare of the child, acknowledging the trauma caused to the child by abuse and neglect. And it also states the goal of child protection is, in the first interest, to provide services in order to keep the child in their own home and with trusted and known individuals. Sections 2 through 8 amends or repeals and reenacts various definitions under RSA 169C:3 to include abandoned, which recognizes the emotional and psychological care required by parents. Abused child, to expand protections for physically injured children, especially babies. Imminent danger, to recognize that harm extends beyond physical health to include psychological, emotional, and mental well-being. Institutional abuse and neglect addresses restraints and exclusions, as well as children who are continued in placements that endanger them. Neglected child recognizes that harm extends beyond physical health to include psychological, emotional, and mental well-being, and exposure to harmful behaviors or people. It also includes a more comprehensive and updated definition of psychological maltreatment, and it also includes a much more comprehensive and updated definition of serious impairment to align with trauma-informed and developmental knowledge. Mr. Chairman, these terms need to be updated. We have had so much improvement in understanding a child's well-being, the effects, the emotional, the psychological, and how important the mental well-being of being a child is. And so I'm hoping that we can update those definitions. To go on, Section 9 removes the prospective repeal of RSA 169C:12F, which is the rebuttable presumptions of harm. This reenacts a substance use presumption in a more encompassing manner related to both the substance misuse as well as harm caused to the child. It also reenacts an expanded presumption related to driving offenses with a child in the vehicle. It also reenacts presumptions related to exposure to physical violence, verbal abuse, or psychological maltreatment in line with language previously drafted by the New Hampshire Coalition Against Domestic and Sexual Violence. And it also enacts a new presumption related to serious injuries to non-ambulatory children, and we're talking about babies. Section 10 updates reporting laws under RSA 169C:29 to include signs of sexual abuse or trafficking. The Office of the Child Advocate will testify in more detail about specific sections as they relate to their work on current trends in child protection and social science. At this point, I will conclude my testimony. We have experts here to really go into detail on some of these issues. But if anyone has any questions, I will try to answer them.
Seeing none, Senator Carson, thank you very much.
Thank you very much.
Mr. Fleischer and Mr. Williams, come back down.
Senator Gannon and also members of the Senate Judiciary Committee, thank you again for allowing us the opportunity to come and testify to you on this important legislation, Senate Bill 459 for the record. I'm John Williams. I'm the Director of the New Hampshire Health and Human Services Legislative Affairs for the department. And with me today is
Jeff Fleischer, DCYF.
And continuing on with the testimony that we had on the prior bills, the LBA, great job. They just caught up with this. And I know members in the audience, I just wanted to alert the key stakeholders that the fiscal analysis, I've been informed, will be catching up with the bill. So certainly that information will be with them as well. Again, New Hampshire does it right, and when you identify systems of care, or in this case, dealing with issues of abuse and neglect in children, it's a very critical, very, very important part of this legislation. We will certainly defer to the good works done by the advocates in the room here to testify on this bill, and certainly provide with greater information around it, particularly the New Hampshire Office of Child Advocate. They do a phenomenal job, and certainly working with all the other advocates around the legislation. So with that said, there is at least one technical defect that we did identify, or at least for the committee's consideration, and we don't want to try to tackle it necessarily with this bill, but we do know that there's other very important pieces of legislation dealing with out-of-home placements. So I just wanted to draw the committee's attention to page 2. And line 16. Although this apologies, a little loud. Although this section here in the legislation going through, I just want to point out on line 16, you'll see that the sentence, be placed in group home or child care institution licensed by and contracted with the state. So for those out-of-home placements that do involve other states, we lack obviously licensing authority or jurisdiction for licensing, so that issue does need to be clarified. Our approach here is that we work with providers that are licensed, and that our approach here is to have the department credential them. So whatever underlying authority for licensing should be in place. So working with you, Senator Carson, as prime sponsor, working with the Office of Child Advocates and others, Disabilities Rights Centers and others, Waypoint, we're happy to work. But I do think it's an important point, because this will be harmonized with other bills, particularly one you'll be hearing later this afternoon involving the out-of-home placement of children. As that is the case, again, trying to do things right here in New Hampshire, I will say that the fiscal analysis has a hefty price tag, but a very important price tag as acknowledged by the department. Because the goal here, working with the Oversight Commission around Children's Services, this bill actually expands the definition for abuse and neglect. We as an agency think that's a very helpful piece of the legislation, but by expanding those definitions as to what would qualify under the definition for that, it also would then capture more scenarios or situations, fact-based situations, which we would likely receive reports on. And that's part of the relationship why we're asking for the additional resources to the department. We will acknowledge that with the work of Senate leadership in particular and other leadership, that you have been great working with us over the past several years around systems of care involving children and providing us resources. But as we incrementally move in the right direction, getting it right here in New Hampshire, we do need some additional resources to be able to address those issues. So with that, I am going to mention one other item. We have the wonderful Associate Commissioner with us, Tricia Tilley, who, as you probably now know, transitioning from her role as the Director for the Division for Public Health and Public Health Services within our department. She is now also, in addition to overseeing that important area, and you've seen her testify, she's magnificent. But now she's also working with Director Fleischer, overseeing his area as well with transition. Clearly, our Deputy Commissioner, she's done great work, and I imagine she'll be involved, Marissa Henn. But I just want to acknowledge she's in the room today, and she was very helpful to provide the following. That Senator Carson and the advocates certainly have it right as it relates to sexually transmitted diseases, and it's very important to make sure that that information is provided for investigations. With that said, we're happy to report that our department actually receives from those physicians, clinicians, currently through our Division for Public Health Services, that information for all, not just the cohort of children 13 or under, but all individuals in the state relative to sexually transmitted diseases. And I feel the clarity already that I'm misspeaking at least on a part of that point. But what we wanted to make very clear relevant to this statute are changes that are required here is that we're currently already doing that, and that the Division for Public Health actually provides that information to the Division for Children, Youth, and Family for appropriate follow-up. And I'm going to look back right now. We did it? Close enough? Close enough. And that concludes, but I'd like to turn it over to Director Fleischer.
Yeah, well, thanks, John. Great job. Except for line 16, we're in full support of everything in this bill.
And resources.
And there's always a cost to everything. We're supportive resources as well.
Thank you both. Seeing no questions, great. Have a good day. Ms. Sanchez and Ms. Maggio can come back up. Thank you.
Good morning once again. For the record, Cassandra Sanchez, Child Advocate for the state of New Hampshire.
Attorney Lisa Massio, Associate Child Advocate.
And Lissa is passing out some extensive written testimony. One is from the Office of the Child Advocate, another is from a doctor who specializes in child abuse cases and was unable to make it here today, so it asked that we bring forth her written testimony. We both are here today in support of Senate Bill 459. Much of this bill had been discussed and brought forth in conversations that began in the Oversight Commission on Children's Services. We are very grateful to Senator Carson and her staunch advocacy for the children of New Hampshire and truly pushing the needle forward in the right direction to better protect the children of New Hampshire. We feel this bill is extremely important to protect our children. As I had mentioned previously, we do have the oversight of our child welfare system and review cases that they work on a regular basis. One of the processes that the Office of the Child Advocate uses is a system review mapping. We have learned from and been trained by a program called Collaborative Safety and use a model of safety science. And that is an ability to review some of the critical incidents or more severe cases within the division with a no shame and no blame approach. And for our system review mappings, what we do is we bring together key collaterals and stakeholders that either have involvement with this and are an expert in this field or have some knowledge about what we are meeting and talking about. And so we hold different system review mappings over the year. Those begin with contacting those directly involved with the case and getting their perspective on what went well, what barriers were in place, what feedback they wanted to share. And the outcome that we seek in these system review mappings is truly to be able to look at larger system level changes. We're not looking at the agency to say a specific worker did something wrong and mishandled a case. We're looking at it to say there are a lot of system barriers in place. How can we move the system to work better and act more protectively for these children? The last system mapping that we held was in August of 2023. This mapping was after the Office of the Child Advocate had reviewed 9 cases of serious traumatic injuries, physical injuries to non-ambulatory infants between the months of February and May 2023. Unfortunately, we have also just learned of 2 additional cases this month. One of them was also from that time frame. One of them occurred just this month. So these injuries, unfortunately, are continuing to occur to our children. And so what we did for this mapping is we reviewed, out of those, we pulled out 3 cases. And so there's a bit more detail about the types of review that we have here, what we're looking at, and some of the case examples de-identified for you. And so I won't get into all of that detail, but in the mapping, we use a learning point. And so by pulling out these 3 cases, the learning point that we identified was that many of the facts of these were very similar. The court in the division response was wildly different, but majority of those babies returned to the caregivers that potentially were the ones that caused the abuse and injury to those children. Every single one of these cases, the children were brought to an emergency department, and there was no explanation given by the primary caregivers as to what happened to the children. And also, the primary caregivers, which in these cases were all the biological parents, were the sole caretakers of these children, so it could not have happened at the hand of a babysitter or an outside entity. They were the sole caregivers. These were babies that were in the home, not going to daycare during the day. They were home with a family member. So we used this learning point and spoke with many experts, and came out of this, one of the recommendations that came out of this mapping was to take a look at our abuse and neglect laws in the state of New Hampshire and how we can enhance them to protect our very vulnerable children, infants who cannot tell us what happened to them, they cannot speak, but medical experts are finding that there are multiple broken bones, multiple stages of healing, indicating abuse, and no stories to match up with what could have happened to these children. And so we worked very closely with Senator Carson and the Oversight Commission to discuss these concerns, to bring forth our worries for these children and seek some changes in legislation to ensure that we can enhance those protections for our children. Some of those, as you heard from Senator Carson, but I may go into a bit more detail here as well. So in section 2 and 8 of this bill were specific amendments that did relate to the outcomes of the system mapping. So expanding protections for physical injury to children by expanding that definition of abused child, adding the term recklessly to intentionally, also expanding and ensuring that we include physically injured by other than non-accidental means, and also or indeterminate means if the parents or primary caregivers have offered no reasonable alternative explanation. And also in this, there's a new section 1 which defines serious impairment, any single incident or occurrence of serious injury or illness. This is important because in some of these cases, what we had heard and some of the pushbacks from the court was, this was a one-time injury. This could be a fluke. This isn't going to happen again. The children could be safe returning to their families. But what we're saying is, yes, it was a one-time injury, but this is a serious one-time injury. Some of these injuries could lead to developmental and physical disabilities for the child moving forth for the remainder of their life. Some of them included broken skulls. It included multiple broken ribs, fractures to the arms and the legs. And so these are serious injuries that a one-time cause is enough to have a very great impact on the children. We have also reviewed many cases with the agency in which we had some wonderful collaboration around what they were seeing when they were reviewing cases. Some where they didn't feel that they had enough testimony to bring this forth to the court and file petitions. In other instances, they did file petitions, and those petitions were denied by the court. And so we worked with the agency to try to understand why. And in doing that, they're very willing to share every and anything with us, and we were able to review their affidavits, which identified very clearly their concerns, the harm to the child, and why. And so it left us quite perplexed as to why our judges are not finding that to be enough. And in that, we did find that serious impairment to the child has been one in. We have asked oftentimes to be able to review the orders that the judge produces in their denial decision. And in many of them, they're referring back to serious impairment of the child. That is in section 7 that we have amended here. And we were looking to truly recognize the impacts of trauma, also ensuring that it encapsulates the psychological abuse. As we know, if we're truly moving towards trauma-informed care in this state, we understand that trauma goes well beyond physical injury. And what we learned through the serious impairment is that many judges were looking at it particularly for the physical impairment, not for the psychological and emotional impact to children. Not all of these cases involved young children. Some of them involved older children. One example I will provide to you today is a child who was a teenager living in a home where there was active substance abuse. And that child was struggling severely with their mental health. The judge found that the child was attending school every single day, and the school did not note any concerns for the child's attendance or appearance in school, so serious impairment was not met. What we understood to be true was that this is a child who was seeking mental health assistance, and the parent was under the influence and unable to bring the child to the emergency department when in crisis. This child further decompensated and ultimately did end up in the hospital. And if there was an opportunity to seek community-based mental health services prior to the incident of a crisis, this child could have avoided that disruption and the need to go to the emergency department and seek out our highest level of acute mental health care, and could have been receiving treatment right along and had been voicing the want to get this treatment right along. But again, that child remained in that family setting and ultimately was not receiving the care appropriate. We expanded some language as well, and one of those amendments includes institutional child abuse. As you heard earlier, in speaking to the prone restraints that have occurred for children, although prone restraint is against the law, it's holding these institutions accountable for their actions. And currently, we have found, although we will outreach, send letters, inform agencies that hold them accountable, such as licensing, such as the Bureau of Children's Behavioral Health that does the certification and contracting of these facilities, we are not seeing the accountability. And we are seeing unsafe practices continue for our children. And so by enhancing institutional child abuse, we are hoping that these facilities can now be held accountable and truly ensure that they are following the laws enacted by our legislature that is truly trying to protect our children. We also expanded here the definition of neglected child. Again, this is to come in line with trauma-informed care and ensure it extends beyond physical and includes the psychological, emotional, and mental well-being of the child. There is a section added as well relating to substance-exposed newborn. In this section, we worked very closely to make sure that it was acknowledging parents seeking appropriate treatment. We often hear that there are parents who have had substance abuse issues and are seeking out treatment while pregnant, recognizing that they were ready for that change in their life, and still may have a call into DCYF and have involvement potentially leading up to removal of the child because they are using medication that comes up as a positive in the hospital. And we want to encourage parents, particularly mothers who are pregnant, to seek out the appropriate treatment if they are ready and ensure that their family can stay intact as long as they are engaging appropriately in their treatment and following all treatment recommendations by their providers. And so this allows the courts, if filed, to take into account what the parents are doing and how they are engaging and ensuring protections of their child by being in substance abuse treatment and maintaining that family bond. It is very, very important for young babies to have an opportunity for healthy attachment with their parents. We understand unhealthy attachment for children leads to many issues later in life. So by allowing that family to stay intact, the parent to seek appropriate treatment, that child is able to build a healthy bond and have successful outcomes later in life. Section 9 repeals and reenacts the presumption of harm. So as you heard, the presumption of harm is set to sunset and expire on July 1st, 2024. There are aspects in there currently that are critical. I will allow the experts, particularly on domestic violence, to be able to speak to that. Which has already been in presumption of harm. And so the Coalition Against Domestic and Sexual Violence will be able to speak to that more specifically, but they had done some really great work in the past to ensure that that language was protective to not only children, but also to parent victims of domestic violence. And we want to ensure that that stays in place. We do not want to lose those protections for those families. We also want to ensure that, and because unfortunately we continue to see an opiate crisis in our state and across the country, we want to ensure that the presumption of harm relating to substance use will remain in statute as well. The addition there is Section 7, which is, as I had discussed previously, our system review mapping of those 9 babies. This is speaking to those serious injuries to infants and ensuring that that is taken in as a presumption of harm to that child, even if those injuries appear to be healing and that child appears to be doing well in the hospital after initial care. And finally is Section 10, as Senator Carson introduced. It does update for medical providers to align with other, in this review had reviewed many other state statutes, and it does align with many other states in regards to signs of sexual abuse and child trafficking. It is wonderful to hear that DPH puts forth these the information to the Child Welfare Agency if this is detected. But as we have seen in many other instances, there are times where if it is not in legislation, if it is not state law, it can be skipped or missed. We want to ensure that that is not happening and that any instance that could potentially show signs of sexual abuse of a young child or trafficking is identified as early as possible and investigated by our Child Welfare Agency.
Thank you, Ms. Sanchez. I'll just say for me, Senator Whitley and Senator Carson are much more versed and it's in their wheelhouse, this area. And so when I first, as more layperson in this field, I wasn't really appreciating the emotional, psychological problems. You know, it's easy to like, okay, physical abuse, it's there, abandonment, physical abandonment. But I didn't, you brought up the example of someone with a drug addiction problem, a parent, and the damage it could do to a child. I probably wasn't thinking broad enough because I was like, emotional, psychological. I was thinking you were going somewhere else with that. And so I appreciate it much better because of your testimony. So thank you.
So I want to just take a minute and sort of jump into the legal weeds for a second, especially around serious impairment and the presumptions of harm, because some of them are a little counterintuitive. The amendments to the statutory section serious impairment, which is 169C327, if I know how to read Roman numerals, again, sort of just generally is trying to broaden the scope from the older school way of thinking of just physical injury to a more trauma-informed area around the psychological well-being. Some of the word changes there, while they may seem minor, really have a lot of roots in trauma-informed care and effects on children. So, you know, changing the definition of serious impairment and making it clear that it could be a single event, it could be a consistent pattern, it could be observed or just predicted, knowing child behavior, trauma informed. Several of the sections have expansions. Section A, as far as age and developmental level of the child, adding, although the child's age or ability to care for themselves is not dispositive to potential harm, there's instances that our office has seen where older children in particular, who are resilient and resourceful young people, which is great, are then not being protected because they're kind of taking care of themselves okay, but that does not make the harm any different for those kids. just tweaking language around recognized mental, emotional, or physical disability to expand it, that it's social, learning, behavioral, physical conditions. With regards to school attendance and performance, it's not just whether the kid's body is in the chair. We know that they need to be able to attend and fully engage. It can reflect on, are they hungry? Do they have a place to sleep? Have they been able to rest? Do they have clean clothes? So just really expanding that thought. The one around illegal use of substances, we sort of deleted some child blaming language and expanded it. We've seen cases where parents aren't using or misusing substances, but they may be manufacturing substances in their home or selling substances or allowing people who are selling substances in their home. All of that is very harmful and dangerous for children. Again, also seeing that it depends on age. Teenagers who, are taking care of themselves are sort of being pushed to the side. In addition, that new section L, as Cassandra discussed, has to do partially with the babies, but also a single injury to a child, especially an assault by a primary caregiver. Maybe the black eye heals, but that is an extremely traumatic event. Also ties back to some of the definition changes in psychological maltreatment. So, some of this may seem like just some wordsmithing, but really it's based in a lot of science around the trauma effects on children go beyond when that broken bone heals or whether or not they're physically sitting in the classroom, or, whether their parent is actually using substances or exposing them to that entire community. So that does go back to the presumptions of harm. It does seem a little counterintuitive. The purposes of the rebuttable presumption is to sort of shift the burden to allow the division to bring a case with a little bit more weight, because some of these things are really hard to prove. And some of the medical providers here today will explain a little bit more, particularly around injuries. You can say that type of break does not occur naturally. It's not accidental, but this presumption of harm, particularly the new one, allows the court to presume that that's a not naturally occurring accident. There is a rebuttable presumption, which means the parent can bring evidence, but it does allow the division to proceed in a sort of just a different fashion. So again, sort of just building out some of the language in the substance abuse piece, adding recklessly under the impaired driving, because as you know, some substances are hard to test for, and also if people refuse a breathalyzer, you can't really get them on impaired driving, but they're still driving recklessly with small children in the car. So some of those just building out of ideas to really truly be protective for children. And as you know, in a 169C case, the standard of proof is only a preponderance of the evidence, yet unfortunately, the way some of the statutes are currently worded, courts are holding the division or witnesses like experts, like doctors, to what feels like a much higher level because of the definition of serious impairment or psychological maltreatment. So we believe that this language will sort of expand the universe, allow people to see that full spectrum of trauma and abuse for what it really is, and it's harming children.
Thank you both. Senator Whitley.
Thank you, Mr. Chair. I think it's important to take a breath too, because we're talking about really, really tough situations. I'm honored to be on the Oversight Commission led by Senator Carson, and we hear really tough stuff. We're talking about babies, right, who have broken bones, and babies who are being subjected to sexual assault. On my very best day, I have to believe that parents love their children. And so would you agree that all of this work, which is so desperately needed, is not so that the hammer of the government can come down and punish parents, but that it's really so necessary to connect these families who are in desperate straits? I mean, you have to be to commit this type of abuse. And would you agree that all this work is so necessary to build that prevention framework, to get these families connected so we can prevent these things in the future? We're not looking to punish parents, we're looking to support families. Would you agree with that?
Yes, absolutely. And thank you for that point. That's a wonderful point. We understand that the majority of cases that are called into the division are not then court involved in open cases. There are a lot of opportunities for them to offer voluntary services to families. So by expanding this, it may bring the family issues to the attention of the division, but it does not automatically mean it is court involvement. A lot of times there are those preventative services that can be put in place by the division, and that family can then overcome those difficulties and move on, finish out their voluntary case, and have no further involvement with the division.
Follow up?
I would just add to that really quickly too. When read in conjunction with SB 417, which will be heard this afternoon, by stressing that the placement preference is to keep the child in the home, even court-involved cases, these changes to the abuse and neglect statute doesn't mean we want to take more children away from families, but like Cassandra said, we want to make sure those children and families get the services that they need.
Would you also agree that this work is even more important coming out of the pandemic where families were isolated, children were isolated? We saw a decrease of reports to DCYF because kids weren't in school, right? So would you agree that this is even more necessary now as, families are emerging, children are emerging, that we're probably likely starting to see the traumatic effects of things that happen? Would you agree with that?
Yes, absolutely. We're seeing a lot of traumatic fallout of COVID from all levels, not just for our children. We are absolutely seeing it in our child populations, but our rise in mental health needs in children is not isolated to children. It is with adults as well.
Thank you. Senator Evans?
Thank you. Just more of a constructive question. On page 2, line 30, it strikes the word consistent. So it would basically, it would be considered abuse if there's consistent mistreatment or neglect. By striking consistent, I guess I was just going to ask, would that result in virtually any finding of neglect also meaning abuse? Or am I just reading it too far into it?
So this is to align with some of what we had mentioned around the serious injury or psychological injury, that there are instances where it can be severe enough that once is enough, and it does not need to be consistent to have that impact to children. And so it does not mean that every one instance would rise to that level, but it would need to be something that has that serious impact on a child. So by taking out the word consistent, we don't have to let a child repetitively be traumatized and psychologically mistreated. That one time that rises to that high level, that high threshold, would then qualify.
Thank you.
Oh, okay. Yes, Senator Carson?
Thank you, Mr. Chairman, and good morning. It's good to see you again. I want to thank you for all of this. For some of us have been doing this for a while, and we've been very lucky to have the support of Governor Sununu standing with all of us, the advocates and the legislators that are interested in improving child welfare in the state of New Hampshire, and really recognizing there are codependency issues, that when a child acts out or something happens, we know that there's something else going on, that acting out is the result of something that happened here. And that's the same approach that we've taken with substance abuse, that oftentimes the substance abuse is the result of trauma and long-term trauma that a person has gone through. So that's another reason why I think this is important. But equally important is recognizing that small children are being victims of psychological as well as physical and emotional abuse. And I guess it's really a point. How many times have we read in the paper where a toddler was found wandering out in a neighborhood with no one watching it, and upon investigation, the parent or the caregiver is in the home and they've passed out because of substance abuse, and that's how the child got out? Or the police are called because there's a car and there's a child, an infant, sitting in a car seat while either mom or dad is passed out because there's been some sort of drug thing going on. And really, those are the things that we're trying to get out. This is not aimed at parents and pointing the finger and saying, you're bad, you're bad, you're bad. This is recognizing that young children are often put into very difficult situations, and that needs to be addressed, because if you don't address it, it will occur and occur and occur. More damage to that child is going to happen. That child, as they get older, are going to start acting out and doing other activities that could bring them in contact with our juvenile justice system, our adult justice system. So if we put the care and the prevention here early on, so that person can become and grow up to be a productive adult and not getting into contact with our criminal justice system. For me, that's really one of the goals here, is to really just look and say, look, we've got to take care of this here. We've got to recognize that children are being subjected to horrific psychological and emotional abuse. That needs to be recognized as we go forward. And regards to my colleague, his comment about the use of the word consistent, how many times does a child have to show up in an emergency room with a broken bone? Do you have to establish the fact, is it 3 times, 4 times? And we have to take a step back and say, every time more damage is being done. And sometimes that damage can be physical, but you gotta stop and think about the emotional and psychological abuse that's happened to this child. These little kids cannot really articulate and understand why this is happening to them. And that's why people being informed about trauma-informed injuries is so important. And I truly believe this is a great step forward to educating not only the state, but all of our citizens, how important it is that they know and understand what trauma-informed injury really is. So I want to thank you. It's more of a comment, not a question.
+1 to all that.
So thank you very much.
Thank you.
Thank you both. Seeing no more questions, thank you. Pamela, I can't remember the last name. Kylie? Okay, thank you very much.
Good morning, Mr. Chair, members of the committee. Mr. Chair, this morning. My name is Pamela Kylig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. The coalition is the umbrella organization for our state's 12 community-based crisis centers. And as you know, we serve nearly 14,000 victims of domestic and sexual violence annually, and that includes both adults and children. I'm here to testify today in support of SB 459 legislation, as you've heard, that will strengthen our state's child protection laws to better respond to cases of abuse and neglect and help mitigate the devastating impact of domestic violence on victims and their children. The coalition specifically has a vested interest in policy initiatives that seek to prevent child abuse and neglect, especially when it comes to cases involving domestic violence. Specifically, this bill does 2 key things that I just wanted to speak to this morning that are both protective for victims and their children. It expands the definition of abuse and neglect to include the emotional, psychological, and mental well-being of a child, and it maintains an important carve-out for victims of domestic violence under the rebuttable presumption of harm. I know you've heard a little bit this morning about this, so I'll try to keep it brief. But adverse and traumatic experiences in a person's childhood, such as exposure to domestic violence, can place individuals at an increased risk for chronic health problems, mental illness, and substance use, among other things, into adulthood. Identifying these adverse childhood experiences and creating certain support systems for children at an early age is critical to breaking the cycle of abuse and violence on an intergenerational level. While we have long recognized that child abuse causes long-term effects for the child, we have been slower to recognize the very same effects are suffered by children who do not experience physical violence, but are growing up in a household and witnessing violence and other forms of abuse. And so this can have an emotional, psychological, and mental health impact. By expanding the definition of abuse and neglect to include these facts, this bill would allow children who have previously been unidentified or unserved by the system to receive the services they desperately need. The child protection statute currently sets a really high bar for determining neglect and risk of harm, and we have heard from countless victims across the state that the strict interpretation of the statute has had an impact on the ability to take the necessary actions to protect children who are at risk or are experiencing abuse that has resulted in serious bodily injury. So I think this really is looking at the whole circumstance that might be going on in a household. And I think it's just really important that we recognize that child abuse can take on many forms and doesn't necessarily need to result in physical injury in order to have long-term and devastating impacts. I think just to quickly highlight, we know that there have been instances where victims have come forward and tried to seek help and protect their children, but because of the current language have been told that their child isn't at risk of abuse or harm, and that has cause so much stress and anxiety when they're just trying to protect their children. And protective parents shouldn't be forced to wait for the unthinkable to happen to their child before they can act in their best interest and for their safety and well-being. And so I just really applaud the effort here today to bring this language forward. And then I just wanted to briefly speak to the rebuttable presumption of harm that was highlighted. We do support the language and are happy to see that it won't be sunsetted should this bill pass. I think it's just really important because it recognizes that under current law, the rebuttable presumption of harm only applies to the perpetrator, not the victim, and really allows us to ensure that when a child is exposed to violence in the home, we're not we're recognizing the perpetrator is alone responsible for the dangerousness in the household, and it's not the victim's fault. And so we are grateful for the language to be included in this bill. I will stop there because I know a lot has been discussed this morning already, but we just, again, really support the bill, and thank you for your time today.
Thank you, Ms. Kiley. Just, we can just talk, me and you, no one else is here. So when you don't see the state ever being in a position where they could be abusing the emotional or psychological factors. If someone pushes their Tiger Woods dad pushed the kid too hard, we're going to take him away because you driving the kid crazy. California, where they maybe have a different set, they have different values for a trans or something, might say the family's not providing an emotional or psychologically nice foundation. Or, you know, I won't let the kid have puberty blockers, so I'm a terrible parent because that's the natural course if I was out there. Could we ever get in a problem where this, and it's probably just a far tangent I'm looking at, but do you see those possibly getting abused?
I want to echo what the Office of the Child Advocate said in terms of what the scope of what the bill is trying to address. I don't think that would be the focus.
I'm reading things.
I'm thinking about instances that we've heard where children are losing hair due to stress and anxiety of witnessing what's happening and their parent trying their best to get them out of that situation or protect them from those horrible circumstances and not qualifying as harm to the child. So really kind of that focus.
It's probably me looking at myself. So I've always encouraged the kids to do too well, too good. Now my young freshman in high school doesn't accept anything except doing perfect at every sport. So I feel I've directed them too far in one way. And anyways, so I wouldn't want the state later coming to me and saying, oh, no, you're, anyways, thank you. Senator Almus, did you have anything? Thank you for indulging me. Have a good day. Amy Roy. Hi, Dr. Roy. How you doing today?
Oh, you need to turn your microphone on.
I'm sorry.
It's okay.
Oh, is that on?
Yes.
Yep.
Great, okay. I'm Dr. Amy Roy. I'm a pediatric emergency physician from the Elliott Hospital. I also serve as what's called an advanced medical consultant, evaluating concerns for child physical abuse, child sexual abuse, and other forms of maltreatment in New Hampshire, working both with the Elliott and Dartmouth. And I thank you all very much for hearing today's testimony on closing an important gap in New Hampshire's child protection system, which is putting children at risk. Unfortunately, bad outcomes like death or permanent injury are not uncommon for children who experience physical abuse.
This is particularly true for infants who are particularly vulnerable. But I think what we have to acknowledge is that these events are not lightning strikes. We really have an opportunity, and I would say a responsibility, to affect change and to ensure more positive outcomes. Medical literature, which is really amply supported by our experiences here in New Hampshire, consistently demonstrates that children who suffer bad outcomes from child physical abuse have very often been seen and evaluated for previous injuries which were less severe but representative of physical abuse. So these outcomes are preventable. There is an opportunity to change this narrative. We can really change this child's story from something that ends in a personal tragedy, a family catastrophe, to a situation in which children are protected, parents and caregivers are supported, and families have the opportunity they deserve to grow and thrive together. But that outcome doesn't just happen by itself. That really requires recognition and a commitment to action. And it requires some functional alignment of the medical system, the child protective system, and the judicial system. You know, recently in New Hampshire, I think we worry that there has been a breakdown of that alignment. We heard from the Office of the OCA that over a 5-month period, 9 infants with significant injuries, thoughtfully and ultimately attributed to abuse, were sent home from court proceedings. There was no finding made. And what is important is that there was no requirement for caregiver supports or services. This issue was the subject of the system mapping hosted by the OCA in August. I participated in that because I was closely involved in 3 of the cases. You know, I can share that in each of those cases, there was involved a young infant with significant injuries, which a caregiver was unable to offer any plausible explanation for. Each of these babies had a meticulous medical evaluation entirely consistent with national standards of care, which excluded any diagnosable medical condition that might mimic abuse. And yet these children were sent home. You know, in those instances, and bafflingly to me, the shoulder shrug of a parent, a simple, I don't know, carried more weight than the combined and cautious assessment of medical and child protective professionals. I think this bill takes an important step to close that gap. It acknowledges what I think we know intuitively and what is really common sense, which is that parents have a responsibility to know what has happened to their children, particularly to infants. A 2-month-old infant is not independent. A 2-month-old infant does not have a private life. A 2-month-old infant is wholly dependent on his or her caregivers and uniquely vulnerable when those parents can't or won't act appropriately, protectively, and responsibly. The 2-month-old infant that I care for did not break her own foot. Someone broke it for her. So I appreciate very much you hearing this bill and would be happy to answer any questions.
Thank you very much. Do we have any? Seeing none, thank you for your testimony. Is anyone else not signed in who wishes to speak on 459? Go ahead, I'm sorry. Oh, I'm sorry. You are down at the bottom here. Dr. Ual?
Yes.
Thank you.
Good morning,
Morning.
dear members of the Senate and Judiciary Committee. So my name is Dr. Ritu Ulal, and I'm a trained family physician. I work for Dartmouth Health down in Nashua. I am part of the Child Advocacy and Protection Program, and for the last 3 years, I've been serving to help do specialized medical evaluations for children when there's been concern for abuse or neglect. Of note, I'm a trained family physician, and so for about 20 years have that experience as well as a primary caregiver. Also worked in the fields of urgent care and substance use disorder, which has, I think, allowed me to really look at families in sort of a systems sort of way, but also more holistically for that child. I'm here in support of this bill, of Senate Bill 459, as is the CAP program. I'm also a part of the New Hampshire Medical Society, who's also in support of this bill. So I think the relevance of this bill, I feel has been really well fleshed out and pretty well understood. And I just wanted to extend or point out that it extends to beyond the infant age as well. And we see that, or I feel that the wording helps reflect really what we're already doing in medicine and what is supported by best practices, both in primary care as well as in the evaluation when there is a concern for abuse. The addition of the word recklessly is really important when we see cases when there's concern for abuse or neglect, because it's not very common that a caregiver will say, I intentionally did X, Y, Z. And there is no doubt that parents do love their children, and yet things like this can happen. Also, the messaging and the wording around having a reasonable explanation is also really important, because this is how we really do medical care anyways. So attendant and caring for children, whether they're infants, children, or adolescents, when there's been an injury, is that we do need, and we do typically hear a fitting explanation for that injury. This is no different from any other medical condition that we may evaluate. So if somebody comes in with, a child has a deep cough, we often will take that medical history, ask parents maybe when it was started, when it started, what other symptoms are there, what's been done. And it's the same thing. We expect a caregiver to provide us with some history because it helps us in being able to make a diagnosis. We don't usually have someone with symptoms or an injury come in and say, I'm not sure, or give an explanation that completely doesn't fit. So again, the language really does support how we do medicine in general. So it's not necessarily even specialized to just physical abuse. And I think that's really important because it's not, I think the goal here is to bring those services to families where more supports can be given. I think the alignment of the language, as Dr. Roy mentioned, is really critical, because then we're all sort of working with the same set of understanding of what the impact of these injuries can be, and then able to have a consensus on how we manage and provide those services. I did want to share a couple of examples, noting that this can be really difficult to hear, but I think it's important because sometimes the scope, as you mentioned, what is the range? And I'm happy to answer any questions about, psychological maltreatment and neglect, which are parts of the evaluation that I do as well, particularly when it's relevant and disclosed by a child who's able to disclose it. But just a couple examples, just in this is over the last 4 months, I saw a 2-year-old who was removed from a clandestine methamphetamine lab here in New Hampshire. There were other children as well. And this child had extensive bruising to his buttocks, his lower back, his flank area, underneath his diaper area. So it's a padded region. Parents were the only caregivers, and there was zero explanation given for these injuries. His 2 cousins that were also in the home did not have any injuries, which is good, but to not have any diagnosis or any explanation for what those could be was really difficult. I saw a 4-year-old who had strangulation marks or ligature marks around his neck. And so they, it's not diagnosed as strangulation marks, but it's come in with, severe concern for strangulation because of the marks on his neck. The parental explanation in that case was she was pulling on the child's t-shirt from the back. In this situation, the injuries that were open and aware, that there was a delay of sending the child to daycare for a couple of days. And then once they went to daycare, it was reported. When the child came to CAP, as medical providers, we do undress the child and do the full examination. And I was able to appreciate that there was bruising on many other parts of this child's body, not explained by a t-shirt explanation. So again, if the explanation may meet part of it, but not all of it, and even then too is kind of a stretch, it's important in how we are able to care for that child. Having a misrepresented explanation or something that doesn't fit can give delay in care, in terms of evaluation, but also in treatment and any of the other things that might happen. I have a couple other examples that I'm not going to get into, but some of them are with regards to burns, including patterned burns. So not an accidental splash, but rather, you can see the full thickness or the defined borders. And these are classic for, unfortunately, intentional injury as well. delay in care in those as well, especially if it's initially explained to agencies as, oh, it probably happened this way, can actually result in infections and other consequences that can harm a child. So the care of the infant and that non-mobile child is very important. The toddlers or children who may not be able to speak or disclose, or who have that psychological pressure of they've been told to don't say anything. I have a child who, just went to her support hearing, but she was a victim of sexual assault as well. And she was repeatedly told by the perpetrator that if you say anything, you will go to foster care. So his psychological maltreatment contribution actually kept her from being able to even seek care for years as this was happening. I'm happy to answer any questions. I'll sort of stop there. Sorry to kind of share some of those harder things with you.
Thank you very
but
much.
I think
It's
that's all.
enlightening. Any questions? Seeing none, thank you for coming all the way from Dartmouth.
Thank you.
Does anyone else wish to testify on 459? Seeing none, that closes the hearing. We're done. Good morning.
Just so everyone knows, there's a reason why I put this on last, because I knew we were gonna hear some things that we might find upsetting, but when you operate in the world that Senator Whitley and I operate, we do hear these things, and they can. So I think we need just a little break, and we're going to, the committee will reconvene at 1:00, and thank you all for joining us. So again,
Just grabbing my coffee.
Okay, we're gonna go ahead and get started. Good afternoon and welcome to the afternoon session of the Senate Judiciary Committee meeting for Thursday, January 25th, 2024. We're gonna open the afternoon by recognizing the prime sponsor of Senate Bill 417, our own Senator Whitley. Good afternoon, Senator.
Good afternoon, Madam Chair, and good afternoon, member of the committee. For the record, my name is Becky Whitley, and I'm honored to serve New Hampshire Senate District 15, which includes the wonderful communities of Bow, Concord, Pennacook, and Hopkinton. Today, I'm honored to introduce Senate Bill 417, which is another important child welfare bill, which advances strategies based on solid evidence. I see this bill before you as a very important companion bill to Chair Carson's bill, Senate Bill 459, and Senate Bill 363. As this committee knows well, my life's work as a lawyer, advocate, and now state senator has been focused on strengthening families, building stronger communities, and ensuring access to opportunity, because children and young people need all three to succeed. In particular, I feel we have a moral obligation as leaders to support vulnerable children and families, an obligation I take very seriously, and I'm happy to partner with you, Madam Chair. The legislation before you was a request of the Office of Child Advocate in response to the OCA's August 2023 investigation and report on the mistreatment of New Hampshire youth placed at the Bledsoe Youth Academy in Gallatin, Tennessee. When children are involved with DCYF, developmental services, BCBH, and require out-of-home placement, yet foster care is not a match due to the specific behavioral, developmental, or mental health needs, they are often placed in residential facilities in or outside the state of New Hampshire. These facilities are intended to serve as temporary residents with therapeutic treatment to assist the child in gaining skills to better manage their behaviors and emotions so they can return to a community setting. Prior to placing children out of state, all family, foster, and in-state options are supposed to be exhausted. This is important because many children referred to residential treatment have suffered years of trauma due to exposure to substance misuse, mental illness, domestic violence, and or abuse and neglect by primary caretakers. But tragically, the OCA's report detailed deeply unsettling and troubling conditions faced by the New Hampshire children at this Tennessee facility, including reports from children that staff offered them incentives to assault other children, that there were cameras in the bedrooms, leaving children with little privacy to change, and that children had suffered rug burns while restrained face down on a carpet. The OCA's report detailed that the facility appeared dirty, had little recreation space, and was defined by a, quote, culture of shame, humiliation, and inhumane punishment. As an example, the OCA noted in her report that staff at the Tennessee facility could not explain the complicated point system that determines a child's privileges and punishments. She noted children were dressed in color-coded jumpsuits based on behavioral needs or punishments, a system that communicated personal information to all staff and children. It's important to note that all of this occurred in the context of ongoing litigation against the state, where plaintiffs are alleging that the state is over-reliant on congregate or institutional settings. Although the bill before you does not solve every problem identified in the Bledsoe report, it's an important first step. Experts tell us that the most effective way to help children is to involve them and their families, friends, and professionals in all decisions related to out-of-home child placement. Specifically, this legislation codifies DCYF policy regarding preference of placement of children involved in abuse and neglect cases, prioritizing children with family or people they have existing relationship with and in their communities. The bill also strengthens the existing statutory preference for the in-state placement of New Hampshire children who are removed from their home, and also strengthens the requirement about residential placement of those children, including an important new requirement that a licensed psychologist with specialized training must oversee any psychological evaluation for child placement. and court oversight of these placements. This bill also strengthens the existing mandate for siblings to be placed together when removed from the home. Lastly, the bill also expands the factors to be considered by the court when reviewing the fitness of a non-accused parent in a RSA 169C case to prevent the tragic results of a child being placed with a previously non-custodial parent who is unable to safely care for that child, and enhances the existing factors when reunifying a child with an accused parent at the end of an RSA 169C abuse or neglect case. I want to thank DHHS, the OCA, and the JRPG, and also the Association of Justice for their commitment to children and their ongoing work on this bill to ensure it adequately protects children. These child advocates are working together on an upcoming amendment that will come before the committee. We had tried to get it ready for today, but OLS is very busy. But they will be continuing to meet to reach consensus, to bring forth an amendment before the committee that balances all the important interests here. Thank you very much for your consideration of Senate Bill 417. I'm happy to take questions, but there are many, many folks behind me who have expertise in representing these children and some technical expertise as well.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Okay, seeing none, thank you.
Thank you.
The chair will call Cassandra Sanchez and Lissa Massis from the OCA's office.
Good afternoon, Madam Chair.
Good afternoon.
Esteemed members of the Senate Judiciary Committee. For the record, my name is Cassandra Sanchez, and I'm the child advocate for the state of New Hampshire.
Attorney Lissa Mascio, I'm the Associate Child Advocate.
As Senator Whitley mentioned in her introduction of the bill, we are here in support of Senate Bill 417 and the critical changes it makes to out-of-home placement for children in the custody of our state. I first want to share, I know Senator Whitley got into some of the details in the Bledsoe report. We did share a copy with you today if you've not seen it already. I do just want to share, I won't get into too much detail because it was quite horrific, witnessing what the children were undergoing at this facility, but it was by far the worst placement facility visit I have ever had in my time, not only working here in New Hampshire, but also in my time working in child welfare in the state of Massachusetts. I have not seen that level of disregard for children and their mental health and their needs in a facility that is calling themselves a treatment facility. So I will share, we have a level system here in the state of New Hampshire that rates treatment facilities from a level 1 being the lowest level placement to a level 5 being the highest level placement. Bledsoe Youth Academy was, it still is rated as a level 3 therapeutic treatment facility. And we did not witness any therapeutic care being provided to the children when they are there. I am happy to be able to share that our state is no longer sending children to this facility and has since decertified this facility. And so although the state, and we have worked very closely with DHHS to take steps to improve out-of-home placement, out-of-state placements for our children, we have seen a great reduction in out-of-state placement for children in New Hampshire. We do still believe strongly that it is going to take legislation to ensure the protections for all of our children in care. So Section 1 of this bill strengthens the language about children being placed outside of New Hampshire. Of course, we understand at all times it is best for our children to be served in their communities and in their homes whenever possible. But we also recognize the struggles currently in our state. We have staff shortages that are impacting our community-based services, as well as our community mental health centers. Those same staff shortages are also impacting our in-state residential facilities, meaning that they cannot fill all of their beds. And so our children are being sent elsewhere to receive a level of treatment that they require. We do feel very strongly that we need to continue to focus efforts in our state on building up our children's system of care and providing those community-based resources, but in the interim, also protecting those children that are required to go to residential treatment because we do not have the community-based resources available to meet their needs at home. And this bill would help do that. A large piece of this bill as well is a focus on the short-term placement of our children. Oftentimes you find kids that go to residential treatment will linger in that care well beyond the length of time of treatment or well beyond the length of time for them to be at a point where they could successfully transition into the community. What happens when our children linger in these placements for far too long is they actually regress in their treatment at a certain point of time. So they're no longer making treatment progress. They're going back to behaviors that will keep them in care for longer periods of time. So this bill would tighten it so that it would ensure that treatment that children are getting in residential facilities is appropriate, is meeting their needs, and when they are ready to move, the state is expected to find a placement for them that is appropriate and is community-based. Section 2 of this bill is, this piece does not touch on what we observed in Bledsoe, but does touch on cases that we have observed and some that we have worked very closely with DHHS on. And this is in regards to siblings going into care and the separation of siblings in care. At the last Oversight Commission meeting, myself and Associate Child Advocate Massio presented a case where there's 3 siblings that are in the care of the division and they had been separated. And unfortunately, because of the circumstances of their family situation, those children are not going to be returning home. So the state is looking for permanency for those children. Myself, CASA, and others have advocated to get those children together for permanency. There is an opportunity for them to have a permanent option. Why would we separate them and have them adopted in other homes and raised separately when these children could thrive and truly want and have expressed very clearly the need to be together and the importance of that sibling relationship? So we do understand that that exists in policy currently for DCYF, but this is just one case example where that is not happening. And it is taking court oversight to intervene and ensure that these children can get back together. And we would like it to be in legislation to ensure that as the court moves forward in those determinations, that they have legislation that supports and statute that supports that these children should be together for more positive outcomes in the future. Section 3, again, also unrelated to the issues that we uncovered at Bledsoe. Section 3 is in relation to fitness of a non-custodial or non-accused biological parent. Unfortunately, we have reviewed some very high-profile cases, one that was just a year ago that involved the death of a child, and that could have potentially been avoided had the Child Welfare Agency had an opportunity to further investigate a non-accused parent before that child was sent to live with that parent full-time. We also have learned quite a bit, including from the Massachusetts Office of the Child Advocate report on Harmony Montgomery, that this was a key issue that they pointed out that occurred with Harmony being sent to her father out of state, where a home study by the state of New Hampshire had not occurred. Information was not shared by our state with whether they felt he was fit to be able to meet her needs. And it was very clearly identified that the court did not have an opportunity to consider her unique needs and his ability to meet those needs. So we were looking to enhance this section so that it allows for an opportunity to truly look into parents who have not been involved, do not have a longstanding relationship with a child, who may be re-entering their life, to make sure that they can meet their needs and they're going to act protectively and not further harm these children or cause further trauma in their lives. A new section, 169C19G, begins to address some of the issues with our state-sanctioned evaluations and examinations of children in state care. Currently, we have some assessments that children can undergo, and they can be sent to residential facilities for this. These are typically very short-term residential stays, and they're undergoing a number of psychological evaluations, including personality measures. But we understand from reviewing these and from speaking with a licensed psychologist who currently conducts case reviews and takes a look at the outcomes and future treatment goals for these children, we found that currently at these facilities, it is not licensed psychologists that are doing these evaluations. Oftentimes it is master level clinicians, and they are not even being supervised by the appropriate psychologist. The real scary piece of having these evaluations exist in a record for a child is that these evaluations determine next steps in the future treatment for a child. Many times what we find when they are done by unqualified professionals, they're recommending higher levels of care, or they are putting damaging information in a record that follows a child, often making them exempt from being accepted into any facilities in our state. So these are our highest need children that are then sent out of state into facilities that we do not have the same level of oversight to ensure their protections. If by chance we had the appropriate providers to ensure that these psychological evaluations are done following the guidelines to do this testing and ensuring that those outcomes are truly looking at the strengths of the child and considering what community-based options can meet their needs, we feel strongly that they could remain in a lower level of care and not need to be placed out of state, potentially many being treated in the community with community level supports. Another new section, 169C19H, we believe is one of the most important aspects of this bill, including Section 6 of the bill, which mirrors this language and the language of Section 1, to ensure that all children involved with DCYF are covered under RSA 169F. This would mean that we're not leaving behind our children that are involved in the juvenile justice system. Those are our children that may have charges against them. Those could also be our children whose families are going to the court for cases, CHINS cases, they're called, Children in Needs of Services, which are also managed under juvenile justice. These are children with high mental health needs. They have parents and caregivers who are there to support them, who there are no concerns for these caregivers that for abuse and neglect of these children, but their family has not been able to seek out the services in the community to meet their needs, nor can they manage it on their own. They're at a point where they are seeking out assistance to ensure that their child gets support and treatment. And we want to ensure that none of these children get left behind. The other key piece, which is incorporated here in H, is about the placement preference for children, keeping families intact being the number one priority of this bill. We want to preserve families whenever possible, and we understand the impacts and the trauma to children just by a removal from the home. And so ideally, we would like our children to remain at home and be provided community-based services, but when that is not possible, this would allow for the least restrictive setting. And there is a preference here because we understand that as children's needs increase, it may require a different level, or some children unfortunately do not have family and support systems for them. And so least restrictive being the top priority and then moving down, as well as the importance of keeping our children connected to their communities. We find far too often that our children are removed from their homes, placed further across the state in a community that they are unfamiliar with. They lose connections to their friends, extracurricular activities, trusted adults in the community, school systems. So it is critical to ensure that our children can stay in a family-based setting that is close in proximity to the community that they will return someday. And so with this preference here, we have that from after the legal custodian or biological parent, the next preferred caregiver would be kin or fictive kin, a foster home within the child's home community, a foster home that is known to the child, or a more intensive foster placement that can provide therapeutic supports but can keep the child in a home-like setting. If and only if none of those placements are appropriate to meet the child's needs, should residential placements be considered. Another issue that the Office of the Child Advocate has been following closely for a very long time has been children who are not appropriate for residential care. They very well could be successful in the community, being placed at a higher level of care. And so that means children, again, losing all of their prime connections, losing family, friends, to be in a setting, an institutional setting around children who truly do need that level of care and potentially even learning behaviors from them and further decompensating in their mental health. And so we truly feel that resources that our agency has access to should not be the reason why a child goes into residential care. We need to get creative as a state. We need to work outside the box, which I'm very grateful in the work with DHHS and DCYF Director Fleischer that there is a willingness to do that work. We want to make sure that they are held to that standard to get creative around placements and not place in residential facilities because that is where a bed is available. And unfortunately, we have received inquiries to the office about children being placed in restrictive residential settings as young as 6 years old due to difficulty of securing a foster home.
I'm going to look at section 5, which is standard for return of child in placement. This just makes some changes to RSA 169C23 to align it more closely with what we've been discussing here today with the actual safety of the child in a more holistic manner, knowing that throughout the course of a case, other issues arise. A lot of advances have been made in trauma-informed care moving forward. And again, aligning it with the idea that the parent is able to give proper care to that child when the state is returning a child to a parent's care, because as we've seen, there are sometimes tragic outcomes even after the state returns a child because it wasn't quite safe for that child. I will sort of in a holistic manner, as Cassandra stated, a lot of the ideas in this bill are already current DCYF policy, written policy or stated policy, the goals of the agency to keep siblings together, the goals of the agency to keep children in their home or placed first with relatives. However, without them being in actual statute, the courts do not have to follow DCYF internal policy. In fact, in April of 2023, there was a Supreme Court case in Re JR that stated explicitly the fact that DCYF is not following internal policy does not have an impact on the court, because the court's mandate is to follow statute and only statute, not internal policy, because that would be reading into the legislature's intent. So that's why we feel that even some of these things that the division does now, at least according to their own policies, we have seen so many instances where these aren't being done, children are being harmed, that we do feel it's important for it to be into policy. And Section 6 of the bill, as Cassandra mentioned, mirrors Section 1 in the second part of Section 4. 169C, where they are in Sections 1 and 4, relates only to abuse and neglect cases. We do feel that this placement preference and preference of keeping children in state or at least in very close proximity to their family is important for all children in care, which does extend to kids in 169B juvenile justice cases, 169D CHINS cases, as well as placements for episodes of treatment through BCBH. So by placing these sections mirrored into Section F of 169, that covers all court-ordered placements. So and as Senator Whitley mentioned, we are working on some additional language. You'll notice a couple times in the current bill, there's reference to increased judicial oversight and judicial review, particularly for children in residential care. So that's what the amendment is going to be addressing. It is a pretty comprehensive look at the information the court really needs and is not necessarily getting currently to be able to adequately assess the initial placement, whether it's appropriate, as well as more frequently ongoing, so that children hopefully can get out of those placements more quickly.
And final addition, thank you, Alyssa. You did add in as well the importance of proximity. So we understand, again, because of a reduce in resources in New Hampshire currently, that we cannot have all of our children in state immediately. And so it is important to allow there to be some flexibility for children to be sent out of state, particularly if we do not have a bed or a facility in state that has the specific treatment that that child needs. One that we hear of often is children with eating disorders. There are not a lot of specialized programs for that. And so oftentimes children have to go to out of state for that level of treatment. So having the language in there allowing proximity, it is saying that yes, for appropriate level treatment, a child can go out of state, but ideally we would like that program to be as close as possible. We have many families that live on the southern border, and so placements in Massachusetts can be appropriate and can allow that family to still engage in the family work that occurs at that treatment facility. And thank you. We are open for questions.
Thank you very much for your testimony, Ms. Sanchez. Are there questions? Senator Whitley, then Senator Chandler.
Thank you, Madam Chair, and thank you for all your work and your testimony. Just a quick question as we continue to work on the bill with all the stakeholders. There's been a suggestion that we want to make these requirements applicable to both 169B and C. I just wanted to see if you're supportive of that.
Yes.
Yes, we are.
Thank you.
Yes, in all B, C, and D, yes.
Correct.
Senator Chandler?
Thank you, Madam Chair. I have a question about a statement you made, Sanchez, about, and the placement for the portion regarding placement for evaluation. As I understand it, and correct me if I misunderstood, but you said assessments by master's level clinicians differ from the assessments done by a licensed psychologist. And so I'd like to know, in which ways do they differ? Why do they differ? If you can answer that. And also, if we are requiring that the assessments be conducted by or supervised by a licensed psychologist with specialized training in the evidence-based treatment of childhood trauma, can you tell me a little bit about what that landscape looks like? Do we have those folks available?
We do have an expert here today that can speak to that more in depth than I can, but what I will share is that my understanding is that some of these evaluations that I'm talking about, particularly those that involve the personality measures and that are psychological evaluations, those should be conducted by a psychologist. A master's level clinician would not be qualified to conduct those kinds of assessments. There are assessments that master's level clinicians are certified to undertake, but any psychological evaluations would not fall under that. They do not have the training to do those.
Ben, if I might follow up, do you think someone giving further testimony is better to answer the second part of the question?
Yes.
Okay, thank you.
Thank you.
Okay, are there any further questions from the committee? Seeing none, thank you very much for your testimony this afternoon. Okay, next, we have a number of folks from DHHS. We have Katja Fox, if you'd like to come forward, and Mr. Fleischer from DHHS as well, and Krista Morris from DHHS. If there's a chair that you can bring forward, I think we can maybe get one of those.
What we can do is I can provide the talking points and then field the questions to our directors, so I can get up and move too.
Okay, if that's how you want to do it, that's fine.
No, Jeff will.
Probably a little chair of honor there.
Yeah.
The comfy chair. Thank you very much for being here.
Thank you for having us. Madam Chair and members of the committee, thank you for having us here today. My name is Krista Morris, and I'm the Director of Intergovernmental Affairs with DHHS. With me today is Director Jeff Fleischer. He is our Director of DCYF, as well as Katja Fox. She's our Director of Behavioral Health Services. I'm just going to provide some talking points for you today, and then questions can be fielded to my two experts here with me. The department joins the policymakers, communities, families, and advocates in prioritizing the safety of children. If a youth needs residential care that can't be provided in New Hampshire or with a facility in a nearby state, DHHS has a responsibility to serve them outside of New Hampshire. We engage in a nationwide search to find the most appropriate certified facility to accept the children and serve their needs. The National Youth Mental Health Crisis has put significant pressure on states and national program to find available and geographically accessible programs. We have shifted to a clinical-based assessment with that individualizes placement decisions as of October 2021. When DCYF youth are placed out of state, they are visited monthly, which admittedly is an increase from recent years, where it used to be quarterly. We ensure all programs remain in compliance with their certification requirements. On rare occasions, we or advocacy partners encounter operations that do not meet our standards, and we take immediate action. In addition, over the past several years, the implementation of the juvenile justice and children's system of care strategies has led to more youth receiving services in the community and fewer placed in residential facilities. We will continue active collaboration with the OCA on all ongoing efforts to improve residential and community-based services to ensure the best possible outcomes for youth and their families. New Hampshire has made progress in recent years to reduce reliance on institutional placements for many youth with complex needs. We have achieved the lowest rates of youth incarceration in the country and cut the number of juvenile justice placements in out-of-home facilities, residential treatment, in half. New Hampshire removes fewer children and has lower overall foster care rate than most states. This has largely occurred by scaling up evidence-based, community-oriented programs, building a children's system of care for behavioral health, establishing a juvenile justice assessment process that deflects most youth from the formal justice system, and respecting the incorporating voices and choices of youth and families in our decisions. We have also begun the process of planning for a small, trauma-informed therapeutic detention center, started a new supportive kinship care initiative, and innovative foster care recruitment and retention practices. In addition, system reforms in New Hampshire mean that many of the youth served by residential programs, both within and out of the state, are achieving significant therapeutic improvement in highly supportive and, when needed, highly specialized environments. The Division for Children, Youth, and Families have participated in ongoing and frequent meetings with the Office of Child Advocate to chart a path forward to better serve the small number of children, youth, and families who interface with the residential care system, but whose needs all could be met in the community if applicable where available, and strengthen oversight of residential programs, particularly those that are geographically far from the youth's home and community. This is a major reason we hired Jeff Fleischer, because of the extensive experience he has working with children and families and meeting their needs in the community. Some of our current collaborative efforts include, but are not limited to, conducting joint behavioral health and DCYF visits to providers outside the New England region, assessing and enhancing behavioral health quality assurance oversight process for certified providers, for nearby trusted programs in our region, exploring additional ways to increase availability of care and improve predictability of funding. We're taking steps to an expanding capacity for the Bureau of Children's Behavioral Health to perform reviews and assist in provider management. We're making better use of existing evidence-based high-intensity programs for the high needs population, including exploration of enhanced Medicaid funding opportunities. We are also exploring a pilot with several youth to provide intensive community-based services such as fast forward and transitional residential enhanced care coordination in the youth's homes. Additionally, we are exploring a pilot to recruit credible messengers and other workers from the local communities to enhance existing services. And we're leveraging existing collaborative groups of key advocacy and provider partners to advise and inform this work in general for longer-term recommendations. As it pertains to SB 417, the department welcomes the concept of increased judicial oversight for children placed out of state. We also agree that these placements should always be limited in time and only as deemed appropriate to meet their needs. The department agrees that the proposed increase of scope and visits with youth in the facilities. To build upon that, we have offered to the OCA that they shadow our staff in such visits to observe the process. This will allow us to build on current practices and brainstorm with our counterparts at the OCA to expand and build a stronger program. As it pertains to the reference of expanded facility, So, as I say, we agree with the general concept of this bill. There's one word in there that we do have some concern with, and we've already addressed this with the OCA as well as Senator Whitley, and that is the word contract. And that is because we do not contract all of these facilities. So as it pertains to the reference of contracted facilities, the department cannot agree with the assertion to contract rather than certify these facilities. And while we recognize the contracting and certification process will be hashed out with House Bill 1573 with Chairman Pearson, we did want to point that out here as well. So that's all that I have for you. If you have any questions, we welcome those at this time.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. Oh, Senator Whitley?
Thank you, Madam Chair, and thank you all for your very collaborative work on this, and I truly appreciate it. You know, when I got the call from the OCA, who also called me from the parking lot, you know, I contacted DHHS, and it has been a collaborative relationship going forward, and I appreciate that. I just wanted to flesh out the contract versus certification issue for the committee. My understanding is that everyone agrees that we want to get the kid in the right placement and to make it be the safest. So I think if my understanding is correct, the issue is essentially what would be fastest and safest.
Correct.
And so I look forward to fleshing that out. But I do want to sort of highlight one of my biggest concerns is that there were requirements, I think, under the certification process or regulations in BCBH, and that they weren't followed, and that's really troubling to me. And so that's part of what we need to flesh out here. Would you agree?
Yes, and we have also offered to the OCA that we work with them as to what they would like to see in contracting. We will happily bolster our certification process to expand and enhance that process to make sure all of those checkboxes are met. As I believe your question was more towards the actual implementation. I know that we are working on that through the House Bill 1573 because that has a fiscal note that would include additional staff members to help with that.
Thank you.
Are there any further questions from the committee? Seeing none, thank you.
Thank you.
Ms. Morris. Ms. Fox and Mr. Fleischer, do you have anything else you'd like to add? Yes.
I never pass up an opportunity to take the mic. So good afternoon. I'm Katya Fox, Director of the Division for Behavioral Health. And I just want to thank the committee and thank the OCA for all the work that is being done. The unprecedented amount of resources that have been put towards the children's system of care has made a huge difference. You're already hearing about all of those programs and all of the efforts that have been attributed to, in some part, to the department, but there really should be that all the credit goes to the support that we've received from the legislature, policymakers, the providers who are standing up those services. So just really want to thank the sponsors for continuing to highlight the needs of children.
Thank you. Are there any further questions or comments? Seeing none, thank you all. The chair will next call Cassie Yackley. Is there a Cassie? Okay, here we go. Okay. Good afternoon.
Press the button.
Yep, press the button.
Good afternoon. My name is Dr. Cassie Ackley. Thank you for having me. So I appreciate this opportunity to speak with you all and want to address the questions that you asked specifically were part of what I wanted to share as I spoke with you all today. This is a fairly nuanced but incredibly important issue, and I'm very glad to see that we're entertaining it here today. Just by reference, I conduct treatment evaluations. I've worked in the field of psychology and multi-generational trauma for a little over 30 years at this time. This is an important issue because when we are providing evaluations, as mentioned earlier in testimony, for children who have a high level of need, this juncture of treatment is forming our conceptualization, our ideas about what this child needs, who they are, and what their challenges are. It's providing critical information to our system about the intensity of services, the appropriate interventions that we need to begin entertaining. And so from a both child perspective and a system perspective, obviously we want to get it right when we think about the level of care and the intensity of a treatment setting that we want a youth to be involved in. And then also most importantly, those evaluations form the foundation of recommendations that should follow the child that we as a system and as providers should be watching to make sure that they're making the progress that we hope they are. And if they aren't, that we're making necessary changes to our intervention approach so that they are successful moving forward. So I can't emphasize how important this issue is to the particular youth that we're talking about today. I want to just make a mention about the difference between assessment and psychological evaluation, which I think is the question that you were asking earlier, and then I will address user qualifications, which I think was the next point that you were making. There are many measures that, psychological measures, screening measures that anybody could use. We could use them even as a caregiver to take a look at our own child's functioning. There are other measures that people who are licensed or a master's level clinician are qualified to administer and utilize in a therapeutic way in the context of therapy. When we are administering a battery of measures that include measures of personality functioning, we are drawing conclusions about the child's overall diagnostic impression and making recommendations. That requires a licensed psychologist to conduct that level of psychological evaluation. So it isn't the administration of a single test, it's when we're pulling these together and we're generating an evaluation that makes the difference. There are a few things that happen, and then I'll open it for questions without talking too long about this issue for you all. So I have seen some very concerning issues as I'm looking at evaluations that I want to say aren't conducted by a licensed psychologist, but also aren't overseen. So we're just looking for oversight and supervision of whoever is working on that particular testing battery for the youth. So some of the concerns that arise are the measures appropriate to the situation in the child we're evaluating? And in one case, it was a measure that's really designed for juvenile justice in this case, and it actually hasn't been normed on this particular population, and actually has some counter results, in particular with female youth. And we could get into nuances, but that is a concerning when we draw a parallel to a child we're working with and we're comparing them to a population that doesn't match. There was concern regarding the inappropriateness of the conclusions drawn, and namely those are diagnostic. Other conclusions could be drawn from the assessment results if they were taken as a total, and some instruments weren't overemphasized. And then the other thing is the recommendations that are provided are inappropriate. I'm just going to give a couple of examples so that I don't talk too much about assessment, and then I'll see where folks are at. So, for example, competence in assessment, you should have measurement theory, psychometrics, components of conducting assessments, integration of data points, interpretation of scores, conceptualization, and communication of results and recommendations. So these are even advanced skills for some psychologists who do not hone their skills over time. With regard to the recommendations and my concern, we've had a lot of folks testify today about the importance of trauma-informed care, and we have done beautiful things in our state to make sure that kids are receiving trauma-informed care. So if we have recommendations that are then going to providers, milieu staff at residential treatment, that we know are counterindicated in the robust research regarding trauma-informed care, it is concerning. I'm going to name just a couple, and then I will pause. So one quote is, "It is helpful, therefore, for the counselor to be confident in their ability to deal with manipulation, and perhaps even somewhat cynical about people's motivations, which is generally not an appropriate approach if we think about dealing with complex trauma or youth with significant histories of neglect, abuse, abandonment, etc. It also may be advantageous for staff to refrain from establishing too predictable of a structure, thus creating a situation that the patient can manipulate." So if you look anywhere, anybody could probably use the Google today and ask about predictability and consistency in a trauma-informed approach, and it'll be very much at the top of the list. Last but not least, confrontation followed by discussion can form the basis of counseling. Once the patient has demonstrated an effort to replace manipulative behavior with more positive methods, staff can become less confrontive and more supportive. And I don't think you have to be a psychologist to have a read on that when we hear about some of the youth that we're thinking about and what we would want people to approach them like. I'm open for questions.
Thank you very much for your testimony. Are there questions from the committee? Senator Chandler.
Thank you, and thank you for explaining some of the requirements of assessment and evaluation, and I appreciate everything you had to say. I do have a question about, first, if you could just let us know what it takes to become a licensed psychologist, what the requirements are, and And also, what does that landscape look like in terms of what we have available here in New Hampshire?
Absolutely. In many school contexts, I'm going to differentiate this for you. Typically, let me start here. Typically, a person who has a doctorate has a previous master's in many cases, but does hold a doctoral degree and then has met the requirements of licensure. There are school-based psychologists, so I don't want folks to get confused, that can be licensed as a school psychologist at the master's level and work in a school setting, which is a little bit different facet. In terms of the workforce, there are approximately 716 licensed psychologists in the state of New Hampshire, and we could probably figure out who had expertise through many of our associations, like the New Hampshire Psychological Association.
Thank you.
You're very welcome.
Senator Whitley has a question.
Thank you, Madam Chair. Thank you, Dr. Yackley, for coming. I know you have a very busy schedule. I just want to drive home the point and see if you would agree that, it's important for these incredibly vulnerable children that we have assessments that are accurate and of high quality. And that's both because we want the recommendations to be appropriate to these children. And also for our perspective as policymakers, we don't want to be, supporting a child in a facility or a setting that's not correct. One, it's not good for the child. Two, if they should be in-state versus out-of-state is something that we should care about. Would you agree with that?
Absolutely, 100%.
Great. Are there any further questions from the committee? Seeing none, thank you very much.
Thank you
for
very
your
much.
testimony, Doctor. The chair will call Lisa Wolford. Good afternoon, Ms. Wolford.
Good afternoon, Madam Chair and the committee. My name is Lisa Wolford. I am a lawyer and the executive director of the Children's Law Center of New Hampshire, which is a legal services nonprofit that provides representation to children in CHINS, delinquency, abuse and neglect, and education cases. I'm testifying today on behalf of the Juvenile Reform Policy Group, or JRPG, which is a coalition of child welfare professionals consisting of my organization, New Hampshire Legal Assistance, Disability Rights Center, New Hampshire, Waypoint, and New Futures. I know from our Children's Law Center cases and from available literature and data that placement in institutions is traumatic for court-involved children who have already been subject to significant childhood trauma. And that statistically, the longer these children remain at these facilities, the worse their life outcomes are. As a matter of practice, institutional placement in our current system is often driven by bed availability, not the welfare of the child, not the family's permanency goals, and not the appropriateness of the placement. This is not conscionable. It is harmful to children. It is a practice which gives preference to the convenience of the system over the child's best interest. We support SB 417 because it moves New Hampshire closer to federal mandates geared at protecting children from lengthy, inappropriate, and harmful placement at institutional facilities. SB 14 does this by making explicit, consistent with best outcomes for children, that placement in a family setting is the preeminent placement goal in child protection cases, that enabling children to attend their own schools is a priority, that assuring that children can maintain important relationships is a paramount concern in these cases. The bill also makes clear that institutional placement is the least favored placement option, that if placed at a facility, a child may only remain there for a limited period of time, subject to meaningful court oversight. That is a real change and a necessary change from current practice. The bill also makes clear, as you've heard and just talked about, that psychological evaluations or oversight in these facilities may be conducted by qualified professionals or overseen by qualified professionals. Further, SB 417 addresses the excuse for institutional placement that is the death knell of children's best interest, the argument that community-based services and placement are just too scarce. This is the provision of SB 417 we believe can be strengthened to bring into line, New Hampshire into line with federal law. We would be grateful for the opportunity to work with the Office of the Child Advocate, with whom we collaborate frequently on crafting language that would accomplish that. Thank you so much.
Thank you very much for your testimony, Ms. Wolford. Are there any questions from the committee? Seeing none, thank you very much. Are there any other members of the public who would like to speak to Senate Bill 417? Okay, seeing none, we'll close the public hearing. Okay, I'm up next.
You're getting your workout in today.
Hey, get
Doing
my
laps.
get my step. Let me know when you're all set. Are you all set, Aaron? Okay. Good afternoon, Mr. Chair.
Good
go
afternoon,
ahead.
Senator. No, you're good.
For the, and my colleagues on Senate Judiciary, for the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon, Senate Bill 362, relative to body-worn cameras. I'd like to start out by saying the body-worn camera statute, which is RSA 105D:2, was created and signed into law. And we knew that as more and more police officers started wearing body-worn cameras, we were going to have to create legislation to deal with body-worn cameras. And so this bill is an attempt to do that. I will tell you now that there is an amendment, but I have not had the opportunity to review it. It's drawn up. So just as soon as I review it, I will bring it to you. You might have people here today talk about the amendment. So I apologize for that. I just did not get a chance to review it. So the statute currently restricts any copy or dissemination of body-worn camera recordings. The statute also appropriately restricts access to those body-worn camera recordings and sets standards for the storage and the retention of body-worn camera recordings. The statute attempted to create a balance between the use of body-worn camera recordings and the privacy rights of those captured on body-worn camera recordings, including defendants, victims, and witnesses. Please understand that it catches everybody. So if there was an issue that happened out here on the street in Concord and you just happened to be walking by, you're caught on camera. The language in the current statute creates barriers for defendants and prosecutors to send the body-worn camera recordings as discovery and use the recordings as exhibits at trial. This bill makes it clear that both the prosecution and defense can utilize the body-worn camera recordings for exhibits. In addition, the bill allows the defense to possess a copy of the body-worn camera recording, but appropriately restricts the defendant's ability to further copy and disseminate that recording. Finally, the bill mandates that any copies made and in the possession of the defendant and prosecution may be destroyed at the end of the case, and sets requirements that the original body-worn camera recordings be maintained by the law enforcement agency. And finally, Senate Bill 362 allows appropriate access during adversarial proceedings while maintaining the privacy safeguards of the original statute. Mr. Chairman, at this point, I'm going to conclude my testimony. I don't believe I could really answer any questions because I'm sure that they are on very particular points of law, and as you all know, I am not an attorney. But we do have folks here who will be able to answer your questions.
Thank you, Senator Carson.
Okay, thank you.
Paul Halverson.
Good afternoon. I'm Paul Halverson. I'm the Merrimack County Attorney. I've been a prosecutor for a little over 20 years, and before being a prosecutor, I was a defense attorney for several years with the Public Defender's Office.
My name is Stephen Andrus. I'm an assistant county attorney in Merrimack County. I have also been a prosecutor over 20 years at this point. As Senator Carson said, the legislature passed 105D2, a fairly comprehensive statute addressing body-worn cameras in 2017. That statute was the result of a collaboration between a number of stakeholders that came together. And when I say it's a comprehensive statute, it really is. It can be broken down essentially into two sections. The first section of the statute talks about the creation of body-worn cameras or the creation of body-worn camera recordings, I should say, by law enforcement officers. The second part of that statute deals with the handling of those recordings once they're made. That section that refers to the handling of the recordings can be further broken down into essentially 4 subsections as I see it. There's a prohibition on copy, altering, or distributing those videos. After that, there are guidelines for access to the body-worn camera recordings, guidelines for law enforcement to store body-worn camera recordings, and requirements related to the destruction or retention of body-worn cameras by law enforcement. Clearly, there were privacy concerns when RSA 105D2 was written. In fact, there's a statement of intent from Representative Cushing, and he indicates that he believes that this is the appropriate balance between public safety and individual liberty. And I think before we really get into body-worn cameras, it's important to realize sort of what's memorialized on a body-worn camera. So the last 2 cases I dealt with involving body-worn cameras, the first was a DWI case where the allegation was the person was driving intoxicated, their car had gone off the road into a utility pole. It was in a small town in New Hampshire. There was a single officer who responded to that wearing a body-worn camera. And there's an hour and a half of body-worn camera recording as a result of that case. It shows initially the police officer arriving and speaking to the fire department because the operator's no longer on scene. So there's discussions with volunteer firefighters. And there's a citizen who comes down and says, hey, I was driving down the road and this is what I saw. I saw 2 people get into a car. This is a description of the car. And that individual who comes and speaks to the police, obviously they ask his name, his date of birth, his address. They get his contact information. That's all captured on the body-worn camera. Then they're trying to figure out who's driving the car. So they run the plate and they find that the registered owner is in his 20s. And the police officer and some of the volunteer firefighters have a discussion about who lives on this road that has kids in their 20s, because maybe this guy is coming to visit somebody, maybe that type of thing. And again, all those discussions are captured on body-worn camera. Eventually, the registered owner returns to the vehicle. He has an individual with him who is a passenger, and there's another individual with them, which is the person who picked them up and gave him a ride back to his house. The police have conversations with each of those 3 individuals separately again. name, date of birth, address, all those discussions, all of that's captured on body-worn camera video. Again, it's about an hour and a half video for that whole incident. The other recent case I had involved the New Hampshire State Police pulling over a car on Route 93 that had 3 individuals in it. Each of those 3 individuals ended up being arrested, but for different reasons. The person in the front seat passenger seat had a warrant, and when the police asked for her name, she lied about her name. Eventually, they were able to figure out her actual identity, and they arrested her on the warrant. So there's body-worn camera of the discussions with her when she is eventually arrested. When they find out who she is, she's upset, she's crying. She indicates that she's fearful of going to jail. She knew she had a warrant, but she indicates that she has a drug problem. She indicates that they, in fact, were going to buy drugs in the vehicle. Talks about the other 2 individuals in the car and indicates that they have drugs on their persons. The police then speak to the driver. Again, this is all on body-worn camera. He indicates that he would consent to a search. They find drugs on his person. He's taken into custody. And then the last person indicates that he's not willing to consent to a search, but the police have probable cause to believe he has drugs on him because of what the front seat passenger said. So they seize him and they bring him back to the state police barracks. When they get back to the state police barracks, they apply for a search warrant to search his person to find drugs. That warrant is granted. And during the search of him, they ask, wait, do you have anything in your pants, that type of thing. He pulls down his pants, he pulls down his underwear. And again, this is all captured on body-worn camera video. He's fully exposed. He's then placed into custody. They find drugs on him. He's placed into custody. There's video of the transport of him from the barracks to the House of Corrections. There's video of him going through the booking process at the House of Corrections. All in all, for those 3 individuals on that one stop, there are 13 hours and 40 minutes of body-worn camera video. There's a number of officers who arrive on scene, so there's various angles sort of the same thing. But all in all, there's almost 14 hours of video at that case. So certainly when we look at body-worn camera, it makes sense that there's privacy interests involved in those recordings. Police are dealing with mental health crises, medical crises, intoxicated people. They're interviewing victims of crimes, witnesses of crimes. Sometimes that occurs in people's homes, where not only is what the person's saying being memorialized, but also the background of the home, what can be seen within the home. One of the difficulties when looking at RSA 105D2 is, as I said earlier, there's that prohibition on copying, altering, and distributing body-worn camera videos. That makes it unclear of whether or not they can be provided as discovery in criminal cases. Certainly there's an argument that instead of providing a physical copy of the video, we could simply provide access to it. We could say to the defense attorneys, you could come in and see it, but you can't own a copy of it. There's practical difficulties with that, and defense attorneys have complained, saying, no, we really should be able to sit down with our client in our office and view it, and we should be able to view it 100 times, and we should be able to pause it, and we should be able to zoom in, and we should be able to look at it as much as we want. And I think that's true. And I think what happens in Senate Bill 362 is it makes it clear that both the prosecution and defense counsel can have a copy of this video. And it restricts that copy, though, for further copying. There's some reasonable accommodations for further copying. It allows the parties to make a copy to give to an expert witness. So, for example, if the defense hires an expert witness and that expert witness wants to view the body-worn camera footage, the defense can make a copy and provide it to that expert witness. That makes sense. Outside of copying within that context, though, any additional copying under this bill, you would need the court's permission. And again, we think that makes sense. If you want to make more copies for other reasons, you should have to ask the court and get the court's permission to do that. And the reason we think that's true is because, again, we want to keep track of where these copies are made and who they're going to. With reference to access, again, that's addressed in 105D2, and it's addressed within this Senate bill. It provides that the body-worn camera recording shall be accessed for case-related purposes only. There should never be a situation where the police are standing around a desk saying, hey, look at this crazy video, what this crazy guy did last night. That shouldn't happen. And it shouldn't happen for defense counsel either. These shouldn't be viewed sort of at the expense of people or with an exploitive nature. They should be viewed with the purpose of facilitating the case. With reference to storage, 105D2 has storage requirements for the body-worn camera video. This bill really doesn't have storage requirements because it's really not practical. The statute itself requires that the body-worn cameras be stored in compliance with the FBI's CJIS policy, which is the Criminal Justice Information Services. That policy requires that they be, securely stored, that anyone that has access has certain training. That's really not practical outside of a law enforcement setting, so there is no storage requirements within the statute. And then the last part that 105D2 addresses is retention. And I think this is where we sort of disagree, and I say we, meaning the prosecution and defense, I think disagrees on this a little bit. But the current Senate Bill 362 requires that at the close of the case, those recordings be destroyed. And they're destroyed by the defense and the prosecution. The original recording would still be maintained by the police department. And that language is clear in Senate Bill 362. So it's not like it's gone forever. The police department has an obligation to retain the original evidence. I'd certainly gotten into discussions with defense counsel in the past about this. They indicate that the close of the case is unclear. I disagree with that. I think that the close of the case is a clear mark. That same language is used in Supreme Court Rule 57 with reference to returning exhibits to their proper owner in a criminal case. It says the close of the case and the expiration of the appeal period. Certainly, if the court can figure out when the close of the case and the expiration of the appeal period is to return exhibits, we can figure out when the close of the case and the expiration of the appeal period is in order to destroy this video. The other thing that I've heard from defense attorneys have told me is that, no, we have an obligation to keep that video forever in our file. That's our obligation. And I really don't agree with that. And I say that because there's a lot of evidence that we encounter in the criminal justice system that we don't give to defense counsel to retain forever. And the first and most obvious thing that pops to my mind is child sexual abuse images. If you're defending a person who's charged with possessing child sexual abuse images, we don't give you those copies of those images. You're free to come to the police department, look at them as much as you want, but we're not going to make a copy and give it to you. And you can certainly say, well, that's different because possession of those in and of itself is a crime. But there's other things that we don't provide copies of during the discovery process. For example, violation of privacy jumps to mind. I had an individual who committed a violation of privacy violation. He hit a camera and recorded a woman undressing. I had the video of this woman undressing that he had surreptitiously made. And certainly in the discovery process, we're not going to provide him with a copy of that video. That would make no sense whatsoever. To the extent the court would, and I told him, look, we're not going to give you a copy. You can come watch it as much as you want, but we're not giving you a copy. To the extent you want to try and get the court to order me to give you a copy, be my guest. But certainly I would assume if the court ordered me to give a copy of that video to the defense, they would have put a protective order in there saying, you can't keep it forever. You can't copy it. You can't distribute it. This language creates a protective order by statute. And I certainly heard people say, well, shouldn't this be on a case-by-case basis? Shouldn't we look at each video on a case-by-case basis? And if a protective order is warranted, absolutely you can apply for one with the court. The difficulty is in the two examples I just gave you. The first one, that hour-and-a-half video, I think there's arguments to be made whether or not a protective order would be warranted in that case. I personally would think that the information that the neighbors are giving to the police, the information that perhaps the volunteer firefighters are giving to the police, the information that the passenger in the vehicle is giving to the police, that should be protected. That shouldn't be given to the defendant with the ability for the defendant to further distribute that information, to post it on social media, that type of thing. And then that second case, first of all, again, there's almost 14 hours of video in that case. And I can tell you realistically, we didn't watch the 14 hours of video in that case before we sent discovery out. We read the police reports, we look at the complaints, but we simply don't have time to watch 14 hours of video for one case. And again, that's one case out of the thousands of cases our office is handling. So at some point, going through every minute of these videos becomes impossible. In that 14 hours of video, it becomes problematic to say who has rights to privacy and against who else. Certainly, I would think that if, for example, the driver of that vehicle wanted the 14 hours of body-worn camera video, that his front seat passenger who's crying and talking about her drug problem, that she has a right to privacy in that, and she has a right to not have that given to someone who has the ability to further distribute it or put it on social media. And certainly the gentleman in the back of the car who's being searched and at one point is half naked on the video, obviously he has a right to privacy, to not have that distributed necessarily to the driver of the vehicle without restriction. So I do think that Senate Bill 362 is a wonderful balance between the defense need to have this so that they can prepare a case in a criminal case, a juvenile case, or an administrative proceeding, as well as individuals' right to privacy, to not have this material further disseminated and distributed. I think it makes sense to destroy it at the end of the case and to have the original maintained by the police department. And again, there's language in here that for post-conviction relief, the defense would have full access to that material. If there was an ineffective assistance of counsel claim or that type of thing, it's not like the material is lost forever. I'm sure if Attorney Halverson has anything he wants to add before we're happy to answer your question.
I do have a few things to add. The legislation that's currently out there, 105D, as it currently exists, is tight and it's workable. It's workable, but for this issue of copying and getting to defense counsel and at the same time protecting privacy rights. I don't think changes to the body of 105D as it currently exists appropriate. This added paragraph is. We did not come up with the language of this paragraph with this bill in isolation. I invited members from the ACLU to my office and I spoke with them about this. I invited members of the senior staff at the public defender's office to the office and we had a discussion about it. There were several other people that were involved in the discussions. The Attorney General's office is aware of what we're doing, as are all of the county attorneys in the state. They have all mentioned at one degree or another that the statute as it currently exists, it's extremely difficult to provide discovery to a defendant who rightfully deserves access to it. And this bill helps clear that up while maintaining those privacy protections. One thing that Attorney Andrus mentioned was privacy interests on body-worn cameras. I think one category of individuals that need to be considered for these protections are victims of domestic violence, where a perpetrator of domestic violence could get these videos, edit these videos, post these videos to the detriment of the victim. And I think the contents of the bill as written helps to protect that. It helps to put a check on the total availability of those body-worn camera videos outside of the criminal justice process. I think, too, that the lack of protections on copying and distributing is chilling to witnesses. I was testifying on another bill at the other body the other week, and one of the questions that I received was just on that, would it chill witnesses from coming forward and talking? And I said, definitely. And one of the comments that I made was, without protections, if I'm a witness and a police officer comes to my house and wants to come in and say, Mr. Halverson, we'd like to come in and talk with you. No, you are not coming into my house with a body-worn camera, because there are no protections that keep the interior of my house from being shown willy-nilly on social media. That would be my concern. And I think that concern should give pause for everybody on why these protections are necessary. We've all seen video clips on news reports of some of the worst days that people have. And frankly, I think we owe it to the public to keep those worst days in a manner that doesn't leave them open for ridicule or embarrassment. I'll gladly answer any questions that you may have, as would Attorney Andrews.
Thank you very much for your testimony this afternoon. Are there questions? Senator Abbas.
Thank you, Madam. Thank you for taking my question. I'll address this to both of you. Is there any reason why we wouldn't include an exception if there was like a civil action pending, like a federal civil rights case, something like that, where perhaps the body-worn camera may be relevant to that case?
I think 105D already addresses pending legal matters on that.
Yeah, there's hints in 105D about it being used in a civil case.
Civil case.
I think you certainly could amend Senate Bill 362 to include civil cases, as long as, again, our big concern is those protections in terms of it being restricted from copying and being deleted at the end.
And
Follow up?
and understanding we're giving our answers without having seen the proposed amendment.
Yeah. I guess in my experience, sometimes the civil cases will follow after a criminal case. And it's quite often that there may be a legitimate criminal charge, a legitimate arrest, but also a federal civil rights violation in that process.
Yeah.
So if the body-worn camera footage is going to be destroyed after the criminal case is done, and there's no appeals for that, I guess if the civil case hasn't been filed yet,
Yeah.
how would someone preserve that?
So 106D2 talks about preserving the footage when there's pending civil litigation. The amended or Senate Bill 362 talks about the law enforcement agency having an obligation to maintain the footage until the end of the criminal case in the appeals period. So there is, it's interesting that normally when we talk about an obligation to maintain things, when we talk about town records and that type of thing, it's a minimum date. RSA 105D2 sets maximum dates, that it can be held no longer than a certain amount of time unless there's pending litigation. So if there is pending litigation under 105D2 and this Senate Bill 362, it would be maintained.
Thank you.
Are there any further questions? Seeing none, gentlemen, thank you very much for your
Thank you.
testimony.
Thank you.
The chair will call Jessica King. Good afternoon, Ms. King.
Good afternoon, Madam Chair and members of the committee. My name is Jessica King. I'm a Senior Assistant Attorney General at the Department of Justice. I'm here at the direction of Attorney General Famella to testify in support of SB 362. I expect my testimony to be quite limited, but the office would like to testify in support of this bill, where it clarifies when body-worn camera footage can be used in litigation. The Attorney General's office believes that the current statutory scheme does allow for the use of body-worn cameras in proceedings, but we always welcome clarification to the statute. And there has been some litigation around these issues, so we do welcome clarification where it is being offered. The office offers one potential amendment, and Senator Abbas, you have touched upon it. Currently, the bill explicitly states the use is permitted in criminal, juvenile, and administrative proceedings. We offer that the bill should also be allowed for use in civil litigation. It's important to both the interests of the public and the interests of law enforcement. In the interests of the public, we can hold law enforcement officers accountable for violations of civil rights in civil litigation. It's important to the interests of law enforcement officers to provide vindication in those instances where a violation has not occurred. The statute as it exists right now, 105D, currently allows for a law enforcement agency to retain body-worn camera footage for civil litigation. And so if this amendment, or if this bill is passed, we would like there to be a chance for use in civil litigation where it's already being retained for civil litigation. The protections that exist in the statute and this amendment, we believe they do protect those privacy rights that Attorney Andres and Al Halverson were talking about. And so we testify in support of this bill with the request that it be amended to include civil litigation. And I'm happy to take any questions.
Thank you very much for your testimony, Ms. King. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Gary Apfel. Good afternoon, Mr. Apfel.
Good afternoon, Madam Chair and honorable members of the committee. My name is Gary Apfel. I'm a criminal defense lawyer practicing in Lebanon, New Hampshire. I first began practicing after a legal clerkship in federal court at the New Hampshire Public Defender's Office in Orford in 1989, where I worked as both a trial lawyer and as appellate lawyer until 2003. Since that time, I have been in private practice in the firm where I am now at Simpson & Mulligan in Lebanon. I am a member of the New Hampshire Association of Criminal Defense Lawyers and I appear here as one of the members of the board of directors. Before I commence my testimony, I wanted to let you know that I did make a written submission this morning. I actually did it twice because the first time I forgot to attach exhibits, so I apologize for that. I also have, Madam Chair, if it's okay, just not the whole proposal, but if I could circulate to members of the committee language that we're proposing for the statute.
Please give it to our intern and we will get a copy of it.
It's just because I'll be referring to some of these proposals, I wanted to make sure that you had them available. I'd like to start by saying that although NHCDL is opposed to Senate Bill 362 in its current form, I would like to reinforce what Senator Carson testified to earlier this afternoon, which is that I understand this to be, as Senator Carson indicated, a work in progress where members of the legislature, the prosecutorial branch of government, and the defense bar is working to resolve issues that remain with body-worn camera legislation in RSA 105B, and specifically Section 2. So I also understand that there's different legislation pending currently in front of the House of Representatives. And I heard this afternoon that there's a proposed amendment here. And I cannot imagine that this will ultimately end up in conference with all sorts of discussions about what should be taking place. So that I hope that you will receive my comments in the spirit in which they're intended, of this being an ongoing discussion between all the relevant members of the community about where we should go with respect to these issues. Senate Bill 362, as currently written, if enacted, it would presumptively prohibit citizens from publicizing police misconduct to the general public, in presenting evidence in a civil suit, and in producing evidence in support of police reform. A presumptive blanket prohibition on dissemination of body-worn camera would therefore be unconstitutional. It would violate the First Amendment to the United States Constitution, as well as Part 1, Article 8 of our New Hampshire Constitution, which guarantees freedom of speech. It also would violate the accountability of public officials provisions of Part 1, Article 8. A presumptive blanket prohibition of dissemination of body-worn camera is also contrary to New Hampshire's public policy regarding open government. It's contrary to the spirit of controlling New Hampshire Supreme Court case law. It's contrary to the spirit of RSA 91A, with its provisions with respect to right to know and with requirements for open meetings. I therefore urge to you most strongly that the presumption should be with open access and a right to seek protective order, rather than the way that the language in the statute reads now. With respect to some specific issues then, I would also address the following. First, with respect to retention of body-worn camera. What the bill as it currently reads, it requires that defendants and counsel experts destroy evidence at the close of the case. And that is any appeal or currently pending request for post-conviction relief. I understand how that makes sense to the mind of a prosecutor drafting a statute. But if you're actually out there working as a criminal defense lawyer, or you're working as a civil rights attorney, it's not the way how it always practically works out. And there are sometimes gaps, sometimes they're short, and sometimes they're long in between when the case has closed under the definition that's provided here and when someone seeks post-conviction relief. There are times when a defendant does not know that he or she has not been provided adequate assistance of counsel. There are times when there's new evidence that's uncovered, which may or may not have been in a prosecutor's file or in the file of a DCF caseworker or someplace else that doesn't come to light until after the case has closed. And as this is provided now, the defendant and his or her lawyer is obligated to destroy evidence that might otherwise be exculpatory and certainly relevant. And it's a situation where the police are not going to be preserving that material anymore. And that's, oh, we're sorry, we just don't have it anymore. It's too bad. It's one thing to say that you're not going to require the police to keep things over a certain period of time because it's too much work or it's too much expense. And I'm sympathetic to that. And we all need to be sympathetic to that. But it's different to say that a defense lawyer cannot keep material for as long or as he or she deems appropriate if that lawyer is prepared to do that. And I want to give you an example from my own practice experience. So as I told you, I was a public defender for 14 years. I represented someone up in Littleton in the first year or two of my practice. And we entered into an agreement with the police prosecutor. There would be a very lengthy loss of license that was going to go over a decade. But a couple years were going to be shaved off by, I don't remember exactly how it was. It was probably removing some administrative license suspension or something to that effect. And the police prosecutor didn't do that. I don't think it was in bad faith. He just failed to do it. The last month or so that I was a public defender before I went into private practice, my client called me and said, I've got this problem here. What am I to do? And because I had kept his file, I had written evidence of that. And we were able to correct that situation. that may not be the standard of care for lawyers about how long they keep files, and quite frankly, that issue is far from clear. In civil cases, there are also times various provisions and fee agreements and retention contracts. In the criminal arena, it's less clear. Lawyers are doing certain things about what they put in their contracts. But it is my practice, because I have the ability to do that, to retain files should clients need access to that information. And to say that I'm not allowed to do that, and I might not be allowed to provide assistance to my clients, as this statute will require, that's untenable. If I'm prepared to take that obligation upon myself. I also want to draw your attention to, and this it's not addressed by SB 362 with the testimony that's appeared yet, but it is addressed with respect to the language that I'm proposing to you. And that is amendment to subsection 7A. So the practice now, amongst some, but not all police departments, is to activate body-worn camera at a certain stage, a call for service, either the lights come on or they're called to the scene or whatever the case happens to be. And then if officers don't want certain things to be recorded because they're talking with each other, they turn off the audio, and at some point later on, they turn the audio back on. And the statute at present authorizes the officers to do that. We're asking that that not be allowed anymore. And here's the reason why. And I think this is a reflection also of, later on, my addressing other issues that have been raised by Mr. Anders and by Mr. Halverson. That I know from cases where the officers don't turn off the video, and we're talking about the run-of-the-mill cases, the vast majority of cases, not the exceptional cases, the one that include sensational talk in front of a legislative hearing. But the average run-of-the-mill DWI case, for example, that in Lebanon, I don't think I have a DWI case where there are less than 3 officers who ever report to and oftentimes there are more than that. And I've had cases where a relatively junior officer will conduct field sobriety testing and is not sure whether to make an arrest or not, talks to the sergeant or the corporal on scene, who tells him, go ahead and arrest him. And that's exculpatory evidence, because it means that the officer had concerns about whether or not there was probable cause to make an arrest. And if you don't have the audio of that, it disappears. The other problem I have, and this happens far too frequently, is that the officers forget to turn the audio back on. So that's especially the case when they're talking, for example, to EMTs, and oftentimes discussing about whether there's adequate evidence of intoxication or not to make an arrest. Sometimes it happens also, they forget to turn it on. And I had a case like this a year or so ago. They forgot to turn it back on with respect to talk to my clients. There's no reason why the default shouldn't be that once the camera's on, it's on until the case is done. And if the department feels for some case that certain conversations shouldn't be there, then they can go to the court and seek a protective order saying, we want to block out the audio for this. I watch hundreds of videos every year. And I was thinking when Mr. Anderson was talking about what that means, because those 14 hours that he doesn't want to watch, I got to watch it all. And quite frankly, I'm shocked that any prosecutor would not watch all the video in any case. I mean, that's a different issue, but it seems to me that when you need to know if there's exculpatory evidence or not out there, that you need to be familiar with it and know what the case is about. In any case, that's what my clients expect of me, and I got to watch it all. And so I understand how much work that is. But, you know, and hundreds of videos a year. So that's thousands of hours of video that I've watched. I can think of one case where one police department felt it was appropriate, and it was. There was a witness who her talk was uncovered, and they did the right thing. They had little blackouts on it so that that wasn't visible. And I'm not sure what's happening in Merrimack County because I don't really practice here very often. I come down very occasionally. But I'll tell you in Grafton County and in Sullivan County, where I spend most of my time, and from communicating with other lawyers around the state, the problem that's been presented here about what to do is not perceived by most of us in the criminal justice community as being a problem about what to do from day to day. We're not having hearings about whether or not we can show body-worn camera clips in court. Even the prosecution who wants to show things isn't asking first for permission for court in order to be able to do that. We're not having issues about whether or not stuff can be disseminated to the defense bar or not. It just is. Sometimes, you know, in more in the context of things, for example, video in front of child advocacy centers of children, we agree to protective orders. But for the run-of-the-mill stuff, it hasn't been an issue for us. So it's not stopping what we're doing from day to day. Now, maybe it is a problem here in Merrimack County. Maybe it's going to start to grow to be a problem somewhere else. But I mean, I heard Mr. Halverson talk about talking with all the county attorneys throughout the state. I mean, Mark Hathaway in Sullivan County, Marcy Hornick and her assistants in Grafton County are not saying to me, we can't give you this stuff. They just give it to us right away. That's the first aspect. The other aspect of it is to say that, yes, there are exceptions, but the average defendant is not the slightest bit interested in having that video circulated around to other people because they're embarrassed that they're defendants and they're embarrassed that they've been arrested. So it's really, it doesn't mean that we don't need to think about things along the fringe. We do. And it's on both sides. It's one with legitimate privacy interests of defendants, of victims, of witnesses. And on the other side, it's making sure that police officers are held accountable for what they do. Because there are a lot of wonderful officers out there, but there are some officers who are not doing what they need to do. Sometimes it rises to the level of a civil rights violation. But you know, the more common situation where it's not clear to me at all that a judge would lift a protective order is where an officer is just rude to one of my clients. That's not okay, but it's not the sort of thing that's going to result in any criminal charges. It's not going to result in a difference in how the criminal case is resolved for my clients. But there are some defendants who want to be able to say, this is how this officer behaves. This is what his supervisors are allowing him to do. And we need some change in department culture here. Because it's absolutely the case that different departments have different cultures about what they tolerate from their officers. Without saying anything about any particular departments, but you know, I'll just say to the positive side. In a town like Hanover, where there are a lot of highly educated and wealthy people, what's expected from police officers about how they're going to interact with citizens, whether they're defendants or not, is really different from some mill towns. And some people in those mill towns say, I'm entitled to the same thing, and I want to show the video in order to do that. So they should be allowed to do that and not have to convince a judge that it's okay to do that, for whatever the personal motivations would be, because that's what our constitutions say that we're entitled to have. It's really troubling also to hear Mr. Enders say they want to know a list of every single person who has the video, every copy made, and who it's sent to. Imagine if we said the same thing because I wrote a political document challenging how the governor was enacting certain policies. And the prosecutor said, I want to know every person, I want to know how many copies you made of that document, and I want to know who you sent it to, so I can keep a list. That is so antithetical to our basic form of government. And yet that's the model that's being proposed by the statute as it now is. I say to you that we can craft a system where it's easy enough to recognize when there are legitimate privacy concerns there and go into court and ask for a protective order in those circumstances. And the way that we propose the statute says that. The last thing, but not the last, but pretty close, is a proposed modification to subsection 18. And my concern, and the association's concern at this point about the way the statute is currently written, is that it allows effectively the exclusion of exculpatory evidence or law enforcement misconduct when there's body-worn camera that's taken illegally, but it still has something that's exculpatory. It says that it can't be used for any purpose. And we're proposing language that modifies it, says if the officer shouldn't have recorded it but did, and it's helpful to the defense, or it can be used for disciplining the officer for other circumstances such as that, that should be usable in our courts. So those are really sort of the main things that I would touch on. And I know that you have a lot of other testimony to take today, so I will end my testimony and welcome any questions that you might have.
Thank you very much for your testimony. Are there questions from the committee? Seeing none, thank you very much.
Thank you very much. And as I said, we really do look forward to working with everyone in this matter further as we sort through this.
Thank you. The chair will call Penny Dean.
Thank you, Madam Chair and members of the committee. My name is Penny Dean, and I'm a criminal defense attorney, among other types of work that I do. And if I were to have named this bill what I consider accurately for what it contains, I would say this bill is for the protection of bad cops and liars. And if you were to put it on a scale, put the provisions of this bill on a scale, and say, you know, do you want this? And my dad would say, if you're giving that out on shares, you can keep mine. It's just really, really, really one-sided, as is the current law. But the current law, we've had some judges that do the right thing, and they've said to the prosecution, you either give them the audios or you dismiss the case because it's exculpatory and it's Brady evidence. But I want you to think about the language you've heard and the things suggested up here. Prosecution said, well, we want to protect the victims of domestic violence. Those are complaining witnesses. We have trials and hearings to determine guilt and innocence. So when a person calls in and makes an allegation, they are not a victim. They're a complaining witness, and that term really, really matters. And to suggest that we wouldn't have access to those videos and audios is untenable. Once a court or a jury decides if and when they decide that person is guilty, then that person is a victim. Until then, they are a complaining witness. And I can't tell you how many times, then I hate to say in my practice, it's been more women than men complain against my clients who are men, have made allegations and accusations that could not be supported by any reasonable person in the facts. And thank goodness judges saw sense and dismissed, or the complaining witness dismissed, seeing they were going to have to take the stand. But forbidding us from having this audio for privacy interest makes no sense. But here's what's furthermore a problem. In today's society, if any one of us walking down the street, even in Concord, New Hampshire, think that we're not being videoed and audioed by a dozen different buildings with security systems, I think you're being silly, because it's happening. And so you have to look at that and you have to say, what the heck happens here? And I think this bill inappropriately restricts private citizens because we are paying with our tax dollars to have these things done. We want accountability. And I will direct you briefly to a case I handled probably 15 years ago in Milford. It was a Stuart Urey case, and I've written several stories about it. And what happened was the complaining witness in that case, a convicted felon drug dealer, I might add, was best friends with one of the police officers at the department. And in that particular case, the police officers were calling each other back and forth on their cell phones so they wouldn't be heard on the radio. It's today's equivalent of turning on and off body cameras. Body cameras need to be kept on, and courts are capable of making appropriate decisions when those body cameras or when things need to be blurred out. But I think the prosecution's claim and county attorney's claim that we're concerned about these people's privacy, that just rings hollow in my mind. I have seen way serves the police's need and those trying to prosecute our clients. And what's more important to me is there are people that maybe don't share the same values as everyone else and they're persecuted. I have a client and She's in a small town, and her sexual preference was being mocked and she was treated differently. And it just happened to come on, there was a bunch of police videos of a particular event. And so I hear these police officers clearly referring to my client and clearly mocking her because of her sexual preference. I wrote a letter to the chief of police and I said, I'm really distressed because of this. The chief of police wrote me a letter back and said no such thing ever happened with my officers. And I said, did you view and listen to these videotapes at point X, and point X, and hear these quotes and tell me that that's not that? That was several years ago, and I haven't heard a letter back from that chief yet. But before even looking at it, he denied it and said, unequivocally, I have a letter in writing, said these things didn't happen. My officers wouldn't say these things. They absolutely did. And so I look at this and I say, we need a bill. We need to change what's out there. But I reiterate my concern, and I've expressed this before the committee before. I have been told there's at least one amendment pending. And it's very frustrating in order for members of the public to come in and want to offer some constructive criticism or some ideas when we don't know how we would feel about an amendment that we haven't seen. But you have to ask yourself if we as taxpayers want the police to be the total gatekeepers of this information. And I can tell you that as a lawyer, if I told my malpractice policy, other than child porn and things like that, that I can't possess, that I'm going to destroy or give away evidence before statute of limitations passed where I can be charged with malpractice, I got to tell you, I don't know if they'd issue me another policy or if they'd say, what are we going to do about this? Because we're relying on them, meaning the police, to keep the keys to our clients' freedom in some cases. I've been practicing over 25 years, and I can tell you, minus human error or software problem, I have copies of every file of every case I've ever done. I have complete copies of everything, even though I return the files to the client. So I have those copies, and many, many, many of them have been needed decades later. And so I respectfully say to you, this case holds all the keys in prosecutors' hands. And as a practical matter, here's what we have been told in many instances. Oh, our agreement with the vendor says you can only come here and look at them. Our agreement with the vendor, that was a self-serving agreement. Our agreement with the vendor of this solves this problem. And so when you look at that, you say, doing something is better, but this is certainly not good. And originally what the prosecution was trying to make us do was come in to the prosecution's office at their convenience, where we would look at videos where they could track how many times we looked at a particular section or whatever. That's not good for defense. We need to be able to look at them in our office, and we need to keep them forever. And we need to be able to, if our client chooses to release these to the public and say, look at this. And to say that they're worried about the privacy of neighbors or victims, or neighbors or witnesses rather, those people are going to have to come into court and sit on the stand and put their hand on the good book if they're witnesses and say, this is what I saw or this is what I heard. And if they're not willing to do this, Sixth Amendment confrontation says we've got a lot of problems. So I respectfully suggest that this bill as is needs to be killed and need a major reworking of it. Because as a practical matter, this simply is not fair. It's simply too one-sided. And I'm happy to answer practical questions.
Thank you very much for your testimony. Are there any questions from the committee? Oh, seeing none, thank you. Okay, are there any other members of the public that would like to speak to Senate Bill 362? Okay. Seeing none, we'll close the public hearing. The committee will be in recess for 10 minutes. I'm going to go ahead and open the hearing on Senate Bill 360 and recognize the prime sponsor, Senator Altshuler. Senator, welcome to the committee this afternoon. I would like to make an announcement to the audience. We have a lot of people who would like to speak with us today. So I'm going to give a lot of latitude to the prime sponsor because she is here to introduce her bill and give us reasons why she believes the bill is important. But after she speaks, I'm going to ask anyone else who would like to speak that if you have written testimony, please do not read the written testimony. We are not going to be executing this bill today, so we will have plenty of time to read. If you do have testimony you would like to submit, please submit it to our committee intern, or you can send it to the committee aide, whose name is Matthew Shelzy. This is not Matthew, this is Aaron. He's not normally assigned to us, but Judiciary has been here since 9 o'clock this morning, and that's quite a bit for one person to do. But I'm also going to ask you to please, with your testimony, everyone will get 3 minutes. It is important that everyone who has come here today has the opportunity to speak to us. I think that's extremely important. So with that being said, I'm going to recognize Senator Altshuler and ask her to introduce her bill.
Thank you, Madam Chair. Like many people who are here today, I still get a little nervous doing this, so I'm going to read from my testimony and refer to my notes, as I know many others will need to. I would thank you thank you, Chairwoman Carson and honorable members of the committee. My name, for the record, is Deborah Altshuler. I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Hampton Falls, Northampton, Stratham, and Rye. This proposed bill, Senate Bill 360, is first and foremost a public safety bill and an important step in suicide prevention in New Hampshire. The intention and purpose of this bill is to address the gap in current New Hampshire statute that leaves families and law enforcement powerless when they see with their own eyes and hear with their own ears a loved one in crisis exhibiting suicidal ideation or threats to harm other people. In New Hampshire, suicide is the second leading cause of unintentional injury for people in the age brackets of 10 to 14 and 24 to 34. Behind my testimony is chart, and this chart is actually taken from the information that has been provided to you, the packet of information in the back. In 2020, approximately 89% of all deaths in New Hampshire involving a firearm were suicide deaths. Between 2015 and 2020, 55% of male suicides in New Hampshire involved a firearm, and 28% of female suicide deaths in New Hampshire involved a firearm. Between 2015 and 2020, 71% of male suicide deaths of U.S. Armed Forces members in New Hampshire involved a firearm. Self-reported suicidal ideation among high school youth in New Hampshire increased between 2011 and 2019. This comes from our New Hampshire Suicide Prevention Annual Report. 50% of New Hampshire residents who die by suicide, 50% use a firearm. When someone uses a firearm to attempt suicide, that attempt is lethal 90% of the time. It is the most lethal means available. I pointed out that suicide is the second leading cause of death for New Hampshire residents between the ages of 10 to 14 and 25 to 34, as evidenced on the chart. But what's ahead of it? Overdoses.
So let's look at for a moment at another public health crisis we face here in New Hampshire, opioid overdoses. In 2021, there were 382 opioid overdose deaths in New Hampshire, which accounted for 87% of all drug overdose deaths in the state. In 2021, there were 382 opioid overdose deaths in New Hampshire. And what have we done? We formed task forces. We trained anybody willing to do a training on administering naloxone to someone experiencing an overdose. I keep 2 doses in my car. Why? Because I've been trained on its use, and a former coworker of mine who, like me, never thought she'd be in the position to use her Narcan, ended up saving someone's life at a Cumberland Farms one morning when she stopped for coffee. Equipping the community with tools to help people in crisis is part of our public health harm reduction strategy. Just yesterday, the Department of Health and Human Services announced a statewide availability of the new overdose reversal medication, nalmefene. Like naloxone, nalmefene is an opioid reversal medication that can be used to prevent opioid overdose deaths and reverse the effects of an overdose. In their statement, New Hampshire DHHS said, yet again, New Hampshire is increasing access to every resource possible in our continued work to combat substance use disorder and save lives. This is from Governor Sununu. With this tool, we increase opportunity to partner Granite Staters in need with the variety of recovery resources available and put them on a path to a brighter future. Nalmefene is emerging as one more tool at our disposal as we work to prevent opioid deaths. Is this measure that happened yesterday going to stop all people from overdosing? No, it won't. So why would we even bother doing this? Because this is making this important public health tool available to citizens who are in contact with people in crisis. So yes, it will absolutely have impact. What about cancer? That's a deadly disease. Do we just throw up our hands and say, oh, this is terrible, but you know what? Cancer's gonna happen, there's nothing we can do. Do we say, oh my, so many people are overdosing. What a shame. I feel so bad for them and their families. No, we don't do that. We take action. We take lots of actions. We put awareness programs in place to teach people about the hazards of exposure to certain chemicals like cigarettes and poisons that cause cancer. We pass legislation requiring polluters to clean up their messes. We put warning labels on dangerous materials. We create drug abuse prevention programs, campaigns, and public outreach to alert people to the dangers of addiction. We put support programs in place, like safe stations, for those who are affected to help them recover and heal. We act, we recognize it's not just one thing we do, but a comprehensive series of things. We create laws to restrict access to dangers when necessary. Does one measure eliminate 100% of the risk? No, not usually. Does it make an impact? Absolutely yes. A common objection to any specific measure of gun violence prevention is to apply it to a particular event and then dismiss any efficacy of the action by asserting, well, I wouldn't have prevented this particular tragedy. And that is an uninformed and lazy approach to public policy. But people of good faith who genuinely care about their family members, their communities, and the health of their state, they know this. Otherwise, why bother with any of this? Why not just surrender to drunk drivers on the roads? Because you can't stop someone from drinking themselves into a stupor and getting behind the wheel of a car, right? Realistically, no, can't do that. But we can, and we do, train bartenders,
in not overserving. We penalize bars and restaurants who do that when someone leaves their establishment and kills someone else on the road. We take away people's driver's licenses. We create media campaigns and school programs to teach our communities and children about responsible drinking. And we have limits on certain kinds of advertising. Would any one singular part of that comprehensive strategy work on its own to curb drunk driving? What's funny is that we don't even ask that question anymore because time and practice have changed our culture. Public health harm reduction and prevention works. A collaboration of prevention, training, outreach, and recognizing that people in crisis deserve protection from accessing the most lethal means available will help turn that around. That is our job here today, to do the most good for the most people. Senate Bill 360 is designed to put a speed bump in front of a person who has access to the most lethal means available to do themselves or others harm. It creates a tool for the people closest to someone suffering to prevent a tragedy and get them help. It temporarily relieves a person who is demonstrating their danger to themselves or others around them with their access to firearms, temporarily standing between them and the most lethal means of doing harm to themselves or others around them. Currently, in New Hampshire, there are 3 other statutes right here that temporarily restrict people of their rights to have access to firearms. 2 of them are criminal orders. There is the domestic violence restraining order contained in Chapter 173B for use in cases where crimes of abuse have been committed that pose credible threats to the petitioner's safety. They're available to spouses, ex-spouses, housemates, former housemates, parents, aunts, uncles, and anyone else who may be living with an abuser and is suffering abuse. The other avenue that leads someone to being temporarily relieved of their firearms is the stalking statute contained in Chapter 633(3), which applies to someone purposely, knowingly, or recklessly engaging in stalking another person and making them fear for their safety. Both of these are criminal statutes, as they should be. The third statute that temporarily relieves a person of their access to firearms is in Chapter 153C, the Title 10 Public Health Chapter, Involuntary Emergency Admissions, a civil order. This is a drastic measure and a very high threshold to meet. It involves being transported in handcuffs to a medical facility for evaluation after a family member files what is called a complaint and prayer for compulsory mental examination. Then, if that person is in need of psychiatric help, they wait in the emergency room for that, which leaves a gap. The gap between when someone has committed a crime and has been deemed too dangerous to have access to firearms while that crime is being adjudicated, and the high bar of involuntary commitment to a state hospital. What's available for those people in crisis in the gap? Nothing. Families who see their loved ones' behaviors escalate in dangerous directions have only one option available to them: a well check by their local law enforcement. Contained in my testimony is the story of the suicide of one of my constituents and the testimony of his mother. And I strongly, strongly urge you to read through that and get a feel for the depths of despair that this family felt in trying so desperately to get intervention and help. A more recent incident that was very close to home happened in Lewiston, Maine. The shooter, who murdered 18 people and held an entire town hostage for 2 days while he was on the run from law enforcement before shooting himself, was known to have exhibited warning signs of being a danger to himself and others around him. His declining mental health was known to police, Army officials, and family members, according to numerous interviews. 6 months before the mass killing, the gunman's son told law enforcement his father was exhibiting extreme paranoia and erratic behavior. And it was a teenage son, by the way, 15-year-old. 4 months before his killing spree, he was hospitalized for incidents related to his Army Reserve Unit training. 1 month before the impending slaughter, his family had once again reached out to law enforcement with concerns. Were this sequence of events to happen a few miles south in our state, there are absolutely no tools available to family or law enforcement to intervene. We don't have to live like this. 21 other states in our nation have already come to that conclusion and have some kind of law similar to Senate Bill 360 in place to save lives. Senate Bill 360 creates a tool that fills this gap and provides access to a civil order for families and law enforcement to help those people in crisis. Family and household members are on the front lines of this crisis. They see when their loved ones are exhibiting warning signs and pose a significant risk of harm to themselves or others around them. They see, hear, and feel the danger signals, and they feel helpless. They've told us they feel helpless to protect their loved one from lethal harm to themselves or others. I really appreciate the good faith approach that this committee is taking to tackle a significant public health issue that we absolutely cannot turn our back on. We must take action. We must have the courage to face the reality of our current situation in front of us. Listen to the mental health professionals and our constituents who have lost so much. Please give Senate Bill 360 an ought-to-pass recommendation. Thank you for your time and attention, and I'm thrilled to answer questions.
Okay, thank you very much, Senator, for your testimony. Are there questions from the committee? Senator Gannon and then Senator Abbas.
Thank you, Senator, for taking my questions. So you're aware this bill has far-reaching effects. Your testimony was broad on a lot of issues, so I'm just going to be really narrowly tailored and want to ask you. So you were mentioned this is a major public safety issue, but are you aware that we're the second fewest for assaults for states, third safest overall? Personal safety is fourth. Our rate of homicides, because you talked about suicides, our homicide, including suicide rate, is the lowest in the nation.
With all due respect,
Okay.
Senator, our suicide rate is not the lowest in the nation. We're actually in the top 10.
This was from helpdata.org. My assistant just got it about an hour ago. So I'll furnish you with the statistics, but it has us second lowest at 1.06 per 100,000, Maine being second safest. So
For suicide?
for homicides, including suicide, homicide, and they had the stat together. I didn't have a breakdown. So I'm just
Okay,
saying,
well,
we're a very safe state.
I will absolutely furnish you with correct data that demonstrates
Thank
that
you.
our suicide rate is in the top 10.
Can I go just a little more detailed follow-up? Thank you, Madam Chair.
Sure.
So this is a Second Amendment right, a very important constitutional right to have a gun. You're going to seize the person's gun, correct?
I'm sorry, the question is,
Section
would this
360, the Second Amendment right is
provides a civil order to relieve someone
So
of their
you-
firearms when they're a danger to themselves or others around them?
And so when they take that weapon, where this is such a fundamental right, the standard you have as preponderance of evidence would be just a mere 51%. So for me, when you're taking one of my most fundamental rights away, shouldn't it, even at that stage, it be a clear and convincing standard of evidence to seize someone's gun?
Thank you for noticing that. And I would draw your attention to, I highlighted this because I knew you were going to ask it.
No, so follow up. I
The
realize it.
Well, may I answer the question at hand?
Sure.
Okay, so this civil order has a preponderance of the evidence, so more likely than not to get the order. And then at the hearing, a clear and convincing evidence must be shown to keep it.
Follow up?
Yes.
So then I'm concerned with the time frame that you're going to keep the weapon. It's 7 days to have a hearing. There's appeals process. This could be 7 days. They have a 15-day time, even if you're proven that you're not a danger at all. To give your gun back is another 15 days. I have problems that if the weapon is damaged, they will not compensate you. This just seems to be, and then so they seize if it was you had a permit to carry, they take your permit. I would think if you're found you're not guilty of this offense, that you're not a danger, you should just get your gun right back. You shouldn't have to reprove that you're competent to have a license. You're saying here.
Where are you reading that? Could
On
you?
page 9.
Could you point me to
sure.
what you're
Sure.
looking at?
Yeah, just give me a second.
Okay, thank you.
Let's see, page 9,
Yeah.
line 26. The respondent shall have the burden of proving by clear and convincing evidence that the respondent no longer poses a significant risk of bodily injury to himself or others. There's a couple of places in there where they're saying the burden shifts to you. I would think the burden would still be at the state to show him a danger. No?
I'm sorry, could you ask your question again? Because I don't think I would like to answer what I believe I hear your question to be. If you are looking at page 9, it's a continuation of section 159F9, return and disposal of firearms. And this is upon the completion, if an extreme risk protection order is vacated or ends without extension. So that means it's already been in place. This is after it's been assigned.
Yeah.
So,
Anyways, I'm fine. Thank you, Senator.
okay.
Hey, Senator Abbas has a question.
Thank you, Madam Chair. It says it several times throughout the bill, but one example, if it's on page 3, lines 31 and 32. It says the court shall consider any relevant, reliable, and material evidence. What's the rationale for not following the traditional rules of evidence, or perhaps outlining some evidentiary exceptions rather than having this like that kind of? It seems like it's a very broad approach, because I look at relevant and material. I mean, any evidence that's material is also relevant. Relevance a little more broader than material. So, and then reliability, generally the court kind of assesses that with any piece of evidence, but there's no other evidentiary rulings or evidentiary guidelines in the hearing.
So if I understand the series of questions, that I would direct you to line 18, which starts off the section that you are referring to on line 31. This is the preponderance of evidence for temporary relief. This is the same standard that we use to issue a domestic violence restraining order. It's a preponderance of the evidence. So, I mean, it is not out of line with what we do right now.
I'll clarify the question.
It's the temporary, it says right there, temporary orders. So, this is the temporary part.
Now, I understand that
Yeah,
there's a preponderance of the evidence at the temporary when you have the ex parte hearing. Then if you have a two-party hearing, the standards elevate to clear and convincing evidence. I understand that part.
yes.
But at both of those hearings, the rules of evidence that would apply are the same. And it says any relevant, reliable, and material evidence, that's what the court's allowed to consider, rather than the traditional rules of evidence. I'm just asking, what's the rationale for not following the traditional rules of evidence, or perhaps just having some evidentiary exceptions rather than have the broad language that's stated herein?
So when this was written, the court shall consider any relevant, reliable, and material evidence that applies to preponderance. So that is what the courts are asking for. And this is coming from the petitioner. So this is an ex parte temporary seeking of relief. This is not a case yet.
So if I can just direct your attention to page 4, if you look at
Yes.
lines 32 to 36.
Yes.
That's, my understanding is that when there's the two-party hearing, and that's where there's the clear and convincing evidence standard.
Correct.
I'm just asking why have the relaxed evidentiary rules? And that's where I'm reading it would apply in both hearings.
Well, that's incorrect, because the first hearing, like when it's a temporary seeking of relief, and so we don't have this. So we want to have a preponderance of the evidence, which would be showing that someone has demonstrated to someone very close to them that they are actually a danger to themselves and possibly to others around them. If we're going to take this, and because we take our Second Amendment rights so very seriously, we raise the level of evidence to clear and convincing when we get to that two-party hearing. So that's, I mean, I don't know how much, I think we could probably go around and around, but the application is preponderance. The order, should the court decide that this is necessary beyond that temporary order, is a clear and convincing standard.
It's the fault. And I understand that's the burden of proof in a party, with a petitioner or respondent, they're offering evidence to either satisfy or perhaps defend against a party meeting the burden of proof, whether it's clear and convincing or preponderance. But the rules of evidence that would apply and how a party does that in these hearings are very relaxed. I'm just asking, what is the rationale for having the relaxed standard for those rules of evidence in order for one to demonstrate clear and convincing evidence or preponderance of the evidence, whatever hearing they're at? Why are we relaxing the rules of evidence for the petitioner to demonstrate that?
We're doing that. We're doing that because, like what happened in Lewiston, a preponderance of the evidence would have shown that the shooter in Lewiston had been exhibiting warning signs of danger to himself and others around him repeatedly over a series of months. Had this tool been available, the preponderance of the evidence would have relieved him of access to firearms. That's why. That's the answer. To save people's lives.
So to have a low.
If you want to get into the law books, I'm happy to do that and actually have an attorney speak to you about those details. The reason I wrote this like this, preponderance, clear and convincing, was because we had multiple discussions with many stakeholders about what would be the standard that would be the most helpful to maintaining our constitutional rights and making sure that we have a tool available to citizens to make sure that they can interrupt potential violence. So that's the answer. That's the answer.
You have a follow-up?
Yes.
I'm sorry, I'm just looking something up.
And now on page 4, it talks about obtaining a warrant if there's probable cause to believe someone's not subject to this order, they're not complying with it. I'm just
sorry,
asking,
essentially what?
someone's subject to this order, they're respondent, and there's probable cause to believe that individual is not complying with the order. Is that warrant that's being issued, is it being issued under the authority of the civil order, or is that because they're investigating a criminal investigation?
Did you just assert that the person was not in compliance?
Well,
there's nothing to comply with yet on page 4. Like, we haven't gotten that far yet.
if lines 14 to 18 is what I was referring to. I'm just asking.
Yes, the court may subsequently issue a search warrant authorizing law enforcement to search for and seize any all firearms and ammunition in the respondent's possession, custody, or control. If there is probable cause to believe the respondent has firearms or ammunition, and if the court has reason to believe that such firearms or ammunition have not been relinquished by the respondent. That's exactly what we do with 173B. That's the standard. Like, that's what we do. This isn't, I didn't reinvent the wheel on that.
No, I follow. What I'm asking is if someone is suspected of violating that and they have a warrant, and that doesn't mean they did something wrong, but there was probable cause, is that the validity of that warrant challenged under the protection order here, or is that challenged in a subsequent criminal proceeding?
This is nothing to do, this is not a criminal proceeding. When someone has firearms and they are subject to a temporary ex parte order, they're asked to relinquish them. And if there is suspicion that they're actually holding some back, law enforcement can get a warrant and go get them. So, I mean, that's what we do. That's our policy and practice right now. This stays in that realm. Yeah.
Just another thought.
Okay.
In respect to the discussion about the court ordering a mental health evaluation, I think he also says,
Where are you?
on page 5, it's lines
Thank you.
5 to 10.
Yeah.
I assume if a respondent is ordered to submit to that, it would be at the extension of an order after a two-party hearing. What's the rationale of waiting so long for the person to be simply ordered to get a mental health evaluation, never mind when they would actually submit to it? If the person's been considered by the court to be suicidal, why is so much time going by until they'll get any mental health treatment?
There is nothing that precludes anybody from seeking and receiving mental health supports or services prior to a court-ordered mental health evaluation. Like the court doesn't say you can't go get help. It says you must get by this certain date. So yeah, I mean, there's nothing that's stopping them. In fact, it's implied and encouraged that if you have reached the point where your loved ones are coming to the courts because they fear that you are in such a crisis that you might harm yourselves or others around you, we have reached a mental health crisis. But it's actually doesn't even reach the bar of an involuntary commitment yet. So we're addressing the gap.
Thank you, Madam Chair. I just want to go back to this, what rules of evidence apply. I don't think it's entirely, a dispositive, part of the, whether it's, I don't know how important it is to the entire bill, but I just wanted to clarify that, Senator Abbas knows, as I know, that, and I'm not sure if you're aware, that there are frequently cases such as civil, certain civil cases like family law and other areas, particularly when we're talking about temporary relief, sometimes when we're talking about ex parte relief, where the rules of evidence are relaxed. And so isn't it correct that, it's pretty common for a court to relax the strict rules of evidence, particularly where there's safety involved? Would you agree?
Well, yes, thank you. Thank you for bringing it up like that. And forgive me for not being as eloquent as you may have liked in describing the preponderance of the evidence and the clear and convincing. I thought we were all on the same page with our understanding. So thank you for that detailed explanation.
Real little. Thank you, Senator, for taking my last question.
Yes, sir.
At the beginning on, what page is this? The second page, family and household members, what it means. So.
Family, what line are you on?
Line 15, 16, 17.
On page 1. Yep.
Yep. So are you at all concerned? I used to a long time ago do a lot of divorce work, and ex-spouses, I never knew who was telling the truth half the time. So I have an ex-spouse here, and you have people who no longer share the same residence, no longer cohabitating. I've seen a lot of mean and nasty divorces, and people would say a lot of things. So are you concerned at all that you included ex-spouse or other people you no longer habitate with for 24 months? Are they going to, are you going to open up people to be nasty and, say, I'll screw him and take his gun away or her gun away?
Yeah, that is a common myth that, my ex-wife is going to take away my gun. It's so interesting that every time that scenario is played out, we never hear about my ex-husband. It's going to take away my wife, take away my gun. Like that never comes up. So I would ask you to look at the penalties for perjury. So you have to fill out this affidavit similar to 173B and attest that the information you are presenting to the court is truthful And then not only do you have to present that and attest to it being truthful, you can't do it anonymously. You have to come to court. You have to stand before the court and tell the court who you are, what your relationship is to this person, and what your concerns are. And then the court absolutely has the opportunity in that moment, which is before anything has happened, to say, is this do I believe? Is there a preponderance of the evidence that this may be used as a tool to hurt someone? Or have I received lots of information that tells me that this person they're concerned about has a problem and we need to get in front of it? So the courts actually have the moment to discern that. And a person who is seeking that temporary order has to come forward with who they are, what their relationship is, and why they feel that someone is really in danger.
Thank you, Senator.
Okay, Senator, I have a question, and I've been listening to everybody go back and forth on this.
Yes.
And I think it's important that we try to clarify just exactly what this is. And quite frankly, I find it a little, I'm sorry to the public. I forgot to turn on my microphone. I'm concerned about this. What you basically have is what amounts to a red flag law. And we've seen them in other states. And there have been instances of states that have adopted this type of a law, and it's still failed. This is not a universal panacea. It just isn't. And in Maine, they have a modified red flag law, which is called a yellow flag law, what was in place with the Lewiston shooter, and it didn't stop him. But what I'm really concerned about is you're taking someone who has not broken the law. Being mentally ill is not against the law. And you're allowing someone else to make that determination and to go to court and make that kind of an accusation against someone. And, you can say, yeah, they're doing this and they're doing that. They're not a mental health professional. They are not a professional, nor are they a police officer who, here we're lucky in New Hampshire, they get a lot of training on dealing with individuals who are suffering from mental health. We have mental health advocates that for years have come here and said, we've got to stop stigmatizing the mentally ill. But here, there's an automatic presumption, something's wrong with you, and we're going to take away one of your constitutional rights. I find it very disturbing because you're trying to prevent someone from committing suicide. I think this kind of thing might be something that pushes somebody over the edge, because this is a court order. This is a permanent record. This can be accessible to the public. This will follow an individual around for the rest of their lives. And it's extremely serious, and we really have to know what we're doing here. I'm just very, very concerned. You've talked about domestic violence issues. There is a case in front of the Supreme Court of the United States, because many states have adopted this position, including New Hampshire, that if someone goes to court and they want an emergency protection order, they can say whatever they like, and the judge will issue it. But the person that they've accused, and who now, the police don't ask for their guns. The police demand they turn over their guns. I want to make that very, very clear, because I have heard from constituents of mine that has happened to. They demand, if you have any guns, you must turn them over. It is not voluntary. So they've been deprived of their Second Amendment rights based on an accusation. And as far as I know, we live in the United States of America. You are innocent until proven guilty. Now, this person has lost their Second Amendment rights. They've got to go back to court. It's usually about 10 days later. And in order to get their guns back, in order to go in front of a judge and argue why that person is wrong. And even then, they have to again go back to court for another hearing to get their guns back. That, to me, is egregious. This is a Second Amendment right. We have the duty and responsibility to protect the Second Amendment, whether we like it or not, just like we protect other First Amendment freedoms, the freedom of speech, freedom of religion, all of these things. I just don't think that this is going to work. I understand where you're coming from, but there is nothing that stops anybody who gets this and they take their guns away from going out and finding another method to kill themselves, if
Madam
that's what
Chair?
they want to do.
I have a point of.
Thank you. And I
just have a point of order, excuse
Sure.
me, just a point of order that we, this is a hearing, we should be questioning the hearing. I
Yes.
know this is an important issue, but just a point of order, I think we should be
Yes,
asking
and I
questions.
will get to my question. Thank you very much. So do you believe that this is a violation of an individual's Second Amendment rights?
Thank you. I understand that you have some very passionate feelings about this, and I will note to you that also I'm not blind to a talking point of guilty until proven innocent. This is not a criminal claim. So, with your questions about due process, we have safeguards in place in this legislation that protect the respondent from unconstitutional violation of his or her due process. A pre-hearing deprivation followed by a full hearing within a reasonable timeframe satisfies the due process of law required by the Constitution. The prompt evidentiary hearing and high burden of proof of the evidence standard, as well as the provision of penalty for false allegation, has proved satisfactory for constitutional objections addressing due process in other states with similar laws. We've been on a long journey with this piece of legislation, and this began way back in 2019. And when we began, there were 13 states that had similar laws. Now there are 21. We're lagging behind. The U.S. Supreme Court has recognized in multiple contexts, stating, and I quote, where a state must act quickly or where it would be impractical to provide a pre-deprivation process, post-deprivation process satisfies the requirements of the Due Process Clause. This is a civil order, not a criminal violation. So no one's guilty of anything till they're proven innocent. They are in a crisis where they're a danger to shooting themselves or others around them. 18 people experienced that. They're not around. They don't have any Second Amendment rights now either. They don't have any First Amendment rights. They have no amendment rights because they're 6 feet under. So let me be clear. In Maine, since you brought up the yellow flag law, because Maine couldn't get their legislature all the way over the hump to put in a real extreme risk protective order. They limited it to only law enforcement. And a tool is only as good as it's being used for. It doesn't, if I have a pen and I leave it over there and I complain about how I can't write, oh my God, I can't get anything on this paper, but I have a pen right there. I could solve my own problem if I picked up that pen, but oh my God, the pen is all the way over there. Can I possibly reach and get that pen? No, I don't think so. This is why it went wrong in Maine. They didn't even use the tool they had. They had time and opportunity multiple times to use a tool. And so we don't know if it would have worked because no one used it. I don't know if that pen works because I'm not picking it up. So you cannot judge the efficacy of something you have never used. So we believe that guilty until proven innocent is a false statement. This is an important gun violence prevention tool. It is narrow in scope. It relates only to those who are extreme risk. It satisfies constitutional objections in 21 21 states. And if we were to not do anything because a couple of times it screws up, we wouldn't be here. We wouldn't have laws. What's the point? We have to do something. We have to do something. We have to do something now. It would have been better to do something back after Columbine, but we haven't done anything. And so now I hope that we can see forward to have the courage to take action and do something around the piles of bodies that are stacking up around us from taking no action. The time is now.
Thank you for your testimony. Senator Abbas has a question.
Thank you, Madam Chair. So if someone were to be involuntarily confined under 135-C, in that scenario, they actually would get a mental health evaluation. And then when they go before the judge would have that to rely upon when making any types of findings on whether that person should continue in mental health treatment or if they pose a risk to themselves. I'm wondering, in the way this is written, I'm referring to the policy, the provisions on page 5, lines 5 to 10. It appears that if the person's been found to be a danger to themselves, you're gonna have to wait 7 to 10 days for the two-party hearing. At that point, they're only ordered to get a mental health evaluation, never mind what type of treatment they need. I understand the firearm issue you're talking about, but what about the issue of suicide itself? It seems that if a person's suicidal, we're really not addressing that potential harm for quite some time. If the court believes someone's suicidal, why do we wait so long? And why would the court not want that evaluation right away?
All right, thank you for pointing that out. I'm on page 5, line 5. Is that what you started?
5
through, okay. So on line 5, during the hearing, the court shall determine if a mental health evaluation or chemical dependency evaluation is appropriate. So that is the court deciding if the court feels there should be one administered. Is there anything stopping that person who is now subject to this order or subject to this proceeding from seeking mental health services or addiction, chemical dependency services before they're ordered to? Absolutely not. Which brings us to line 11. The court may subsequently issue a search warrant. So there's shall determine if someone should have a mental health evaluation. Doesn't stop anyone from doing it. Perhaps, but we won't know because we don't have it yet. So hopefully, perhaps, the process of being brought into court to respond to an extreme risk protective order is a wake up. And it certainly is a better idea than going to a funeral. And I really, really implore you to read the testimony included in the testimony from my constituent in Exeter on pages, well, I put mine in big type, so it's a different, you have different typeface. I put mine in 20, so on me it's page 9, but because this is what they needed. They needed this. And you'll hear from other people who need this. She wouldn't be in a position of asking for this if it had been available. This family used all the tools that were available. And because we don't have anything to interrupt dangerous behavior, they don't have a son.
Let's follow up.
Let's follow up.
All I'm trying to I understand what you're saying, but if a person is found suicidal, I'm just wondering why the court is not, it seems that this focused on disarming the person, but not really concerned with resolving any issue why the person was suicidal.
Okay.
It sounds like you're telling me
I see what you're saying.
mental health should get one themselves.
Okay.
If that's the case, they should have already got one, but I'm just explaining why is it taking so long for that to happen?
I hear you. Okay.
That can be done in the front end, because then I assume that evaluation would be very helpful to the court in subsequent hearings.
Yeah, okay, heard. Now I understand where you're going with that. So if someone is having suicidal ideations, we know, and we have data, which I have given to you here, and in the packet that came with the testimony that tells us that when someone uses a firearm or has access to firearms, it is the most lethal means. 90% of the people who attempt suicide with a firearm complete that suicide. There's no coming back from it. So yeah, that's exactly what we want to get in front of. That's what we want to do, because a suicidal person, we want to get the most lethal means away from them. In fact, when you look at the New Hampshire Suicide Prevention Annual Report, that is one of our New Hampshire goals, is to relieve someone of the most lethal means. That's we want to do that. That we have made that statement. I will send you the link to our suicide prevention report. Maybe there's someone here who was part of drawing up that report, but it is in black and white. Get the most lethal means away from someone who is having suicidal ideations.
Thank you. Are there any further questions? Seeing none, thank you, Senator.
Thank you. Thank you for that robust discussion.
You know this committee, Senator, that's what we do here. Let's see. I have two representatives that would like to speak, and I'm going to start the 3-minute rule so we can make sure that everybody has an opportunity to speak. First, we have Representative Laura Is it Selvig?
Laura Selvig.
Okay, thank you.
Thank you. Thank you, and thank you to the committee for allowing me to testify today. My name for the record is Representative Lauren Selig. I represent the town of Durham, New Hampshire, which is Stratford District 10. And I've made note for myself because I get nervous too.
Yeah, that's okay. Thank you. Appreciate it.
Yes, so I'm here to speak about extreme risk protection orders. I'd like you to imagine a group of young adults, similar in age perhaps to my own children, meeting up for refreshments after a long week at work. One starts talking about his frustration with his boss and how he thinks his boss is always picking on him and punishing him for things that aren't his fault. His friends sympathize and leave it at that. The following week, they meet up again, and again he complains. And the week after, and the week after. He expresses his frustration another week, but this time he says he needs to do something about it. He gets angrier and angrier and talks to his friends and tells them about his AR-10 and that he's not afraid to use it. He finishes by saying, "Look for me on the news next week." So we've got some different options of what could happen. Option A, the friends say nothing to anyone. On Monday, the guy goes to work. He shoots and kills his boss and 10 other people who happen to be nearby, and then turns the gun on himself. At his funeral, his friends say they wish they could have done something. Option B, the friends call the police. Unfortunately, it's New Hampshire and there are absolutely no laws in place to have the police intervene based on the friends' comments. The guy goes to work on Monday. He shoots and kills his boss and 10 other people who happen to be nearby. He then turns the gun on himself. At his funeral, his friends and family ask why nothing was done. And politicians offer their thoughts and prayers. Or option C, the friends call the police. The police go to the home of the young man. They temporarily take custody of his guns and ammunition and refer him to the courts and to a mental health evaluation, which will take place within 7 days. In the time taken, the young man seeks and gets the mental health care he needs. HR also assesses the problems in his workplace. Everyone goes home to their families at the end of the day. And when the young man is deemed mentally stable, his guns and ammunition are returned to him. When he and his friends go out for refreshments again, he thanks them for having his back. This bill is not intended to permanently take away anyone's guns or gun rights from them. It's intended to stop someone who is having a mental health breakdown from accessing deadly weapons, to allow time for proper intervention and care to be provided. Today, I ask you for more than your thoughts and prayers. I ask for your action to please support this bill and save lives. Thank you.
Thank you very much, Representative. We've got 6 seconds to That's pretty good. Thank you. We really appreciate that. So are there any questions? Senator Abbas?
Thank you, Madam Chair. With what you would just testify to, the example you gave where the person gets the mental health evaluation, in this proposed legislation, would that evaluation be available through the court order after the ex parte hearing, or would that be something that come up at the two-party hearing?
I would leave that interpretation to an attorney. I am not one. I would say one would always encourage and hope that with the training that we are hopefully providing to our police, and for example, in Portsmouth, where they've now added a mental health counselor to their police department, that we would be advising the person and assisting them in getting the mental health support they need as quickly as possible to have them back on the path to wellness as quickly as possible.
Thank you.
Are there any further questions? Seeing none, thank you very much.
Thank you.
The chair will call Representative David Muse. Let me know when you're ready, Representative, and I'll start the timer.
Thank you very much. I'll paraphrase my remarks as much as I can. About a month or so ago, I attended a convening of state legislators at Washington, D.C. that was organized by the White House Office of Gun Violence Prevention. I was one of about 100 legislators from around the country that was actually there. There were 2 legislators from New Hampshire, and generally there were 1 or 2 from each state, with one big exception, and that exception was Maine. There were actually 8 legislators there from Maine, and the reason that they were there was because a month before, the mass shooting in Lewiston had happened. So what were these legislators like? What were they like to meet? They were serious, they were intense, there was a sense of purpose about them in the questions that they asked and in all the discussions that we had. But I think one of the things that permeated all of our conversations was this sense of unreality and shock that something like this could happen in their state. And very much like New Hampshire, Maine people have a perception of their state as being safer than other states. And what they found out in October was that their state is no safer than Nevada, Florida, New York, Maryland, or any of the other states where these incidents have taken place. And as a home state legislator, one of the things that I think everybody needs to know is that something like a Newtown, an Uvalde, a Parkland, or a Lewiston doesn't just shock you, it haunts you. And one of the reasons that it haunts you is if you know that there was something you could have done at some point to prevent it. Because one of the lessons that we've already learned in New Hampshire is that we can't unring the bell. We have a bill going through the House right now that would straighten out our law with regards to mental health reporting for background check purposes. It was a law that we could have passed 4 years ago, and we did not. The reason why we're considering this bill now is because a police officer, his former police officer, was shot to death at New Hampshire Hospital. It's taken a death to get us to act. And I think the reason why I come here and I testify to this committee and I testify before my own and why I sponsor this legislation time after time after time is because I think there need to be legislators in this state who are interested in working together to make sure that things like this not necessarily can't happen, because I don't think there's anything we can do to totally prevent incidents like this. But one of the things that we can do working together is we can decrease the risk of things like this happening in our state. There are measures that we can take that don't involve taking people's guns away, that don't involve not letting people who should have weapons not have weapons. There are many, many things we can do. And one of the things that we learned—
Representative, your 3 minutes are up. If you could just please wrap it up in a few sentences.
I think the key lesson of the mental health reporting law is that we actually acted together in a way that hopefully will allow us to temporarily get firearms out of the hands of people who are a danger to themselves and to others. That's exactly what this bill does. Not everybody who commits an act of violence is adjudicated mentally ill. There are quite a few people who don't fall into that category, who are dangerous. These are the folks that this bill is intended to address.
Okay, thank you very much, Representative. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair, let's see, we'll call Jenny O'Higgins.
Thank you, Madam Chair and members of the committee. I'm Jenny O'Higgins. I'm our legislative liaison and a senior policy analyst for behavioral health with the Department of Health and Human Services. I'm here today to not take a position on SB 360, but rather to provide some information on behalf of the department relative to specifically behavioral health and public health concerns, and really that reduction of access to lethal means as a highly effective suicide prevention strategy that you have heard so much about already. So in New Hampshire, we know that about half of households have at least one gun. And while firearms are a part of the Granite State's cultural fabric, we also really know that they can present significant risk to those who are experiencing a mental health crisis. Firearms are the most common, quick, and lethal of suicide methods. And so New Hampshire has had a suicide rate above the national average for more than 10 years. And we have, as a Suicide Prevention Council, worked very diligently on many different ways that we can help to reduce those rates. You've heard the scope of that issue already from previous testimony, so I won't get into the data points. However, what I'm here to just talk about is that there is significant research to indicate that reducing access to lethal means for a person at risk to harming themselves or others is really one of the only evidence-based ways to prevent gun deaths, especially suicide deaths. And the good news is that New Hampshire has this amazing reputation of being a national leader in advancing this work in direct collaboration with gun owners in a way that respects the Second Amendment and that builds on the gun community's own safety culture and culture of protection, right? And it emphasizes that no person in crisis should have access to a gun. Examples of that are that there's homegrown programs, both the counseling on access to lethal means that was started here in New Hampshire, as well as the Gun Shop Project that was started here in New Hampshire, where suicide prevention experts and gun owners came together to create both of those programs, recognizing that gun owners, like everyone else, want to protect their families, right? And so they're often also deeply invested in suicide prevention. And so we're able to create these programs that have now become national recognized. And so we know that there is a reduction of suicide fatalities that's been shown in relation to policy, that what it does is just put some time and some space between a person at risk and a really highly lethal means. And that is, I know my time is up, so I'll just say that the one last piece that I'll say is that when other states have enacted types of policy that put that time and space between a person and lethal means, they have seen a reduction in firearm suicide deaths without a corresponding increase by another means. Thank you so much.
Thank you for your testimony. Are there any questions from the committee?
Great.
Seeing none,
Thank you.
thank you. Okay, the chair will call Holly Stevens.
Good afternoon, Chair Carson.
Good afternoon.
Members of the committee. My name is Holly Stevens, and I'm the Director of Public Policy at NAMI New Hampshire, the National Alliance on Mental Illness. NAMI New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted by mental illness and suicide through support, education, and advocacy. I am here on behalf of NAMI New Hampshire today speaking in support of Senate Bill 360 relative to extreme risk protection orders. The impact of a single suicide death is profound and ripples out to the family and out to the community at large. Additionally, it has a significant economic impact, with the estimates of the cost of each suicide death being around $1.3 million. It's important to note that 90% of people who survive a suicide attempt do not go on to die by suicide. And unlike other means of suicide, as you've heard earlier today, the use of a firearm in a suicide attempt is almost always lethal, leaving little opportunity for intervention. While people may contemplate suicide for a long period of time, when they make the decision to end their life, there is often very little time between the point of them making the attempt and them making that decision. And toward that end, temporarily restricting access to lethal means is an important strategy for suicide prevention. I do include a bunch of statistics in my testimony. You've already heard a lot of them, so I'm not going to repeat them. But one thing that you haven't heard today is that every year, an average of 124 people in New Hampshire die by gun suicides. Simply put, temporarily restricting access to firearms when an individual poses a significant risk to causing harm to themselves or others is a common sense measure to assist in addressing the major public health issue of suicide in New Hampshire. With that, I'll end my testimony and just ask that the committee support this bill.
Thank you very much for your testimony, Ms. Stevens. Are there any questions from the committee? Senator Gannon.
Just a quick question. Would you think that these other means of attempted suicide are more cries for help? And they really, they took too many pills. They want the family to get their attention more than a real suicide attempt?
No.
So it distorts the figure? No, thank you. Just a question. Thank you.
Are there any further questions? Seeing none, thank you very much for your testimony.
Thank you.
Okay, let's see. Okay, the chair is going to call Catherine Giddens. Let me know when you're ready, Ms. Giddens.
Good afternoon, Madam Chair and members. Thank you very much. My name is Catherine Giddens. I am a lawful permanent resident here and a local resident. I am a competitive firearms shooter and just learned about this bill from a friend a couple of days ago, read through it yesterday, and just want to acknowledge that I can feel that there's a lot of pain and hurt here. And from the bottom of my heart, I just want to honor that. I know what it's like to lose someone you love, and it's very sad, and it's very real and very raw. And nothing of what I say is meant to belittle that or diminish it. But I also want to acknowledge here that there is also a spirit of unconstitutionality that I believe is the true spirit of this bill. A lot of the members here have pointed out ambiguous aspects of it. When you get through the whole lot, you can see that there is so much that just goes against the Second Amendment and potentially infringes upon my right to bear arms and everybody's right here to protect themselves and their family. Where they're a danger to themselves, there are already laws and statutes in place for emergency help for those people. On the matter of temporarily confiscating weapons, I know it was mentioned a couple of times, the word temporary, and that legal advice could be sought. In the bill itself, the responsibility is on the defendant to supply their own legal counsel. So if they can't afford to do that, then that temporary suspension becomes permanent, which is one of the red flags to me, that the spirit of this is not in helping those in mental health crises, but it is for gun regulation, which can be seen as to where it's placed in the statutes. And I do not believe that this is closing a loophole. I believe that this is an underhanded way to create a black hole in which gun rights can be disappeared. And I say that not from a place of hardness of heart to anybody here who has suffered. I just say that from a reasonable layperson's view of what this bill reads. And the law must be reasonable. It must be clear. It mustn't be emotional. It must be dry as 3-day-old toast. And this bill is not that. It is fully charged. And if anything, I implore you to reject it. It can go back to the drawing board. It can be placed somewhere else. But if it's about regulating guns under the guise of protecting mental health, issues, then it must be knocked down. And that's what I have to say. And thank you very much.
Okay, here, let me turn this off. Okay. Thank you very much for your testimony. Are there any questions from the committee?
Beg your pardon.
Senator Gannon.
Did you get that bag with Penny?
No,
Same bag.
no,
Same
I did notice. Got some taste,
Okay,
lady.
we're talking fast.
Thank you.
Okay, I see no further questions. Thank you very much for your testimony.
Thank you for your time.
Okay, next, we're going to call Nina Nirk, I think it is at K-N-I-R-K. Let me know when you're ready, Ms. Nirk, and we'll take it from there.
Okay, my name is Lana Nirk, and I'm a volunteer with Moms Demand Action for Gun Sense. I support SB 360 because it establishes a procedure for issuing extreme risk protection orders to protect against persons who pose an immediate risk of harm to themselves or others. Extreme risk protection orders provide families a proven tool to reduce gun suicides and mass shootings. I will focus my comments on gun suicide because a shocking 88% of gun deaths in New Hampshire are suicides. Each year, an average of 124 people in New Hampshire die by gun suicide. Many gun violence tragedies are preceded by red flags, warning signs that often are noticed by family members. Reducing a suicidal person's access to firearms by temporarily removing them when that person is clearly in crisis could save lives, so could save their life. Data shows that having access to a firearm triples one risk of death by suicide, and states that have passed this type of protective order or red flag law have seen decreases in firearm suicide rates. Connecticut's extreme risk protection law has been associated with a 14% decrease in gun suicide rates, while Indiana's extreme risk law has been associated with a 7.5% decrease. My personal experience working with families in New Hampshire when they're in crisis reinforces my belief that families deserve access to every tool that can help prevent warning signs from escalating into tragedy. The ability to temporarily limit access of lethal firearms by individuals in crisis will help save lives. Thank you.
Thank you very much for your testimony, ma'am. Are there any questions from the committee? Senator
Just a quick
Gannon.
question, because you mentioned Connecticut, the gun suicide rate went down, you said 14%, I believe, when they implemented a red flag type law. Did other suicides go up when that went down?
That I
Other
don't
times?
know.
Okay, thank you.
Okay, thank you very much. The chair is going to call Dr. Christine Arshow. Is it Arshow? Terrific. Thank you very much. We do have another physician, John Hink. Good afternoon, Dr. Hink. If you could let me know when you're ready, and we will go ahead and start the clock.
My name is Dr. John Hink. I'm a psychiatrist representing the New Hampshire Psychiatric Society and the New Hampshire Medical Society. The New Hampshire Psychiatric Society is a branch of the American Psychiatric Association, or APA, and the APA has called firearm violence to be preventable and has urged elected officials to take action to keep communities safe. The New Hampshire Psychiatric Society strongly supports SB 360. Research has shown that risk-based gun removal laws, or red flag laws, were associated with reduced firearm suicide rates in states such as Connecticut and Indiana, where such laws have been instituted. They are most often used to prevent suicide. I was working at New Hampshire Hospital on November 17th when suddenly gunfire was heard in our lobby. Security Officer Bradley Haas died heroically while defending the patients and staff at New Hampshire Hospital. We don't know yet what led up to this tragedy, but in many situations, when a person is struggling with urges to harm themselves or others, there are people around them who know and are very worried. They often don't know what to do and can't act until it's too late. A red flag law can strengthen the abilities of community members to respond proactively to save lives. When asked, the majority of American citizens support red flag laws. Earlier this year, a national news organization found in a poll that 80% of voters say that police should be allowed to take guns away from people considered a danger to themselves or others temporarily. In closing, the New Hampshire Psychiatric Society strongly supports passage of SB 360. This law should improve public safety. Thank you.
Thank you very much, Doctor, for your testimony. Are there any questions from the committee? Senator Abbas?
Thank you, Madam Chair. I asked, and thank you for taking my question. I asked a few questions to the bill sponsor about the procedure related to when the mental health evaluation could potentially be ordered and perhaps the time frame that that would take. And from what you describe, I would think that you would believe that some of these suicides could be prevented.
Yes.
I'm just asking, this is a 12-page bill that focuses on disarming an individual. And I understand why someone who is believed to be suicidal, you would want to separate that person from a firearm. I guess my question is, why is there virtually no attention being paid to the mental health crisis that person's going through? Both the fact that they're suffering from suicidal thoughts, but also not doing anything to actually address why that person's suicidal. After they're disarmed, it doesn't change the fact that they're suicidal. It seems to just focus on the fact that the individual is now disarmed.
Okay. Yeah, thank you for your question. I think it's rather complicated because, we do have other laws like the IEA, for example, if someone's suicidal, but that is actually a higher level of taking away someone's rights, because if you go through the IEA process, that means that you actually get put into an emergency room, typically for a long period of time, and then you ultimately get admitted to a psychiatric hospital. So this actually I see as being, taking away less rights than the IEA law. So it just gives us another tool. And especially in cases where there may not be a mental illness involved, because you cannot do an IEA unless doctors can say this is dangerousness due to the mental illness.
Follow up?
Thank you, Madam Chair. So how would you recommend that this bill, if you do recommend any changes, actually address the issue that the person's suicidal beyond just the issue of firearms?
Yeah, I mean, at any point, the person could seek voluntary care. But sometimes there's problems with access to voluntary care. And then there's the IEA as well. So the person can certainly seek help. Another problem, though, that we encounter many times is that even though family and friends encourage the person to seek help, they may not agree with that. And that's another situation where if you know someone's being offered help, but they're not choosing to take that help, then this would give another safety measure.
Thank you.
Are there any for Senator Champlin?
Thank you, Madam Chair. We heard some concern raised earlier that a bill like this might stigmatize those with mental illness. What would you respond to that?
Well, it's a complicated question. The vast majority of people with mental illness are not a danger to others. In fact, they're actually more likely to be a victim. So we don't want to give that message that people with mental illness are dangerous. However, there is a very small subset of people with psychiatric disorders that might actually have an acute increased risk of being a danger to themselves or others. And that's why we have other laws that say that people in that category might fit into the IEA law as well.
Thank you.
Okay, are there any further questions? Seeing none, thank you very much for
Thank you
your
very
testimony,
much.
Doctor. Next, we're going to call Kimberly Moran.
Wait, don't start yet.
I'm waiting for you to tell me I'm starting.
Okay, thank you. I'm Kimberly Moran. I am here for the Women's Defense League of New Hampshire. We're a grassroots 2A Second Amendment organization that teaches women how to safely and accurately shoot, as well as fighting for our Second Amendment rights. Not only is this bill completely discriminatory against a large subset of law-abiding granted staters, but it takes away several guaranteed and protected rights, not just a couple. The Fourth Amendment right of privacy, the Fifth Amendment right against uncompensated takings of property, the Sixth Amendment right to jury trial and to confront opposing witnesses, of course, our Second Amendment right, and the 14th Amendment guarantee of due process of law, which is not protected in this bill. They were talking about petitioners earlier, and someone mentioned friends could file one of these petitions. That's not true. There's specific people who can file petitions in this. It's kind of pretty much anyone and their brother, as long as they lived with you at some point within the past 2 years. It could be a psycho ex-roommate who got mad because you moved out. It also could be an ex-mother-in-law or a cousin of a cousin if you were, related to somebody by marriage. So those are the type of people who can petition, not the friends just sitting around hearing you complain about something and then possibly being psychopathic about it. Who are the accused? Because this isn't just about people who might be having issues. Who are the accused? Law-abiding gun owners who have committed no crime. I'm going to repeat that. The accused are law-abiding gun owners who have committed no crime. They're accused. They could have police show up at their house and randomly come and take all their firearms because a petitioner made some kind of accusations, and these people didn't go to court first. They are having their firearms taken away. And then when they try to go get them back, they have to go and spend all this money on getting attorneys, and they have to prove using a high bar of evidence that they aren't thinking about planning on committing any crime sometime in the future. There was one just like that where a red flag law was passed. A woman who was sister of the man she called the red flag law on, he ended up being killed. She did it because she didn't like his politics. There was nothing wrong with him, but no judge is going to say, no, I don't believe you. We're going to take your evidence. They talked about suicides. They always try to talk about suicide as preventative measure in this, but statistics prove otherwise. Indiana put a red flag law in place in 2005. It didn't work out. Not only did suicides overall increase, but so did suicides with firearms after red flag laws were passed. And they did nothing to decrease the number of suicides with or without firearms. In fact, murder increased as well after Indiana's red flag law was passed. And I have a cousin who committed suicide. Oh, shoot. With a firearm, I'm almost done. A cousin who committed suicide with a firearm, and then I have a friend who committed one by hanging himself. Why is one more important than the other? This is just the same dumpster fire of a bill that New York City billionaire Michael Bloomberg tries to pass each session. It's ironic that the New York State Supreme Court shut down New York's red flag bill as unconstitutional. SB 360 isn't about safety, it's about gun confiscation. Bill of Rights be damned. Please vote inexpedient to legislate. Sorry.
Thank you very much for your testimony. Are there any questions? I have a question for you. And please, if you have testimony that you would like to submit, please hand it to Aaron, and we'll make sure every member of the committee gets it. We heard testimony that in other states that have instituted these red flag laws, they have brought together mental health professionals, various nonprofits, and gun owner groups to formulate these types of laws for their state. I've known you for quite a while. You've testified in front of us. You're one of the leading voices in protecting gun rights. Were you contacted by anyone who wanted to work on this bill so that the voice of gun owners could be reflected in the bill?
Absolutely not. And that's the thing, like if they would include gun owners want people to be safe and we want people to get help when they need it, but This bill isn't about mental health, it's about gun control. That's why we probably weren't contacted.
Okay, thank you very much. Are there any further questions?
Yeah, just what was your name?
Senator Gannon?
Your name.
Kimberly Moran.
Thank you.
Yes, I'm one of your constituents.
Thank you very much. Ms.
Thank
Moore.
you.
Okay, next we are going to call Dr. Rachel, is it Laramie? Is that correct?
Yes.
Okay, thank you, doctor. Let me know when you're ready and we'll go ahead and get this started.
Hi there. My name's Dr. Rachel Laramie. I'm a pediatrician in Dover, New Hampshire. I've been a pediatrician there for 28 years. I live in Portsmouth with my husband and 2 children. I testified a couple weeks ago for SB 371 and 377. I'm here to testify in support of SB 360. I'm going to say again that gun violence is a public health crisis. I am not going to read what I wrote.
Thank you.
But I want to respond to some of the things that were said today. The statistics, being a physician, I know that you can change statistics any way you want it. So you have to learn who to trust. And I know people hate the government, but I do trust the CDC mortality rates. And they publish a weekly morbidity and mortality. And so I trust this, and doctors trust this across the board. A lot of this information is used to publish articles in the New England Journal of Medicine. So although our suicide rates are lower compared to other states, it's still there. And a preponderance of them are by gun. So I do think might not be the leaders in suicide by guns, but it still happens here, and I think it needs to be addressed. The red flag laws in Indiana and Connecticut keep coming up and up, and that's because these are states that they've actually done studies on. And I want to address a few things. First of all, the homicide rate, these 2 states started these laws because of a mass shooting in Connecticut and a police officer being shot in Indiana. But what they found is that suicide rates did go down. I do want to address the question of, do other suicide go up? In Indiana, in a period of a year, 10 years, they prevented 383 suicides by gun, but may have contributed to 44 non-gun suicides. I don't know how they got that statistic, but I'm just letting you know that, and it's in your packet. In Connecticut, it prevented 128 suicides, but may have contributed to 140. So I want you to know I'm being transparent here, okay? So you can trust what I'm saying. I'm not going to sugarcoat anything. I'm going to be honest with you. But I do think we have a place here where we can help people. As a pediatrician, saving kids' lives is what I do. The last time I talked to you about things I do, I'm going to tell you this. I tell parents when I give them antibiotics, you need to use the whole course. I tell kids you need to wear your helmet when you ride your bike. Never swim alone.
Okay.
Wear your seatbelts. And to my older patients, don't drink and drive. This is another thing that I can do. The American Academy of Pediatrics supports ERPO laws and red flag laws to prevent kids who are at increased risk of suicide these days from completing their suicides.
Thank you very much for your testimony, doctor. Are there any questions? Senator
Nope.
Gannon?
Did you have written testimony?
Yeah, I handed it to you.
I didn't get that one.
I only had 4 copies.
Oh, okay.
So we'll
I
get-
didn't have
we'll
one.
get it.
Yeah, so I have it, and I'll have it all highlighted
Thank
for you and everything.
He'll get it to me. Thank you.
Okay.
Thank you very much, doctor, for your testimony this afternoon. The chair will call Elaine Kennedy.
Thank you. Excuse me. And I will be brief, but I have been a pediatrician for 50 years. I was a young pediatrician once. I'm an old pediatrician now. And I was very passionate then and now. I've heard your passion. I've heard other people's passion. Children die unnecessarily from guns, bullets from guns. And that creates passion. Families deserve help. They deserve to know safety regarding keeping guns away from children. They deserve to know suicide prevention and the risk of guns around people who are distressed. All families have serious distresses that happen in them, deaths, mental illness, physical illness. It is hard to access mental health care in a timely fashion. When you get mental health care, you don't get well before you leave the hospital. You may be improved before you leave the hospital, but you are not well enough to be around guns just because your family appropriately did access mental health care and get that care for you. I've known too many children, 4-year-olds, 10-year-olds, 12-year-olds, young mothers killed a week before Christmas. So that's my passion. I'm leaving the papers for you guys.
Okay, thank you very much for your testimony, Doctor. Are there any questions from the committee? Seeing none, it's a pleasure to see you again, Doctor.
Thank you.
You take care. Okay, next we're going to call Dr. Joe Hannon.
Hello, Madam Chair, members of the committee. Thank you for hearing me today. Good evening, almost. Sorry.
Yeah, we're getting there.
Hope not. My name is Joe Hannon. I'm the Vice President for Gun Owners of New Hampshire, and we oppose SB 360. This whole bill is basically based on pre-crime. If any of you have seen the movie Minority Reports, I won't get into explaining it to you then, but this is all based on speculation of a petitioner and the judge's determination. While psychiatry and other medical-based sciences have not been able to predict who is able to commit violent crimes. The purpose of this is to allow nullification of the Second Amendment right of an individual with a stroke of a pen. Okay, is my 3 minutes start now?
Yeah, no, that because I've got the timer on and the volume up.
All right.
If my phone rings, everyone's going to hear it.
Thank you. We heard discussion about people retaliating or getting retribution against a spouse or someone in divorce proceedings or an ex of some kind. I think that's, it was kind of brushed off as not very common, although it is extremely common in divorce proceedings to have the accusation, whether it's warranted or not, is up to what studies you look at. The idea that an ex parte hearing for the initial emergency order is in line with due process rights is ridiculous. The definition of ex parte is done with respect to or in the interest of one side only or an interested outside party that is not how the justice system works. We have a presumption of innocence in our justice system, and the entire system is based on that presumption. William Blackstone said, it's better for 10 guilty people to go free than for one innocent to suffer. And this is basically, I'd like to say one thing as a positive change from previous versions of this, which I've talked about over the years in here. The clear and convincing evidence portion for the second hearing, the permanent hearing, I think is it's on its face, it sounds like a step in the right direction. But if you have clear and convincing evidence that someone is a danger or is a violent person or has threatened somebody, there are other legal means to deal with that. An ex parte hearing has nothing to do with the justice. There's no opportunity to respond during the hearing. It's not a trial. We heard it's not a criminal case. It's a civil hearing. But there's no jury, no defense attorney can be present. The person doesn't even have to know that there's a trial. Imagine you all had to step out of the room and we decided that you or you or you or you or you is guilty of something and you had no right to say anything. Now, granted, it's only temporary, but you'd still be outraged. It's not how our justice system works. There's increased danger to law enforcement and the respondents when police are called to confiscate firearms. Also, you have someone who is supposedly a danger to themselves or others, and then they're ordered by the court to go get those guns and ammunition and bring them to the police station. That would be like telling the drunk driver, go get your car and drive it downtown. We don't do that. There's a cost to the respondent, not to the petitioner. There's also no process for restoring rights. I got about a million things, but I'll just end by saying if someone is accused of murder, they have more rights and they're afforded more due process and protections than a law-abiding citizen who might do something in the future. So I ask you to please ITL this bill, and if there's more you'd like to know, I'd be happy to submit more in writing, but I'll have to type all this out.
Thank you very much for your testimony.
Thank you.
Dr. Hannon. If you would like to submit your testimony, we're not execing this today, so we will have plenty of time to review your testimony. Are there any questions for Dr. Hannon? Dr. Hannon, I have a question for you, and I'll ask you the same question that I asked Ms. Moran. You are a well-known advocate for the gun community in the state of New Hampshire. You're a member of Gun Owners New Hampshire. You've appeared in front of this committee numerous times concerning a number of different issues. We heard testimony that in states where these laws are successful, they brought together everyone. They brought people from different communities in to talk about how they can address this issue. You, as a prominent member of Gun Owners of New Hampshire, were you contacted to be a part of this bill and to get the voices of the gun owners heard?
Not this year at all. I will say that a few years ago, I interjected myself into the conversation, reached out to different members, and some of them are here today for a bill. This might have been 2 or 3 versions of this ago. And I did sit down and gave some things that I would say would be acceptable or not acceptable, and none of those were ever met. The language was changed, and like I did say, they did change the words to presumption of preponderance of evidence to the higher standard. But with that higher standard, you don't even need to do this. If you have that higher standard, you can probably charge that person with a crime and have them arrested and then have their firearms removed for that avenue. So, I'd be happy to sit down and talk to people. I'm always willing to talk to anybody who is willing to come up to a solution. As far as my background, since you brought it up, I have an extensive background with harm reduction and naloxone. I was actually one of the people that helped sponsor the naloxone bill, and I was the first sponsor of the first bill for syringe exchange legislation. So I have a very strong and long history with harm reduction. And for harm reduction, we don't just chain people to a radiator to keep them from doing drugs. We don't remove necessarily every medication in their medicine cabinet or their prescription cards or their ability to go to the pharmacy. That's not what harm reduction is. I grant there are probably avenues for using harm reduction methods for prevention of any kind of issue, but unilaterally removing someone's rights without any crime or evidence that they've committed a crime is just not what that is.
Thank you very much for your testimony. Are there any additional questions? Seeing none, thank you very much, Doctor.
Thank you.
The chair will call Samantha, I think it's Sweater? Okay. Let me know when you're ready, Doctor, and I'll start the timer.
I'm ready. Madam Chair and honorable committee members, my name is Dr. Samantha Sweater. I'm a psychiatrist at New Hampshire Hospital, but today I'm representing the New Hampshire Psychiatric Society, which, as you heard Dr. Hink testify, we're in strong support of Senate Bill 360. I am also a gun owner. I'm also a staunch supporter of the Constitution and have the Bill of Rights in my foyer. It's the first thing you see when you walk into my house. It's very important to our family. Firearms are a major cause of injury and death in the United States, and this is a serious public health crisis, as you've heard other people testify to today. This bill is not, in my perspective, does not address mental illness. It addresses dangerousness. Not everyone that commits suicide has mental illness. And we know most people who commit violent crimes do not have a mental illness. This helps those people. There's actually a lot associated with people with substance use disorders, which the IEA and getting mental health treatment does not address. If you have a substance use disorder, you cannot apply for an IEA. You cannot send them to New Hampshire Hospital. This bill can help those people. And that is, substance use disorders are associated with a lot of violent crime and suicide. It's one of the biggest risk factors that we have for suicide as well. Red flag gun laws or extreme risk protection orders are evidence-based. I included it here, along with position statements from various medical societies. All of the evidence is in there. But a summary is that extreme risk protective orders delay access to guns in suicide, and it's estimated that for every 10 to 20 gun seizures, 1 suicide is prevented. And yes, that analysis included people who attempted by other means subsequently to having their guns seized. And that it's quite a lengthy article. I read it this morning, but it is included in the information here if you want to reference it, how they did the analysis. And it's very thorough, very well done, and very thoughtful. I also included in this reference material that information from the first year of Colorado's implementation of extreme protective orders. And what they show is that misuse of this is rare. Lastly, I just wanted to follow up with a story. My Aunt Bonnie, wonderful, wonderful woman. She lit up a room. She made every person feel like they mattered. Everyone loved her. She genuinely was like the belle of the ball everywhere she went. And she unfortunately had a substance use disorder, or developed one. She did not have a mental illness. And while we knew she wasn't doing well, we couldn't get her help. She didn't want help. And as I mentioned before, I'm a gun owner. My whole family is gun owners. Most people have a gun on their person at all times. We couldn't get her help, and she shot herself on May 4th, 1999, in front of her daughter. And not only was her life taken, my cousin doesn't really have one either. So 2 lives could have been saved that day if there had been a bill like this.
Thank you very much for your testimony. If you would like to give your testimony to our committee secretary, as I said, we're not execing this today, and so we'll all have plenty of opportunity to read it. Are there any questions? Seeing none, thank you very much for your testimony this afternoon.
Thank you.
Okay, the chair is Ms. Spencer, Louisa Spencer. Is she here? She didn't check whether or not she wanted to speak. So there's no one here? Okay. Okay, next we're going to go to, I think it's Joel Weintraub? Yes, we'll get there.
My name is Joel Weinreeb. I'm an Eagle Scout, United States Marine Corps, in the United States Infantry. I've been a police officer and a state police officer. I want to re-quote what the chairperson said today, that this document is not going to save anybody's life. My cousin was just recently shot in the face by a gentleman who had a restraining order on him. I'm going to tell you why the system has failed, because the medical system has given people HEPA. So before, when I went to the police academy, people were identified. If you went to a mental institution or you were on certain things that you qualified, you were on a list not to receive a gun. If you were on certain medications, not to receive a gun. The next thing I'm going to start with is USC 18, federal law, prohibiting the children to have possession of firearms and not being secured. Those laws have been there since 1968. Page 1. Line 25, law enforcement officer, unless you have a PhD, and I'm pretty sure the only person who has a PhD in this subject matter is the chief of police in Franklin, and he's a highly educated man. He's testified before the House and the Senate on many things before also. As far as page 2, 25, 26, 27, any person who files a petition under this chapter containing alleged petitioner knows to be false who files a petition with intent to harass the respondent shall be subjected to criminal penalties set forth in RSA 159F11. I'm going to tell you that's minutia. I've been arrested 5 times by the same person, falsely accused. Faced 17 criminal charges. None of that and she was never ever charged. And no prosecutor is going to come before any court anywhere in America after they just defended someone else's rights, saying that they were a victim, and then they found out that they were a liar. So you can go check the court records in any state in this country, and you'll find that there's not been one prosecution of anybody who has ever falsely made allegations against anyone about any kind of domestic abuse. All right, page 4, 14, 15, 16. Search warrant. The senator over there asked the question again. So they give the search warrant to this person. What if they go in there and they find child pornography? They find drugs? Is that within the scope of the warrant? So now that person faces other charges. Okay, on page 7, line 19, 20, 21, shall issue a receipt, identify all firearms or quality of ammunition. Well, there's other subject matter. I can attest to that. As the senator also reiterated, that this ain't going to stop anybody from violence, that the police do not allow you to surrender your things. They come into your house and they take your property and they do not properly, lawfully document a chain of custody of everything that they've removed from your home. How do I know that? Because I have a handgun and a rifle that was stolen from the police department that I still worry about after many years. And the last one I wanted to hit on was law enforcement by the court being written orders to return their property. People don't get their stuff back. And if someone's stuff is taken, why are they having to pay for storage for something that they were falsely accused of, had to pay for an attorney to take and get through, and then have to pay restitution for storage? I live in fear every day because one of those guns was a handgun that it's going to end up on a body someday. And I only have a document that has that serial number on it that it was taken. The rifle, that was another whole situation. But the storage of the firearms, the state isn't set up for that stuff. There's no chain of custody on these properties to be properly done. And the value that Senator brought up about destruction of property, all you gotta do is go to Muskego auction and see that there are guns that go for $250,000 that may be a little gun this big that some police officer has no knowledge of what it is, and that property is now worthless because somebody damaged it. Thank you for the extended time, ma'am.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you, folks. Have a great night.
The chair will call Kathleen Slover. I think that's how it's pronounced. Good afternoon, Ms. Slover. Let me know when you're ready and we'll get this started.
I'm ready. My name is Kathleen Slover. I live in Portsmouth, New Hampshire. A lot of what I had has already been said, and I too have a study that shows the Connecticut and Indiana study done. And the reason why those states were studied were because they had the first red flag type laws in place. And so the study was done to see if it affected suicide rates. And I think based on the numbers that you got, I highly recommend you look at that and show that it was a mixed result. It was hard to tell, but definitely suicide by firearm was reduced. We understand, I'm part of Moms Demand Action, which is a gun violence prevention advocacy group. And we are completely under the understanding that no one law or policy will ever reduce gun violence. Red flag laws, along with increased background checks and waiting periods on gun sales, and increased funding on mental health services that is found in the Bipartisan Safer Communities Act from the federal government, will fill the gaps in our safety, and they'll create a safety net. Since I've started doing this, I've actually started talking more about safety. There was a gentleman in our neighborhood. He had gotten a divorce. He was in crisis. We knew he had guns. He committed suicide with a firearm and left 2 girls behind. And nobody felt like that they could do anything. And this is before I started doing this work. I also had a friend more recently. Now that I've started doing this work, she has a brother who has PTSD. He's a veteran. And he went to Sig Sauer to use the gun range, which she was fine with. But she came to me not knowing that I was part of Moms Demand Action. And she goes, "What do I do?" And I said, "Call Sig Sauer. Tell them, don't sell them a gun." You know, the gun community is our partners in this. They won't do something dangerous. So I'm doing my part on educating people. I am. I'm starting to talk and saying, go to the police. Use them as your friend. I'll end with this. At a gun safety presentation, police officers who came to the meeting encouraged attendees to call the police if they know someone in crisis. Police can intervene, do a wellness check, and encourage the person to voluntarily relinquish their firearms. In Portsmouth, that has happened, and that does happen. And we have a great police department that the community has faith in and has the resources to do work like that. But not all communities do. And you can hear people come in, they don't trust their police. So wouldn't it be great if we could have a backup to the police so that they had a law that would back them up. I'm doing my part educating. The police are doing their part protecting the community. We need you to do your part in enacting these laws to keep our community safe. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much. The chair will call Robin Skudlaric. Did I get that correct?
You did. Skudlaric. I can't say it very well. She had to leave. I'm going to leave her testimony. She did want to highlight that she has a personal story that she would like to tell. Please, I highlighted it on the testimony.
Okay. Thank you very much. Okay, the chair will call, and I'm not sure what the name is. It looks like Paul. Yeah, Paul Markey. Okay.
My name is Paul Markey. I'm Vice President of New Hampshire Firearms Coalition. I testified on this bill 4 years ago when it came up in the House, and it's the same bill. And it was rejected then, and it should be rejected now for the same reasons. The people of New Hampshire don't want it. It was set aside as inexpedient to legislate, and we see this as an attempt to just keep bringing it up until somebody lets it slide. It's a compromise, and we don't compromise on gun rights. We can't compromise on any of our civil rights. This bill is especially egregious now because it gives anybody that wants to make a statement against you the power to remove your guns, just because they might think that you have a threat, you are a threat to someone or yourself. I don't see any path forward to it. Our guns are personal property. We have a right to own them. Gun owners in the state of New Hampshire that I know, and I know a lot of them, are responsible, and they don't want to see anybody get hurt any more than anyone else does, that's for sure. In the light of the willingness of our government to politically attack people using the legal system, I think again, a law like this is extremely dangerous and should be voted inexpedient to legislate. Thank you.
Thank you very much for your testimony. Are there any questions? Excuse me, sir. I'm going to ask you the same question I've asked every member of a gun group that's been here to testify. We've had testimony that in other states, laws were able to be passed because groups were brought together that were interested in this issue. Do you know if the New Hampshire Firearms Coalition received an invitation to work with folks on this bill?
I see all the correspondence that goes to the New Hampshire Firearms Coalition officially, and I've seen nothing requesting our help.
Okay, thank you very much, sir. We appreciate your time. Okay, let's see. Next, we're going to have Penny Dean. Let me know when you're ready, Ms. Dean, so I can start the timer.
Ready, set, go, and I'll try not to talk too fast, but I want to make my points. This bill is a bad DVP on steroids and worse than IEA. At least in IEA, you get an attorney. You don't get an attorney here. I don't trust the CDC data, and neither should you. A few years ago, Congress forbid them for many years from doing gun research. Why? Because they were anti-gun biased, and one year they said the murder rate went up for kids. Well, they didn't tell you until the small footnote that they put 19-year-olds in the kids category. So they're just quite frankly dishonest. I think that I look at this from a practical point of view. This bill, to me, looks worse than the other ones. And I didn't compare the prior versions line by line. This is off the back of my head. And if I were to go through line by line and tell you the defects, it would probably take me a good hour. One of the things first I want to talk about is found in the introductory paragraphs. And it talks about what a family member means. And specifically, they talk about on page 1, line 22, intimate partner, what they mean. And they go on to talk about law enforcement officers can bring this forth. Here's the problem. I think of swatting and people who have crushes on you because there's no time frame other than the past 24 months. So if you have a crush on me and we didn't consummate our relationship because I refused all your flowers and such, you can do the same as people do with swatting other people. That's a problem I see. When you go to page 2, lines 4 through 5, they allow you to commence that. If you live in Coos County, and I've never been in Coos County, you can present this in Coos County, and I've got to go up there and defend it. That's a basic jurisdictional problem, but this bill gives them jurisdiction. Furthermore, the specific allegations here, when they talk about person being prosecuted, prosecutors have absolute prosecutorial discretion. So even if it says here that those people are going to be prosecuted, you tell me which prosecutors are on board with this and when it's going to happen. The Pope will convert to Islam first. Won't happen. The other thing when we go through here, we talk about them on pages 2, anywhere from lines 14 to 17 and line 19 to 20. There's provisions in here where the, quote, victim is to circle pictures of the guns we have. Well, a victim doesn't know the difference probably between a 3-possession selector switch and a 2-possession selector switch. So I can see them circling one of them and saying, hey, you got full autos. You got to turn over your full autos. These are 3-position selector switches they circled. And I'm like, I don't have full autos. I got 2 autos. I got 2-position ones. That's a really dangerous thing, allowing them to do that in this bill. The other thing is, specifically on page 2, lines 28 through 35, I'll just put, yeah.
Just try to wrap
Okay,
it up. And
thank you.
please, if you have more pointed testimony, please write it up and send it in to us. It will be included in the public record, and we will all have an opportunity to read it.
This I will try to. It'll probably take a good 2 to 3 hours because there's a lot right here. They talk about a couple, 3 things, and I think of things as a practical trial attorney. The things that you need to look at is you are telling the clerk here to go left and go right. So these poor court clerks that are overburdened look at this and they say, this paragraph says this and this paragraph says this. What do I do? Just tell me what to do and I'll do it. But you have conflicting things. But this particularly here on notice, they say when we're walking in the courthouse door, as long as I'm given a written document showing me further claims of the victim, that I got to defend the client, that now I've got a copy on my notice. There's no way in heck you can prepare a notice. Furthermore, the 7 days that they have to hold this in, you talk to any litigator, which is what they want. You have a client call me and tell me I need to be ready to do a case and prepare it and have the time in 7 days. Not happening. Not happening. My clients in the domestic violence context, there's a provision in the bill where the accused can waive time limits. We regularly waive time limits up to 90 days so I can prepare a case. There's no provision in here, and a judge is going to say, and rightly so, sir, I'd like to give you that additional time, but the statute doesn't say so. So there's just a lot of fundamental fairness things in here that talks about, and one of the most dangerous things is they say that they can allow, with a court order, your firearms being given to an FFL. But then the procedure in here is that when the time comes, temporary, they say, to get your guns back, that the FFL has to turn them back over to the police department, who will then turn them over to you. No FFL on planet Earth is going to do that because they have to go in their bound books. And the other thing that I've got to ask is where they're going to store these things. I've had clients where I say, look, my client's going to turn over your guns. I can think of one police department, I said, bring 5 vans, 10, and this happens with many times, 10 men, and plan it on them working a double overnight. And department said, we don't have manpower like that. I said, you want all his guns and ammo, he's going to give them to you, but you have to come in and get them. That's you have no choice. So there's just, but I think there's a lot of procedural problems where you're telling clerks to do things that I don't know they can do, judges things that aren't reasonable to do. And I think there's some separation of powers problems here. And particularly—
Madam Chair, point of order.
I mean, most people have been very respectful.
Yes,
Oh,
I
I'm
know.
so sorry. Yes, ma'am.
But I was
Yes,
getting ready
Senator.
to do that, so.
Yes, Senator.
Thank you very much for your
Thank you.
testimony, Ms. Dean. Senator Abbas has a question.
Thank you, Madam Chair. And do you have a copy of the bill in front?
Yes, well, I have two versions. I had to print it out in bigger letters, and if you look at all my orange, greens, that's all the defects. But yes, I have a regular one too.
Follow up?
Yes, follow up.
So I'm on page 8, beginning on line 15. That has to do with the return and disposal of firearms. Basically, when an order is either not extended after, if the order's been issued but it's not extended, or it was vacated for whatever reason. Beginning on lines 25, which is 159-F:9B, talks about circumstances where the petitioner is now there, and then I guess I'm confused on how that hearing would play out. I don't know if you can offer any comment, because it seems that where I'm confused is the order that took the person's property away is gone.
Yep.
You're now in the courtroom trying to get it back.
Yep.
But the petitioner's there asking the order to be extended, reissued, but I guess if the order's been vacated or expired already, I'm not sure why, I'm not sure what's happening in that hearing. So
I call this dirty pool. They're getting two bites at the apple. And so what I've seen some courts do in this instance is you've already had a hearing, like you said, where it's vacated or dismissed. And now in every one of these cases throughout this bill here, every time you're gonna give the firearms back to the man or to the person, the person they've been taken from, the petitioner has to get notice. But there's one scary provision in here, and I can't point it to you without looking through it, that the petitioner has to get at least 30 days notice prior to the hearing. How can a court clerk know that they can notice a petitioner 30 days before? Because what if the petitioner's out of state, out of country, out of whatever? It doesn't say received. It doesn't say mailed. It says received. So what you're doing here is you're bringing the petitioner back in. And I have seen cases where judges will say, well, she's not comfortable with your having your firearms back. And I'm like, but the DVP is dismissed. The man is free to have firearms. And they've denied it because they don't feel comfortable with them getting them back.
Follow up?
just to clarify, even if the order itself has been vacated or not extended, the courts could still deny.
Yep. Yeah, I know you're going, that can't be happening. It happens. And here's the larger issue. A lot of people can't afford to appeal that. This is very expensive for a person to prepare for these type of hearings and credit thousands of dollars. And a lot of working class people don't have that much money. And so you're exactly right. So they have your property, and now you got to prove, if you look at the different provisions in here, you have to prove that it's yours and you should have it back, even though they took it from you.
Okay. Are there,
Thank you.
Are there any further questions? Seeing none. Thank you very much, Ms. Dean.
Thank you.
Okay, I've gone through the list of everyone who wished to speak. Are there any members of the public who would like to speak? You, sir, I'm sorry, you are? John, okay, let me look here. Okay, you didn't check that you wanted to speak. So come forward, we'll get you on the 3-minute timer and
Hello, my name's John Krasuski. I live up in Tilton. And I wanted to show you a different viewpoint, if I could. I had a story I was going to tell you. I wanted to tell you about my son, who was falsely accused of something. Ended up serving probation because he pleaded guilty because he had felt no choice. For me, it was a very difficult time. And I was very stressed. And I felt like I was getting very depressed. And don't hold this against me now. I moved from New York State. All right, so I moved, and all this was occurring in New York State. Well, New York State had a red flag law at the time, and these red flag laws are a slippery slope because in one of the parts of the New York State law, it said a physician could report you and say, "This guy, he needs to have his guns taken away." I'm a proud gun owner. I come here now, and that's my hobby. I'm retired. I used to work for the State Department. And I'm relaxed now. I can go out and shoot my firearms. But in New York State, And this, you could potentially change this law that you got to include physicians could report you. So I felt I needed help, but I was afraid to go to the doctor because I was afraid he was going to have to report me and they were going to come, the police officers were going to come to my door and take my guns away. I finally, after about 3 years, I struggled. I went to my physician and said, I need some medication. I need some sort of help. So he knew me. He says, okay, let's work with you. So we tried some medications. We found that it worked. And now everything's fine. But I feel that there's people, laws like this will prevent men and women from going out and seeking help. Because the issue here is mental health. And gun laws are just a way around. We need to find help for the people who need the help and encourage them to go to their doctors, encourage them to go to whoever, go talk to someone. Make it easier for those people to find help. That's all I want to say. Thank you.
Thank you very much for your testimony this evening. Are there any questions from the committee? Seeing none, thank you. Are there any other members of the public that would like to speak to Senate Bill 360? Okay, hold on. You, sir, are?
David Brawl.
Oh, okay. You didn't sign up here.
No.
I think there might be a sign up sheet in the back. Could you please go ahead and do that?
Okay.
For our records, and you, sir, are? Did you actually sign in here?
Yes.
Your name is?
I am Reverend Deacon Edward P. Munns.
Okay, let me see. It's just that these are the records that get included in the permanent record, so I just have to make sure. Are you Edward Munns?
Yes.
Okay, you had checked you didn't want to speak. So, okay, but that's not a problem.
I changed my mind.
You say, we all change our mind about things. So, sir, let me know when you're ready and I will go ahead and get the timer started.
Whenever you're ready.
Okay.
The Second Amendment, a well-regulated militia. Let's keep that word in mind, militia. Being necessary, that's another important word. To the security, another important word of a free state. The right of the people to keep and bear arms shall not be infringed. If that is the Second Amendment, then the question really is one about the security of other people because of too many guns in this country. If we look around the world, we can also see that we are the most country on the planet that has those kinds of weapons. There is no reason for that. There's no reason for an AR-15 rifle for deer hunting, unless you want deer hamburger. We have kids who are scared in school. I am a school teacher. They are afraid of somebody coming into the room and blowing them away. That is not okay. That is not the way the United States of America should take care of their people, particularly their young kids. There are too many mass killings in this country. Something has to happen about it. Now, whether it is a red line or a blue line or a pink line or whatever, the point is that we have too many people in this country who has too many weapons. And they're not necessarily for hunting. Certainly an AR-15 is not a hunting machine. It is something else. As a matter of fact, even in the Vietnam War, they did not have those kinds of weapons. Finally, if all of these weapons are okay to have, then perhaps we should have fire blowers. Should I have one of those? Or bombs? It's the same thing, isn't it? What we're doing is there's too many people who are afraid of even walking the streets. And it's not just in Buffalo or Connecticut or any other place. It can happen here as well. And we should do something about it. Thank you very much.
Thank you very much for your testimony, Reverend. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
And the chair will call David Brault.
Thank you for hearing my testimony. My name is David Brault, and I live in Salem, New Hampshire. And I've lived there for 4 years. And before that, I lived in New Mexico for many years. I am a retired psychotherapist. I was a psychotherapist for 50 years. And many of those years I worked at the University of New Mexico Department of Psychiatry, an outpatient clinic there. I'm a volunteer with Moms Demand Action and with Gun Sense New Hampshire. And I was a volunteer with Moms Demand Action in New Mexico since 2017. And there I was what they call the survivor lead, meaning that I interviewed the survivors, gun violence survivors that were members of Moms Demand Action. And that was quite an experience, talking to those people. And we had many survivors from the Las Vegas massacre. And the amount of trauma is unbelievable, as you can imagine. One woman that haunts me, her image haunts me, is a woman named Nina, who her son shot himself, a young adult son shot himself. And he, she was, I've been a therapist for a long time, but this may be the saddest person I've ever seen. Her sadness was just palpable. And she tried so hard to get her son to relinquish his gun, tried to get help doing it. She would switch into anger and rage, and mostly about therapists, because she tried to get therapists to help her get the guns away from her son, and it wasn't successful. So, that's just an image I have in my head that goes on and on. So one of the things that, this thing of 21 states and DC having these laws, strikes me as important. And one of the questions I've had is, what is going on in these states? What is actually happening with these laws in these states? What are they doing? What kind of cases are they seeing? We're hearing all kinds of speculation about what's going to happen, but we have 21 states that are actually doing it. So I found a document from Everytown for gun safety that has examples of how extreme laws save lives, extreme risk laws save lives. And this document presents 42 actual cases of extreme risk law cases in these, a number of these different states. And it's a very powerful document to me. And two things that strike me about this document and these cases is, one, how extreme they are, and that how real the danger is, that there's no mistaking. This isn't just like false allegations in custody cases or something. These are terribly scary, very violent cases. The second thing that impressed me about these documents is the sense of teamwork I got from them. Judges, family members, police officers working together to make these things happen, and the actual stories of the gun owners, relinquishing and feeling, that they are saved themselves and their family being saved. by these laws. So I recommend that the committee, read this document and look at actual cases that are happening around the country. Thank you very much.
Thank you very much for your testimony this evening. Are there questions from the committee? Thank you. If you can give that information to the committee secretary, he will ensure that every committee member gets it. Okay, we're going to go ahead and close the public hearing on Senate Bill 360. You guys need to take a break? You need to take a break? You want to keep going? Okay.
Take a break if needed.
Okay. If what? I really feel badly for Senator Ward. I am so. Okay. We're going to go ahead and open the final bill of the day. And I'd like to thank all of my committee members. We've been here since 9 o'clock and it's now 5:15. And I do want to apologize to Senator Ward. You've had to wait quite a while and I appreciate your patience. I'm going to go ahead and open the public hearing on Senate Bill 573. I'm going to announce, just like I did with the previous bill, and seeing the late hour, I'm going to give latitude to the prime sponsor to explain the bill to us. But after that, I'm going to be asking people to, if you have written testimony, please do not read it. Please do not repeat things that we have already heard. And you will be given 3 minutes of testimony. And I'm going to try really hard, but there are times when people, they're in a thought and you don't want to stop them. You want them to be able to finish their thought. So we're going to go ahead and get started and recognize Senator Ward. Thank you, Senator Ward.
Thank you very much, Madam Chair and members of the Judiciary Committee. It's been a very interesting and informative afternoon.
Senator, this is where all the fun happens.
That's right. So I'm introducing the Senate Bill 573, Parental Consent for Medical Care. This is a simple bill brought to resolve a growing, alarming, and inexcusable threat to parents' rights in New Hampshire. As I expect members of the committee already know, parents around the state have increasingly reported that their children are being given medical treatment of various kinds by public authorities and private medical practitioners without parental consent, treated in secret or, in the most truly bizarre cases, treated contrary to a parent's express wishes. In late 2022, the National Department of Public Health administered the flu vaccine to a 7-year-old girl with no parental consent form. When he was asked about this event, New Hampshire State epidemiologist Dr. Benjamin Chen publicly described this incident as a never event, a medical term for a breach so rare and severe that it should never occur. But it was not long before it happened again. This time, even more egregiously, in October of 22, the mother of a 5-year-old girl in Rochester was asked to sign off on her daughter's flu vaccination. Instead, the mother gave written notice to the school stating that her daughter, quote, will not be getting this shot. Please do not, I do not consent. The school received the notice and vaccinated her daughter anyway. I mention this case in particular because State Representative Jim Kofall personally reviewed the documents supporting this mother's account. In our legal system, parents have always been understood to have a natural and constitutional right to direct the upbringing of their children. Limiting that right has always required some specific evidence that individual parents are failing in their responsibilities. Yet, these reports are only one part of a disturbing trend. Public institutions, especially, are increasingly infringing on parental rights by effectively declaring all parents guilty until proven innocent. Parents' rights are being steadily stripped away by default and entrusted to state institutions. Schools and other public institutions may sometimes think they are the more trustworthy than many parents, but state employees and officials are every bit as human as the most irresponsible parent. And people with power, if left unchecked, have always been able to do greater harm than people without. This bill will legally prohibit any surgeries, examinations, medical prescriptions, or mental health practice upon a child without parental consent, except in a case of an emergency or when a parent cannot be located. The bill provides civil relief only, including declaratory judgment, compensatory damage, and reasonable attorney's fee. Our current laws and regulations have clearly failed to adequately protect parental rights, and there is no other reason to think these violations of parents' rights will stop if the general court does not act. Thank you.
Thank you very much, Senator Ward. Are there any questions for Senator Ward? Senator Whitley has a question.
Thank you, Madam Chair. Thank you again, Senator Ward, for sticking with us. I hear you loud and clear that the intention of this bill is to protect parents' rights, particularly when it comes to health care. You know, I do appreciate that as a parent of a 10-year-old. What I'm concerned with is just the unintended consequences of the bill, and I'm just wondering if, I want to raise these issues and to see if you have thought through these unintended consequences. The first is a population that I care really deeply about is our foster care youth. So under this bill, I'm concerned that in those situations, right, the state of New Hampshire is the legal guardian. So would that mean that someone from DHHS would have to go with, a 17-year-old to, go get birth control? Would someone from DHHS have to go with them to do that?
I hope I understand your question right. Unintended consequences, I don't know exactly, do you have an example of something like that?
Yeah, I'm concerned that this will impact our foster care youth and our state, and just it will mean that state employees will have to go to every doctor appointment and birth control appointment, even for a 17-year-old. That's the unintended consequence of them.
Well, I assume if the foster care youth, then foster parents will have the right to direct the medical care of their child.
Follow up? But not every foster youth is in a foster setting. Correct.
So who is the foster youth?
There are some children that are in residential settings. I think in a perfect world, all of our children would be in a foster care family, but that's just not the case. So there are children who are in residential care or elsewhere, and so that's the population I'm concerned with.
I have to admit, I do not know the legal standing of those children and where they are and how they are considered and who is considered their responsible caretaker. So you have to find out from somebody.
Thank you. Follow up?
Yes, follow up.
So the other unintended consequence that I'm concerned with is with our family planning program. So you may know that, and I would ask this to DHHS, but it's so late and I think that no one's here. You may know that Title X is the country's only national federally funded family planning program. So this is a critical program for particularly our low-income population. And so I'm concerned, I have heard concerns about the potential impact of this bill, the requiring of parental consent in all cases on our Title X funds, which do have a prohibition on that. So I'm not sure if you've thought through those consequences.
I don't think I'm the best person to answer that question.
Okay, thank you.
Are there further questions? Okay. Seeing none, thank you very much, Senator, and really thank you for hanging in there with us.
Thank you very much.
Okay, I'm looking to see if there's someone here from DHHS. I don't think so. They're not here. Okay, so we're gonna try to figure this out. Okay, okay, we have Courtney Tanner from Dartmouth Health. Maybe she can answer the questions. Thank you. I hope, Ms. Tanner, that you've heard Senator Whitley's questions. So if you can answer them, that would be terrific.
I have a sneaking suspicion somebody else will be able to answer the Title X questions.
Okay.
But I will address the first a little bit.
Okay.
I'll be as quick
Let me know when you're ready.
I'm ready. For the record, Courtney Tanner, Director of Government Relations at Dartmouth Health. And we do have some concerns with Senate Bill 573 as drafted. I just want to first address the intent of the bill. We, as you can imagine, in a variety of situations, and the vast majority of our families, we applaud and are really grateful for parental involvement, including parental consent, because that's a legal requirement. And so the concerns that I'm going to talk about a little bit right here are concerns with the interplay between state and federal statute. So I'm going to address 3 specific areas that we have some concerns about: abuse, population health, and then privacy balances. First, to address the abuse, unfortunately, there are small handful of circumstances where family involvement is not helpful, but it's actually harmful. You can imagine that there are cases in our state where physical and sexual abuse do happen, as you know, Senator Carson, with your time on our child welfare work. Dartmouth Health is home to CHAD, and CHAD is the only children's advocacy and protection program in the state. This is a multidisciplinary team that includes SANE nurses, social workers, child welfare specialists, and we treat the most severe sexual and physical abuse in the state. And we coordinate across hospitals across the state, including the Elliott. And so we do have concerns about what does that mean when a parent really shouldn't be involved in that type of critical care. There are also circumstances where foster parents, it does get a little bit gray, because there are times where there are foster children that parents still have medical rights, still have the ability to consent and should be consenting. And so there are times when there's child welfare involved families where those medical rights should still be with the parents, and they still should be consenting to treatment, including vaccines for their children. I'm not DCYF, but those cases do exist. The next is population health. And so further, as policymakers, you have a responsibility to balance interest. And we see this with population health. The New Hampshire legislature has restricted access to tobacco to persons who are over 21 and older rather. However, we do allow minors to navigate substance use disorder treatment when they are 12 years old and up. And we also allow minors who need access to diagnosis and treatment services for sexually transmitted diseases for those before they are 18 years old too. Finally, I'll just note that we have some questions about this bill. We believe that federal and state privacy and required to consent treatment provisions strike a balance as they are currently drafted, and we don't see a need for this bill. The balance between family participation in care and protection of vulnerable individuals, and we at Dartmouth Health would ensure compliance with all applicable laws and regulations. I'm happy to take questions. We do have some questions about the bill including, what is solicit to perform mean, and how would this law and this new law interact with some of our other provisions that we already have in place?
Okay. Thank you very much for your testimony. Are there questions? Senator Abbas.
Thank you, Madam Chair. If you look at line 13 on the very first page 1, it would prevent prescribing or dispensing any prescription drug or medication to a child, obviously without the parent's consent. I guess any circumstances you would say that it's appropriate to actually provide prescription medication to a child without the parent's consent in the first place?
So there may be circumstances where I would say the general rule is no, right? But there are probably exceptions to that general rule, and there are places in state and federal statute that contemplate that. But I'd say that again, the general rule is no.
Thank you.
Okay, are there any further questions? Senator Whitley?
Yeah, can you identify, just so we have it, those areas where, you know, what I'm getting from your testimony is that we already have this sort of balance in place, you know, we need to have those exceptions. The general rule is, of course, parental consent, but there are important exceptions. So can you identify what those are and where they are in state or federal law?
Well, I can't do that in this hearing because there's a lot of them, but there are circumstances, for example, navigating substance use disorder, navigating sexually transmitted diseases. Those are just two examples of state law. I do have questions that there are gray areas. For example, what happens when there are children who are navigating when there are children whose families are navigating termination of parental rights? Where do medical responsibilities lie? Is that a state? Is the child a ward of the state or not? There are just those really vulnerable families that are in the gray area for this, and I just couldn't answer that when reading the statute as drafted.
Follow up? You're a lawyer, right?
Yes, I play one on TV.
I know that because she was also an intern of mine. We've had a lot of former interns of mine in front of this committee. I asked that because, you know, don't you think that if you're having trouble sort of identifying, you know, you're in healthcare, you're a lawyer, and if you're having problems sort of figuring out these gray areas, particularly for vulnerable children, you know, wouldn't you think that other people would too?
Yeah, there's more questions than I can answer in this bill as drafted.
Okay, last question.
Last question.
Because I don't know who else to ask here. I'm curious about prenatal care and you know, going right up to birth. Again, you have experience of this very recently.
Yes, I do.
And how important prenatal care is. And also, you know, as you know, a lot of mothers make very conscious decisions about how they're going to give birth. I want to give birth at home. I want to give birth at the hospital. I want a midwife to be there. I don't want this family member to be there. How we give birth is a very, very personal an important decision that we make. So I'm thinking of, you know, a 17-year-old, right? 17-year-old becomes pregnant. They are a minor. They decide they want to continue the pregnancy. You know, is it that, you know, they have to get parental consent for their birth plan? How do we manage the logistics?
I think that's a question that I had when looking at this bill that really wasn't answered here. I would suspect that 17-year-old, when she became a mother, would be able to provide consent for her child. But that circumstance of a person who's under 18 years old giving birth is not clear to me here. I would still have some questions about that.
Thank you.
Okay, are there any further questions? Okay. Seeing none, thank you very much, Ms. Tanner. The chair will call Representative Selig.
Oh, she didn't want to speak, she said.
Oh,
She might have made a mistake.
okay. All right. We're going to go to Aubrey Friedman. Let me know when you're ready, Mr. Friedman.
I'm ready. Madam Chair, committee members, Aubrey Friedman. I'm from Bridgewater. I speak in support of this bill. I'm thinking more from like what is going on in our school, the SAU for the Newfound. We're having a lot of issues, you know, with the social emotional learning. They're rewriting the wellness policy stuff. They've included so here I'm thinking more about mental health services. I think for physical ones, if there's any referrals, they're getting parental permission. At least in ours. The bigger issue is the mental services. And this is, you know, they're adopting in our wellness policy, the WSCC, it's right from the CDC. All the wording is almost exactly word for word, but they changed it. The CDC, when it talks about the psychological counseling, we're talking mental services, CDC says counseling. And in our policy, they're changing it to brief counseling. So we've been asking this question, what is brief counseling? because where do you go over the line here? And getting into this mental services, it is currently unresolved, and we're having meetings on it, and we've got 2 Warren articles about the SEL. It's a whole commotion. So it seems to me, I've told our superintendent, who's like in the middle of this battle, it would seem to me the simplest thing is just get parental permission if there's any gray area at all, just get the parental permission. So I think there needs to be always parental permission, period. I mean, the parents are the ones who are responsible for their children. And there's no getting around it as far as the question about the foster thing. Well, if the state is taking the children, there is a foster family. Okay, maybe they're in an institution. There's got to be parents there or adults there. So I would think they would have to sign up. Again, I'm not an expert on that, but somebody is over the child until they're 18. So I would think that person would sign it. There's somebody's got to be responsible for that child until they're 18. And you must get parental consent. I just think in our school district, there's a hostility with parents, and they're bad, and they'll do this and that, and it's really bad that parents are disparaged terribly. So I think it's just a basic thing. When in doubt, get parental permission. And, I know the counseling people and all that, they feel sometimes the parents may not agree to it, but they're kind of, well, we should get it's safer actually for the school district. And that's it. So I support the bill.
Thank you very much for your testimony, Mr. Friedman. Are there any questions from the committee? Seeing none, thank you very much. The chair will go to Jake Berry.
Good afternoon, Madam Chair, honorable members of the committee. I promise I'll be very brief. I'm Jake Berry from New Futures. We're a nonpartisan, nonprofit health policy and advocacy organization. I do want to express some strong concerns that New Futures holds about this bill. The fact is that our children need access to mental health services more now than ever. Recent data from the Youth Risk Behavioral Survey shows that 1 out of every 10 high school students has seriously contemplated suicide. This is 2021 data, the most recent available, and 1/4 of high school students have 1/4 of it have contemplated suicide. 1 out of every 10 has actually attempted suicide. Between 2019 and 2022, we lost 22 youths, minors under the age of 21 to substance use, to overdose. Our state has done a good job of recognizing the need to increase access to treatment for these kids. We have extended, we have adopted the 988 suicide prevention hotline. We've extended mobile crisis services, and we would hate to see anything that would interrupt, I hate to pass anything that would interrupt access to these services, as this bill may very well do. In the vast majority of cases, we want to believe that parents are really key partners in helping their kids access the mental health services, the behavioral health services they need. But the fact is, in some cases, they're not. They're more of a roadblock. Oftentimes, kids are not willing or not able to talk about what they are facing with their own parents and need other support. Sometimes parents are not ready to hear it, and sometimes parents just are not present and able to offer consent the way that we need to. These children still need to be able to offer the treatment services to address these conditions. Otherwise, they're going to follow them throughout their lives. With that, I'm happy to take questions.
Thank you very much for your testimony, Mr. Berry. Are there any questions from the committee? Senator Abbas.
Thank you, Madam Chair. And thank you for taking my question. Sure. Can you walk me through, under the current law, if a child who's a minor and wants to get mental health treatment without a parent's consent, how exactly is that happening?
So there is, we treat substance use differently from mental health. There are other folks who might be able to answer more on the mental health side than I can. I believe that for people for kids looking to access substance use treatment, that over the age of 12, they do not need parental consent. And at this, we feel that that's critical, and that some of these children are coming from families where their parents have been, have been experiencing substance use disorder. Some of them still are, and are not able to, again, face their condition and support treatment for themselves or their children in the same way. And we think it's critical that these children continue to be able to access these services.
Follow-up?
Thank you. But your testimony was that you don't want to create any roadblocks for children to get mental health treatment. So I'm asking, how are the minors, the children, getting this mental health treatment in the first place without the parents' consent? And my other concern is, if that's happening, how is it going to be facilitated regularly? How are they going to pay for it? How's this? Just walk me through how this is even being done.
Again, I'm thinking there are other folks in the room who are mental health clinicians themselves who may be able to speak more to it. But I'm happy to look into it and get back to some.
Thank you.
Are there any further questions? Senator Gannon.
Thanks for taking my question, Mr. Barry. Aren't the outcomes much higher for children whose parents participate and are part of the process? Aren't the outcomes much less for children who go it alone and don't get their parents' involvement?
Thank you for the question, Senator. I don't have the data in front of me, but certainly it's safe to say in the vast majority of cases, the parents are an absolutely critical partner, and we want them to be there present every step along the way when they're available and when they're able to be supportive in that way. But that's not always the case.
Right. Senator Abbott, I know it's been a long day.
Thank you. I understand what you're saying in regards to mental health treatment, but is there any objection to the section that involves surgical procedures?
No, I would say we are, New Futures was founded primarily to address behavioral health concerns, and so that's what I was speaking primarily on. We certainly do have concerns about access to reproductive and sexual health services for folks. I know there are other people in the room who will speak to that more, but those are certainly concerns that we share.
Thank you.
Are there any further questions? Seeing none. Thank you very much, Mr. Barry.
Thank you.
The chair will call Jackie Abakoff. Let me know when you're ready, Ms. Abakoff, so get this trying to start.
Is this on? Yes.
Yes, it is.
Okay, I'm ready. All right, good evening. It is evening, isn't it? Yes.
Yeah, it is.
And thank you for allowing me to speak to you today. My name is Jackie Abakoff. I'm here representing the New Hampshire Alcohol and Drug Abuse Counselors Association. So perhaps I might be able to answer some of the questions that you brought up. I'm also a clinician, a social worker, a substance use clinician, a social worker, and I have been working in the field for very close to 50 years. I do program development, I do administration, I do clinical work, and I supervise a lot of programs around the state. So I'm familiar with different programs and how they do things. So clearly, you heard from Mr. Barry that in the substance use disorder field, children are permitted to access treatment without parental consent at the age of 12. What I'd like to assure you in the position of the Counselors Association and the ethics that drives the profession of substance use disorder treatment really speaks to the fact that we understand that this is a family illness and that it is critical to have parents and family members involved whenever possible. It is highly unusual that a child seeking treatment without parental consent is doing so for any reason other than fear. That fear may be of abuse. That fear may often be about harming the parents because they may say something about the parent's substance use that they believe will get their parent arrested or in trouble somehow or cause them to lose custody of the children, and they don't want to see that happen. It's a very frightening situation, both for parents and for children, that the ability for the child to access treatment with both without having to go through the parent and risk being told, don't tell our secrets, or risk being physically harmed by that parent, and it's both ends. And the ability for the child to be able to talk with a counselor without fear that their parent is going to be notified helps that child share information that in the long run may wind up getting the entire family help. It is not the goal of substance use disorder or mental health counselors to serve as a wedge between the parent and the child. It is the goal of those counselors to work with the child at trying to get at what is getting in the way and how do we get your parents involved, because the outcomes will be better. And that what we find is that most kids who come without parental consent, and there are very few, I will tell you that right now. But those who do come because their friends, their neighbors, their aunts or uncles, their teachers have encouraged them to do that. And when they come scared. And it is our job to help them sort through, how do we talk to your parents? Is it safe to talk to your parents? And how do we get them involved so as to improve the outcomes, not just for you, but for the family as a whole?
Thank you very much for your testimony this evening. Are there any questions from the committee? Senator Abbas.
Thank you. Is your objection only to the mental health treatment and the substance abuse treatment section?
Yes.
Thank you.
Okay, are there any further questions? Seeing none, thank you very much for your testimony. The chair will call Anne Marie Banfield. I think, okay, it's here. Okay, next we will call Nancy Biederman.
You got it correct.
Let me know when you're ready.
Yeah, sure. Hi, Nancy Biederman. I was just appointed the parent representative for the Rare Disease Advocacy Council by the governor last week. Just to let you know that, I'm speaking on my own. I'm not speaking for the council. Something that everyone up here that's already testified said they're not trying to put a wedge between parents and children. I don't believe that. Dartmouth Hitchcock, when my daughter was a patient there at the age of 13, we got emails saying, yep, you need to change your portal, email, username and everything. And, it's just yours now. Don't let your mom have it. And don't let your parents know it. And then constantly, if I used the portal and asked a question of the doctor, because my daughter was very sick and her concepts and understanding of what was happening to her medically and what needed to be asked of the doctor was not there at age of 13, they would get upset with me if I was the one writing the email and asking questions. And instead of trying to work with us as a group, we got told, no, we just want to hear just from your daughter. And I'm like, she's 13, she's in pain, that's not going to happen. So when I hear testimony saying that, yes, the doctors are working with the family, they don't always. And to sit there and send an email to my daughter at 13 and saying that you need to change your password and not let your parents have access to the portal anymore, I don't think that's being helpful. I'm here mostly on the medical part. Yes, if there's an emergency situation, yes, they have every right if there's an emergency situation. But with my child with a rare disease, for any doctor to move forward just because they couldn't get hold of me, that's the part of the bill I do not appreciate. That just needs to be taken out because that lets in too much of a loophole in saying, we didn't get hold of you. No, you can get hold of every parent, especially these days. And not every doctor can understand the complex issues of rare disease. My daughter sees 8 doctors. And Dr. A does not know what Dr. Z knows about it because they don't bother to read all of the records and understand how this part and this part work together. So, and I do, and I have all the information, but one doctor doesn't have it all. And especially when you have a rare disease, somebody in the emergency room does not understand any of the unintended consequences. If they give my daughter an IV bag that's not been warmed, she will go into anaphylactic shock. So, and if she's in an emergency situation, she's not going to be able to convey that information. So again, I'm for this bill other than the part where they said that the parent, that unless the parent's been notified. If it's not an emergency situation, if she's breathing, if the blood is flowing and circulation's going, there's no need for them to rush into any medical procedure or anything without the parent being there to consent.
Thank you very much for your testimony. Are there any questions? Senator Abbas.
Thank you, Madam Chair. You heard some testimony from prior witnesses with concerns about substance abuse and like sexually transmitted diseases as perhaps a potential exception to this policy, which it may already be an exception for, but either way, would you oppose any amendment that would satisfy some of those concerns?
I think the parent should be involved in any decision because especially if birth control. I mean, there are children that don't know their entire family history medically. And even my daughter, with being everything that we've gone through medically, she's not going to remember that there's possibly a blood clotting issue in our family or that there's a heart disease issue when she's talking to her doctor about possibly getting birth control. She won't remember that. And most 17-year-olds don't. They don't know their family history or their medical history. And if they haven't talked and the parent's not involved, and then that child takes birth control and has a stroke or has a heart issue because of the birth control, then who's liable at that point?
Thank you.
Yeah.
Are there any further questions? Thank you for your testimony. I just, it might be because it's late and it's probably a silly point.
That's
but
okay.
I'm also the parent of, she's an adult.
Mine is
with
too now.
Severe issues, physical issues. And, the more that I hear from the public and advocates about what's going on out in society today, I can see the erosion of parental rights taking place over time. So my question to you is, do you foresee a time where a parent is going to have to go to court in order to get legal guardianship of that child in order to have their rights as a parent recognized?
It's already happened in Boston. In Boston Children's Hospital, they took a child and decided the parent had no right over deciding what that child should and shouldn't have. We've had many cases where the hospital and the medical personnel have decided to take children off life support against the parents' wishes. There's case after case after case, and we wouldn't have to, have a bill like this if the relationship between the medical society and parents was good. At this point, medical personnel, school counselors, they've all stepped over the line. And they've assumed and tried to take over the parents' role. And we've heard it time and time again that the parents are the bad guys and that the medical personnel and the counselors are the good guys and they do no harm and do no wrong. Well, I hate to say they do harm and they do wrong. And I've seen many cases of it that the counselors and the doctors have done wrong.
Thank you very much for your testimony, and thank you for answering the question Senator Abbas has.
Thank you, Madam Chair. If you have the bill in front of you on line 29, it talks about, this is really has to do with the enforcement side, and it does say that under a parent who successfully asserts a claim or defense under this chapter may recover, and it lists all sorts of things, including reasonable attorney fees. My interpretation of that is the court has the discretion to award legal fees, but would you be opposed to any change of language to mandating that legal fees can be recovered?
I think if the parent has to endure any legal fees or any fees whatsoever in protecting their child, it should be they should be received back to the parent.
Thank you.
Okay.
Hey, any last questions for this?
I play a doctor on TV, not a lawyer, but I do the doctor thing. So
thank you very much for your
thank
testimony.
you very much for your
this
time, and thank you for staying late.
evening. The chair will call Melissa Blasik.
Thank you, Madam Chair, members of the committee. I'm Melissa Blasik. I am from Merrimack, New Hampshire, and I am here as the Executive Director of Rebuild New Hampshire. We are neutral on this bill at the moment. We support the concept of the bill, but feel that it does need amendment. Otherwise, it could potentially be almost a step back in parental consent, particularly Section 2B. So Section 2A spells out the exemption, like the exception to the law is in case of emergency, right? To protect the child from death or imminent irreversible physical injury to the child. Obviously, this is very necessary, right? However, Section B reads that a parent of the child cannot be located or contacted after a reasonably diligent effort. This pretty much negates all parental consent. Anyone could just say that they made a diligent effort. What does diligent mean? I don't know. So if that section is struck, we would be a lot more apt to support this legislation. Section 1 is also concerning, it uses the term blanket exemption. Unfortunately, what occurs is that a parent will sometimes fill out a form, say at the beginning of a school year, right? This has actually happened. I had a parent contact me a couple of months ago saying that their daughter had received a dental exam in school and she had not specifically consented to it. When she called the principal and asked, the principal said, well, you signed a form at the beginning giving consent for all exams and treatment. And she was like, oh, okay. That's an example of a blanket exemption, right? That is not real informed consent. They don't really know what they're consenting to, right? So I do believe that if we're really going to strengthen parental consent, it needs to be specified for each procedure or exam individually. If those changes are made, we would be happy to support this legislation.
Okay. Thank you very much for your testimony. Are there any questions from the committee? Senator Abbas.
Thank you, Madam Chair. I asked the previous witness a question about line 29, changing the may to shall. And I guess my point is that legal fees can be expensive, and to perhaps entice someone to represent the family in this, the may versus shall to me would be a very big deterrent or comes to enforcing it. Because the recovery of damage is one thing, but legal costs can sometimes exceed your damages.
No, I agree with you. Yep.
You would be supportive of such an amendment?
Yes.
Thank you.
Any further questions? Okay, seeing none, thank you very much.
Thank you.
The chair will call Ben Bradley. Let me know when you're ready, Mr. Bradley.
I'm ready. Thank you, Madam Chair. For the record, Ben Bradley, Vice President, State Government Relations for the New Hampshire Hospital Association. Just a quick note, I am not Kathy Bizarro-Thunberg as indicated in the written testimony. Kathy was able to go home and I volunteered to stay so that I could provide testimony.
Okay.
I'm not going to cover what has already been said. I think you are perfectly capable of reading my testimony. But I do want to reiterate that we completely agree with the general principle that parents are responsible for providing and coordinating medical care for their minor children and are presumed to act in their best interest. The vast majority of parents absolutely act in their child's best interest. The reason there are these exemptions is for those exceptions. And state law and federal law recognize that, as well as certain regulations, as Senator Whitley had pointed out. So not just in statute, but also in rulemaking. I provide an example here in my testimony on when it may be appropriate for a provider to recognize child abuse and neglect and have an ability within their professional judgment to protect the minor child and ensure that that healthcare provider fulfills their professional obligation to report on any suspicion of child abuse and neglect. There are a couple of other things that have been outlined by others, but just want to reiterate a little bit of ambiguity in the language around soliciting to perform or arranging for the performance of. It's unclear whether general medical information provided to the public or directed to local households about various care options would be considered soliciting to perform and therefore be out of compliance with this bill. I'm happy to try to take questions. I know it's late, and I'm more than happy to follow up if you would prefer to just follow up with me.
Okay. Thank you very much for your testimony, Mr. Bradley. Are there any questions? Senator Whitley.
Thank you, Madam Chair. So what I am concerned with is that we have identified a problem, but maybe this bill isn't the solution. And what I heard from previous testimony is that we already have sort of this, we already have existing law to both protect parental rights, require parental consent, yet carve out these situations that are important to protect the minor child, and that those exceptions are defined in law already and that this bill is unnecessary. And so, you know, would you agree with that? And that this sort of like, if this passes, how do we square it with all that other stuff?
So I'll leave that second question
Yeah.
to the legislature's contemplation because I think it's an important question to ask that I don't have an answer to. To your first point about existing law, statute, regulations, rules, whatever it may be that affords those exceptions, I think my point here is that although the vast majority of parents have the best interests of their children, there may be exceptions. And you know, I don't know that we're going to be able to go over all of those in a committee hearing this late in the evening, but it's something to think about and contemplate what the effect of this type of bill would be. I don't know how you square it.
Follow up? Yeah. And then again, we don't have DHHS here, so I'm sorry I'm asking you this question, but do you have any thoughts about this issue? What do we do about the kids that are in state custody if this passes?
So I don't have a concrete answer for you. I think that providers are going to make every effort to, it's my belief that providers do have the best interest of ensuring parents are involved. And I think to the previous testimony of the woman who has been intimately involved with her child's health care, it's provided value. And I think providers recognize that it's important to have somebody with you along the way. I don't know what will happen if the state, you know, you think about delays. Would there be a delay in consent if the state is tied up or busy? You know, it's something that the legislature has to contemplate. It's a fair question, in my opinion, to ask, but I'm not sure I have an answer for you, and that's part of the concern.
Thank you.
Are there any further questions? Senator Abetz.
Thank you, Madam Chair. So the very first sentence of where it begins, lines 5 and 6, it says, except as otherwise provided by statute or court order. Then the rest of this could be applicable, and then it actually has 2 more exceptions. But either way, I guess if a child's in state custody, I would assume there was some type of order of the court, some legal action for that to happen, and wouldn't that be addressed in that circumstance?
I think when you're enacting legislation, clarity is so important, and when it's ambiguous, and we just are asking these questions, it's worth exploring some more. So I don't have an answer for whether that blanket statement about unless otherwise afforded in statute covers everything. I don't know that to be true. And I think it's worth the committee's consideration because I don't have an answer.
Thank you.
Okay, are there any further questions? Seeing none, thank you very much.
Thank you,
Mr.
Madam
Berger.
Chair.
The chair will call Lynn Courier Stanley.
Thank you, Madam Chair, and members of the committee for hearing my testimony today. I will try to be very brief. For the record, my name is Lynn Courier Stanley. I am a social worker and I am the executive director of the National Association of Social Workers, New Hampshire chapter. I am a licensed independent clinical social worker who do not see clients, and I live in Pennacook. For the most part, this bill has no effect on social workers because social workers who are seeing minors, they get informed consent, parents sign off. Oftentimes there's insurance papers that need to be filled out. Not an issue, and it's not, this bill would not change any of that. However, for our school social workers, it would have a chilling effect on their ability to provide supportive services to students. The role of the school social worker is to reduce barriers to students being able to fully access their education, whatever that barrier might be. For those students who are receiving therapeutic mental health services within the school, parents have already given consent. Usually it's through their IEP, their individualized education plan, their 504, whatever it is. The parents have signed on and have given consent. However, oftentimes the school social worker will have students come up to them and say, hey, can I talk to you for a minute? And if this bill passes, their answer is going to have to be no, because they don't know they don't know what it is, and being able to provide those supportive services and do some assessment and make some referral, that's part of the school social worker's job. However, the way that this bill would make it so they could not do that without having to say, oh, I can't talk to you until, first of all, I've gotten consent from mom or dad. And what does that look like? Is that an email? Is that a phone call? Is that a piece of paper? And at best, it inconveniences students who are okay but need a little bit of help. At worst, it really puts our most vulnerable kids at risk. That is the end of my testimony. I'm happy to answer any questions that you might have.
Thank you very much for your testimony. Are there any questions? Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. You raised another question for me, and I'm actually thinking about a very personal situation. I have a 10-year-old. He just started a new school, public school. He, loves to go to the school nurse, and he finds comfort there, right? If something is hard going on in class. Sometimes she just talks to him. Sometimes she gives him, a warm ice or a warm thing for his belly or an ice pack for something. Does she need to call me under this bill, does she need to call me every time she gives my son an ice pack or gives my son, some encouraging, potentially clinical involvement? Does she need to call me every single time she does
Yeah,
that?
that's outside of I would hope that the school nurses would be able to provide some testimony. I would hope but that's also part of that blanket, because I also remember signing those forms at the beginning of the school year, that huge packet of forms, where you say, oh, can you give them a Tums? Can you give them an Advil? That sort of thing. So I'm not sure if it would have that kind of an impact that every time. And that's rather sad, because one of the greatest protective factors for kids is caring and supportive adults. Sometimes that's the school nurse, sometimes that's the school social worker, sometimes that's the coach, sometimes that's the teacher, because they spend so much time in school, but it's also after school people. And so if those supportive and caring adults are not available because they're afraid of stepping over a line, and is it gone from being supportive to more therapeutic, which can happen pretty quickly, and then referrals need to be made, that's not helping our students. For the most part, parents are involved with their kids. They know what's going on. And Senator Gannon, one of the points that you had brought up, and I apologize if I'm going over, about your the parents who are involved and the parents who aren't, I think I completely agree with you, except that I think the correlation is backwards, that the parents who are, the children whose parents are the least involved are in most need of those supportive and caring adults around them. Does that make sense? Maybe we don't remember the question before, and it's a long day for you. So thank you.
Are there any further questions? I just would like your opinion on something.
Sure.
We've had testimony about the blanket statement that's included, that a parent will just check the box, but they don't know exactly what that means, that they don't know that their child can get this, 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 and this. Do you think it would be important that in all those papers that a parent signs, that there's a larger form that says these are the services we can provide your child, and then have the parent click off the ones that they want their child to receive? So my good friend on this committee said her son likes to go to the nurse, that she can click it off and say, I'm okay with this.
Yeah.
So do you think that would help to solve the problem?
I'm not sure if I should thank you for that question, but thank you for the question. I'm not sure. Okay. I think for some parents, I think Senator Whitley would go in there very carefully she's an attorney. She would look to see what she was signing and making sure that it was all right. I will admit there were times when my kid was growing up and I had that huge stack and I had to fill out 2 of them. Maybe I didn't look at it as closely as I should have. Does that make sense? And I think for some students, schools struggle to get any of that paperwork in the first place. It's all over the place.
Thank you.
That's probably not the answer.
No,
you wanted.
if anything, I appreciate your honesty.
Thank you.
Are there any further questions? Seeing none, thank you. The chair will call Kayla Montgomery and Liz Canada. These are the last individuals who have signed up to speak. And seeing how quickly the room has cleared out, I really think these are the last folks who would like to testify. Thank you and good evening. Thank you for hanging in there with us. And I see you have written testimony, which is even better because we are not execing this bill today. So
I know you both have little people.
yes,
We do.
you do.
Luckily,
And
our partners are on it. So, but
that's the good
but
part.
thank you all. You have been. It's been a long day for you all, certainly.
Yeah, I know
You have little people too.
You do.
I have 2 little ones
Lots
at
of little
home.
people that need parents home with them.
I've been texting my better half, explaining where I'm at.
Okay.
I told her to put on the YouTube.
Okay, let me know when you're ready and we'll, okay.
Certainly. Thank you, members of the committee. My name is Kayla Montgomery. I'm the Vice President of Public Affairs for Planned Parenthood of Northern New England. When we were here before you last time, feels like a long time ago, but I think it was only last week. We talked a little bit about some of the people that we serve. So just some examples. 10% of the patients that we serve are men. 10% of the patients are over 40, and about 12% are teens. And the majority of our patients come in for family planning services. Planned Parenthood, 3-state organization, Maine, Vermont, New Hampshire, and Planned Parenthood of Northern New England is in the National Title X program. Now that, I know it's already come up a little bit, but that is a competitive federal grant for agencies who provide preventative sexual and reproductive health care, and that's contraception, cancer screenings, STI testing and treatment for low-income individuals. And Title X grantees are all required to submit data to a family planning annual report, which is published online. I didn't print it because it's like 200 pages, but you can see it. And we oppose this bill because it would deeply impact the confidential services that we've been providing for decades to adolescents under this Title X program. So just real quick history on the program. It started in 1970 under the Nixon administration with strong bipartisan support. He said, quote, "No American woman should be denied access to family planning assistance because of her economic condition." And that was in 1970. Very soon after, in 1972, Planned Parenthood of Northern New England joined this program. So we have been following these federal rules and guidelines in the Title X program since 1972. And in these last 50 years, since this program has been established in America, it has been incredibly successful at not only preventing millions of unintended pregnancies, but also keeping low-income individuals healthy, because when someone comes in for birth control services, they're also offered related health services like STI testing. And part of this federal Title X program is there is a guarantee of confidentiality for all patients who receive these services, including adolescents. And this confidentiality piece, it is well-grounded in medical and ethical standards. Research shows that without access to confidential care, many adolescents would not seek needed health services because of fear and judgment by parents or guardians. Just real quickly, the practices at Planned Parenthood regarding adolescents, our intake procedures for adolescents are deeply rooted in parental involvement. It is a part of every appointment with an adolescent, regardless of service, regardless of whether it is the law or not. Our clinicians are highly trained in having conversations with these patients regarding encouraging parental involvement in all their healthcare decisions. They support patients who may need some help talking with their parents. And we take this very seriously. And we also know that the vast majority of teenagers do involve their parents when it comes to their sexual health. But we know that there's evidence that shows that young people would sometimes choose not to use birth control and not receive STI services if they were unable to receive them confidentially. And they would, of course, continue to remain sexually active. We also have a few questions, but my timer went off, so I'm going to pass it to Liz.
Yeah, I have 3 minutes too.
Yes, please.
Thank you. Thank you. So for the record, Liz Canada, Advocacy Director of Planned Parenthood New Hampshire Action Fund, Planned Parenthood Northern New England. Right now in Texas, there are 0 teenagers who can access confidential birth control. And that's not an exaggeration. Literally 0 teenagers can do that in Texas right now. Because there's a court case called Deenda versus Becerra, in which a father of 2 daughters sued because his daughters could access confidential birth control without his consent. Not because they tried to, but because they could under the Title X program. Because it is allowable, as Kayla was saying, it is allowable under Title X, and it's a requirement under Title X to do so. So again, Title X is family planning, it's preventative health care, it is birth control, cancer screenings, and STI testing and treatment. It cannot and does not cover abortion at all. So that's what we're talking about here under Title X. New Hampshire has one of the lowest teen pregnancy rates in the country. It actually has the lowest. So to go back to Texas for a moment, this case that was brought forward, it was brought forward by the same person who wrote up the Texas abortion ban that's in place right now that has the bounty hunter provision. This is the same individual who brought forward this case as well. And late last year, Judge Kaczmarek entered summary judgment, and that is why right now there are no teens in Texas who are able to access confidential birth control. So here's some of the impact of that combination package, the abortion ban and the lack of confidential birth control. This week, like literally 3 days ago, a report came out showing that teen birth rates in Texas have gone up for the first time in 15 years. And that Texas teenagers are giving birth at a rate that is 46% higher than the national average. Again, New Hampshire has the lowest teen birth rate. That is really important to know about our state because our state has historically prioritized family planning and funding family planning providers. With that, and I would not be doing my job if I didn't say the Executive Council has defunded the providers who also offer abortion care. And so these things all add up together. We should not be emulating what is happening in Texas right now. It is really devastating. And so we firmly believe in parental involvement. As Kayla said, it is part of every single appointment for a teenager at Planned Parenthood. And also, teenagers deserve to have the ability to access confidential birth control to control their own lives and bodies and future. So we urge you to vote inexpedient to legislate on Senate Bill 573.
Thank you very much for your testimony, both of you, Ms. Montgomery and Ms. Canada. Senator Whitley has a question.
Thank you, Madam Chair. And thank you for providing that very stark picture of what could happen. And I think that's very important for us to know as we set policy. So am I correct in hearing that what this bill is doing is not permitted under Title X? And if we pass this, we could lose Title X dollars?
It is correct that under Title X, confidentiality is a key piece of that, including for adolescents. I don't know if that means that New Hampshire would not be allowed to participate in the Title X program. Again, that's not just for Planned Parenthood, that's other providers who are in the program. It's millions of dollars that comes in. I don't know if that means we'd be rejected. I think that would be a question for DHHS, but it certainly is something that deeply worries us and would be very concerning.
Can I add one thing to that? So Title X requires confidentiality. It also requires encouraging parental involvement. That is also part of the program. So all of the providers, Planned Parenthood Northern New England is one. There are providers in different areas of the state who don't offer abortion, for example, but they are required to offer confidential services to all patients, including teenagers, and to encourage parental involvement. So the folks who work at Planned Parenthood of Northern New England, they are trained to have those conversations to help support teens to be able to talk to their parents if they're not ready to yet. That is part of every single appointment at Planned Parenthood.
Follow up? And how much money, maybe you don't know this, but how much money does New Hampshire get from Title X?
Planned Parenthood receives from the federal Title X program about $5 by about $500,000 per year as a direct grantee, but that is just Planned Parenthood of Northern New England. The money that comes to the state of New Hampshire is the second direct grantee of federal Title X dollars, and that money then goes before the Executive Council, and that goes to, for those providers who get it, it's probably another, I don't know.
Get that number.
Yeah, but it is not just for Planned Parenthood is the point of that.
But it's in the millions.
Mhm.
Okay, last question.
Yes, last question.
I'm concerned, I'm staying with family planning and all those services that are part of it. And I'm particularly concerned because Senator Carson it's not funny, but Senator Carson and I have heard these troubling statistics about the rise of STI in teens. Is that correct?
Thank you for the question. And STI rates are on the rise for everyone across the board. STI rates don't care your age or your party or your gender. And it is scary. It is very scary. We're seeing a trend in a direction that that's not looking good. We're also seeing a drug-resistant strain of gonorrhea has first appeared in New England about a year ago. It started appearing. So certainly something that we're keeping an eye on. And I would say outside of the scope of STIs, there's also a few services that we provide that wouldn't necessarily fall under STIs that we do have a question about. The one that I keep coming back to in my mind is maybe a 17-year-old comes in with a yeast infection or a urinary tract infection. Those are not STIs. You can get that from many different things. Would that require parental notification for something that maybe is available over the counter, but would be costly for the teen to go over the counter, where we can provide that for a teenager at no cost.
Thank you.
Are there any further questions? Senator Abbas.
Thank you, Madam Chair. I understand some of the concerns raised about the Title X issue, but if we just put something in here to perhaps exempt anything that relates to Title X from this policy, would that satisfy the concerns you have?
It would certainly help, but like I just mentioned, there's other services that we provide, like, a 17-year-old coming in with a urinary tract infection that wouldn't cover it. Sexual and reproductive health is certainly wider than Title X contraception.
Thank you.
Okay, are there any further questions? I just have a couple things. If you could provide us with those figures, that would be terrific. And thank you for giving us a better understanding of what Title X is, because that information that came up, and I think my colleague had asked about Title X. So I think having that background is great. One thing you have in your testimony, it says Senate Bill 573 flies in the face of Granite State values, as New Hampshire law has long allowed for broad access to health care for young people without necessary barriers. Do you think that part of the problem is what health care is today, that it's not just going to the nurse or maybe something that was covered under Title X? It's more, because we've heard all kinds of services that are being provided by schools that parents really were not informed about. So do you think that that's part of the problem, is just the expansion of what schools are doing? And I had mentioned, instead of a blanket exemption, that there's a list of services that a school can provide for a parent, and they can check off what they think is appropriate for their child. Do you think that that would be helpful?
Well, I mean, we certainly wouldn't want to speak for schools. That's definitely outside of our purview. And I would say, this is a program that has been working and New Hampshire has been under for 50 years. And and we know it works because we see the low teen pregnancy rates. So I think that is part of our values, that we've been in this program for such a long time and we know it works. Yes, things change. Healthcare evolves. We know that. Birth control evolves. When it first started, it was pill only, and now most people choose a long-acting reversible contraception where they can have it inserted by a trained clinician at Planned Parenthood and then not have to think about their birth control options for 10 years. I mean, it's it's always evolving, it's always changing. So I think, of course, you know, we should be looking at these things always. But what hasn't changed is that people have sex and teenagers have sex, and we want to make sure that people are doing it safely.
Okay, thank you very much. Any further questions? Senator Abbas.
Thank you.
Do you have?
Is there any issue with the section on involves the surgical procedures requiring parental consent?
So that's beyond what Planned Parenthood offers. So, you know, the other components of it, the other sections, there's the part about like, if I had the bill in front of me, I could read it directly for you. That would really allude to not being able to even schedule an appointment for a teen, like the part of arranging for the performance of, you know, a physical or a medical examination. That means that even a teen or, you know, their aunt or uncle wouldn't be able to call and schedule without parental consent. So like it is very far reaching, this bill. We've got a lot of concerns about it in that way. But the surgery piece is beyond what Planned Parenthood offers.
Thank you.
Okay, any further questions? Senator Gannon.
Just a little question. On your birth rate, does that just include American citizens in Texas? You're saying they don't have the birth control options and stuff. Is that American citizens or everyone in Texas?
I don't know that I have that exact figure, but I can send you the report and just send it to you.
Thank you.
Okay, any more questions? Okay, seeing none. Thank you very much for your testimony. Thanks for hanging in here so late. Really appreciate you being here. Okay, I'm going to go ahead and close the public hearing on Senate Bill 573. Thank you all for being here. I'd like to thank my committee members. We've been here since 9 o'clock this morning, and many thanks to our staff that's here that helped us get through this today. So everyone have a great evening, and we'll see you next week.
Yeah, we get paid.